Good morning. I'm just checking that you can hear me okay.
Good morning. I can hear you just fine. Thanks.
Thanks so much.
You're welcome.
Good morning. This is an audio and visual test for those in the ether webs already on the hearing link.
Good morning. I can hear you and see you just fine.
Thank you so much.
You're
Cheers.
welcome.
Good morning. Is the corporate reporter ready and the webcast all good to go?
The court reporter is ready.
Yes, and the webcast is all ready too.
Awesome. Thank you. Good morning. We're now on the record. It's 9 a.m. on July 10th, 2025. This is an evidentiary hearing and proceeding number 25A-0036E, Public Services Tariff on-bill financing proceeding. I'm Commissioner Tom Plant, the hearing commissioner for this proceeding. And just before we get into the entries of appearances, I have a preliminary scheduling matter I just wanted to bring up. The commission has a commissioner's deliberation meeting today scheduled at 1 o'clock. So to accommodate that, I plan on taking a lunch break from 12:30 to 1:30, ish, somewhere around there. See how it all works out. And so hopefully we'll reach a good stopping place somewhere around 12:30. And I appreciate the party's assistance in accommodating that schedule. Okay, we can start with entries of appearance. Public service.
Morning.
Yeah.
Good morning, Commissioner Plant. That's a busy day, and we're representing a public service company of Colorado. Thank you.
You bet. Trial staff.
Good morning, Commissioner Plant, Senior Assistant Attorney General Katie McLaughlin, and my co-counsel Ross Smith on behalf of trial staff of the Colorado Public Utilities Commission.
Great, thanks. UCA.
Good morning, Kate Crampton with the Attorney General's Office on behalf of UCA.
Great, thank you. CEO.
Good morning, Cynthia Vitale, Assistant Attorney General representing the Colorado Energy Office. I'd also like to enter the appearance of my co-counsel, First Assistant Attorney General Jessica Lowry.
Okay, thank you. Sweep.
Good morning, Commissioner Plant. Michael Hyatt with Earth Justice, appearing on behalf of SWEEP.
Okay. City and County of Denver.
Morning, Commissioner Plant. Chuck Solomon, Assistant City Attorney, representing the City and County of Denver.
Morning. City of Boulder.
Good morning, Commissioner Gabriella Stockmeyer of the law firm of Dietz and Davis, representing City of Boulder.
Fantastic, thank you. EOC.
Good morning, Commissioner Plant. Casey Canelio of the law firm Canelio Consulting, here on behalf of Energy Outreach Colorado.
Great, thanks. CEC.
Good morning, Commissioner Plant. Michelle King of the law firm Holland and Hart. I'm here on behalf of the Colorado Energy Consumers and would also like to enter the appearance of my co-counsel, Fripp Prelo.
Okay, great, thank you. WRA.
Good morning, Commissioner Plant and parties. Park Espresso on behalf of Western Resource Advocates.
Clear.
Good morning, Sarah Berman of the law firm Kaplan Kirsch, representing clean energy economy for the region. And I'd also like to enter the appearances of my co-counsel, Sarah Judkins and Sarah Keene.
Fantastic, thank you. And finally, Commission Counsel.
Good morning, Commissioner. Assistant Attorney General Wyatt Foreman on behalf of the Commission.
Great, thank you. Did I miss anybody? Going once, going twice? Okay. We're going to conduct this hearing using electronic exhibits. There's a spreadsheet marked as Hearing Exhibit 1300 that lists the latest versions of the pre-filed testimony and attachments. With that, any objection to the admission of Hearing Exhibit 1300 and the spreadsheet listing all of the exhibits? All right, hearing none, Exhibit 1300 is admitted. Is there a stipulation among the parties admitting all the items listed on Hearing Exhibit 1300? If not, yeah?
From the company standpoint, there is not an all-party stipulation, but the company is certainly willing to that stipulation.
Okay. Any objections? All right, hearing none, the pre-filed exhibits listed in Hearing Exhibit 1300 as filed in the Commission's e-filing system are admitted into evidence. Have any parties decided to waive the scheduled cross?
City and County of Denver has decided to waive its cross of Mr. Murphy.
Okay, Denver. All right, great, thank you. Anyone else?
Yes, thank you. Given the company's agreement not to seek additional budget beyond what was approved in the underlying DSM beneficial electrification proceeding, CEC is waiving its intended cross for both public service witnesses and its reserved cross for Ms. Elam.
Okay, great. Anyone else?
I would, for public service, I would note that I understand that EOC's witness has a scheduling issue for tomorrow morning. And while we're not entirely waiving cross yet, I think we can give an update later today about whether or not EOC's witness needs to testify for the limited cross-examination time public service has scheduled.
Okay, great. Thank you.
Commissioner Plant, I'll just follow up on that. Thank you, Mr. Mitchell, for that update. EOC's witness, Mr. Luke Elderton, is unavailable tomorrow afternoon. So I was just going to request that he testify sometime tomorrow morning, which may or may not be out of turn.
Okay, great. Thank you.
Thanks.
Hopefully we'll be done before then. Anybody else?
Yes, UCA had reserved time for Boulder, Clear, WRA, and CEO. I expect those times to be cut significantly, and kind of depending on where the discussion goes, may end up waiving those crosses. I don't want to waive quite yet, but I reserve time in an abundance of caution. I expect any cross would take significantly less time.
Okay, fantastic. So are there any other changes to the cross?
Scheduling matter, one of Clear's witnesses is only available between 11 a.m. and 4 p.m. on Friday. So we'd just like to request to take Clear's witnesses out of order if necessary. And we've conferred via email and received no objections from other parties.
Okay, fantastic. And I don't have, Ms. King, I don't have any witness for CEC, but we don't obviously have any cross. So if there was a witness, they're excused.
Thank you. CEC has no witness in this proceeding. Thank you.
Okay. All right. Thank you. Any other changes? All right. For each witness, we'll start with the parties' scheduled cross and proceed to commissioner questions and then conclude with redirect. Commission counsel has let me know that the advisors and advisory council have no questions for the witnesses that are listed. Mr. Foreman will let me know if that changes throughout the course of the hearing. Are there any other preliminary matters that we need to address? Yes, Mr. Barroso.
Yes, thank you, Commissioner. For WA witness, Mr. Carley, we have a small modification to his answer testimony and have circulated a revised version of that testimony with counsel for the parties this morning, and I received no objection. For efficiency's sake, would like to go ahead and move for admission of that revised version of his answer testimony.
Okay. It's been moved. Is there any objection to that motion? Seeing no objection, it's admitted. Thank you.
I'm sorry, Commissioner Plant, is that hearing exhibit 400 Rev 1?
Yes, thank you.
Okay, thank you.
Okay. And Ms. Stockmeyer?
Thank you, Commissioner. And I have 3 exhibits that we could either introduce through when Ms. Elam is called as the witness for Boulder, or now I've addressed. One is similar to WRA. It's just one correction to her testimony. So to the extent that it's going to be referenced before her testimony, we can go ahead and do that now, or we can wait. I'll just flag the other 2 as her affidavit of testimony that was filed. Unfortunately, when it was filed, we realized the formatting got all wonky, so we just have a corrected version to submit into the record. And the last one that I have conferred with parties on, in Ms. Elam's testimony, she cited to a white paper and included the hyperlink, but we thought just to complete the record that we would attach that, we would include that into the record as a hearing exhibit. I have conferred with parties. There were no objections, just but that Ms. Elam would be available to answer any questions about that study.
Okay,
So-
great. Yeah, we can do that when she comes up. Is the study that you wanted to enter, is that the one about buying down rates?
Correct. Yep.
Yeah, I think I also put that in our boxes, hearing exhibit 1400. So,
Okay.
yep.
Great. We'll wait for
And
that.
we
Thank you.
can, yeah, we can deal with that when she comes up. Thank you. All right. Any other preliminary matters before we get going? All right. Well, we'll start with the company, Mr. Mansholt.
The company calls to stand Mr. Patrick Murphy.
Mr. Murphy, hello.
Good morning, Commissioner.
Do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
Is anyone communicating with you or assisting you in any way?
No.
If that changes, you'll let us know.
Yes, I will.
Okay.
Good morning, Mr. Murphy.
Morning.
Can you please state and spell your name for the record?
Yes, it's Patrick Murphy, PatrickMurphy.
And by whom are you employed and in what capacity?
I'm employed by XL Energy Services. I'm the manager of program policy and strategy for our customer-facing programs.
And did you sponsor, in this case, hearing exhibits 101, 102, and 103, Rev 1?
I did.
Those have been entered into the record, and so Mr. Murphy is available for cross-examination.
All right. First up, we have staff with 30 minutes, and it's 9:12.
Thank you, Commissioner Plant. And good morning, Mr. Murphy. My name is Katie McLaughlin, and I represent trial staff. I have a couple topics that I'd like to cover with you today. But first, I want to start talking to you about the Colorado Clean Energy Fund, or CCEF for short, because that's kind of a long name. As we all know, the company intends to use CCEF to provide the financing for this tariffed on-bill financing program. In your rebuttal testimony filed on June 20th, you state that the contract negotiations with CCEF are still ongoing. Has the company finalized a contract with CCEF since the filing of your rebuttal testimony?
We have not. We continue to negotiate with CCEF at this time.
Okay. And it's not uncommon for the company to use third parties to assist in the implementation of certain programs. Isn't that true?
That's correct.
Okay. But it's also true that this is the first time the company is using a third party to finance the capital of such a program, correct?
That I'm aware of, yes. Subject to check, but I believe that's the case, yes.
And this is the first time that this commission is hearing a proposal for an on-bill finance program, correct?
From the company, yes, that is correct.
Has this commission heard a proposal for an on-bill financing program for any other utility besides PSCo?
I'm not entirely sure, but I just know that this is the first time the company has brought it forward.
Okay. So under the company's proposal, if a customer fails to timely pay this on-bill financing debt, they risk the possibility of utility disconnection, correct?
That is what we have proposed. Yes, that is correct.
Does the company use disconnection as a penalty under any of its other programs?
Not that I'm aware of.
So this will be the first time that PSCo is introducing disconnection activities for a program that's managed by a third party.
Yes, but I think this presents a unique case here, right? The company is partnering with CCEF, who is using their capital to support the on-bill financing program. The tool, using the disconnection policy as a tool incentivizes customers to make their timely payments for the finance debt. It also helps support the below market rates that CCEF is able to provide in this program. And it's also, without the tool of disconnection, this will essentially be an unsecured debt that CCEF has no collateral to collect from customers.
Thank you for that. Now, I have a little more questions about, will the company include a provision in the contract with CCEF that details this disconnection process?
It will not, I mean, there will be a provision in there that disconnection can be used. The extent of the detail, I'm not entirely sure on. I don't know that we've finalized that portion of it.
Okay, so that part of the contract related to disconnection is still subject to modification as of today.
No, it's still, we're still discussing what level of detail will be in there. We were talking through, the debt workout process that CCEF is also willing to include to support customers to get their accounts back in good standing.
And this commission will not know what that disconnection provision will look like until after it approves some form of this on-bill financing program. Isn't that true?
I don't think that the disconnection process will look much different than what was presented in my attachment, and I apologize, I'm not remembering the exact number of the attachment, but we did provide a kind of a flow chart of the process of how we see the disconnection process working with CCEF, including the debt workout process that we've negotiated with CCEF to assist customers who fall behind on payments, rather than going through our disconnection process.
But similar to what is provided in your attachment is not exactly what is finalized, correct?
Well, I think in conversations with CCEF, I think we don't want to have too many specifics in the contract to allow some flexibility. Conversations with CCEF have informed us that, when customers fall behind, it's going to be really treated on a case-by-case basis. We and CCEF do not want to move customers into a disconnection process for falling behind on the finance debt portion of their bill. And so we've created some options where CCEF has the ability to contact and work with the customer first to help them get their account back in good standing rather than go through the disconnection process.
So the details could look different than what was included in your rebuttal testimony.
I don't anticipate the details looking different than what was presented in my rebuttal testimony. My rebuttal testimony represents a program that we think is reasonable and is implementable both from the company and CCEF's perspective.
Okay, but since there's no final contract, it tracks that all provisions of the contract are subject to modification as of today, correct?
Yeah, negotiations are ongoing, so yes.
Okay. And it's still your position that the company will not provide the commission with any version of this contract with CCEF?
That's correct. In my experience, I'm not aware of the company needing to file with the commission or share with any parties third-party vendor contracts. I think from the company's perspective, this is part of our ability to manage our own business without specific oversight from the commission or stakeholders. I'm not an attorney, but I expect that our legal briefing will probably discuss this issue in some greater detail.
And so, Mr. Murphy, even once the contract is finalized, will you provide it to the commission?
That is not our position. No, we will not be filing the contract.
Mr. Murphy, I'd like to switch topics with you. And Mr. Mansholt asked you a little bit about this in your intro, but just to confirm, you are employed by Excel Energy Services, correct?
That is correct.
And Xcel Energy Services provides an array of support to utilities under the Xcel Energy umbrella, correct?
Correct.
And you have policy and strategy oversight for other states than just Colorado. Isn't that true?
Currently, yes. My current position is working with customer programs throughout our public service and SPS service territories.
And in your rebuttal testimony, you state that this on-bill financing program is a new program and it does not exist for any Xcel operating company, correct?
Correct.
Has any other Xcel operating company proposed an on-bill financing program before?
Not that I'm aware of.
Has any other Xcel subsidiary evaluated an on-bill financing program before?
I am not sure. I mean, I know the company, I know public service has, obviously. I'm not sure about whether SBS or NSP has done a similar approach.
Has any other Xcel subsidiary conducted a cost-benefit analysis for an on-bill financing program before?
Not that I'm aware of.
I'd like to pull up what has been marked as hearing exhibit 701 in staff's box, please. And if we could stay on this first page, I'd like to direct your attention to the title of this document. Do you see where it says Tariffed On-Bill Financing Feasibility?
I do.
And do you see what state this feasibility study was conducted for?
Minnesota?
Isn't Xcel the largest utility currently operating in Minnesota?
They are, yes.
If we could please move to page 13. I want to direct your attention to that first bullet point at the top labeled utility jurisdiction. Do you see where this analysis was conducted for customers of Xcel Energy in Minnesota?
I do, but again, I do not do work for our Minnesota service territory, so I'm not aware of every study that is conducted for our Minnesota service territory.
Understood. Now, if you could take a look at the very last sentence in that bullet point and let me know when you've had a chance to review it.
I've read it.
Would you agree with me that assessing elements such as retail energy prices and utility avoided costs is a form of evaluation?
I would, yes.
If we could please move to page 73 of this document. At the top of this page, do you see where it states advisory working group participants?
Yes, I do.
If we could scroll to the bottom. Thank you. In this very bottom section, do you see that there are two contributors from Xcel Energy?
I do, Mr. White and Mr. Peterson.
Now, if we could please go to page 64. Could you please tell me which utility is listed in that third column?
Xcel?
And on the far left, there are sub-rows with a couple of labels such as Society Cost Test and Utility Cost Test. Would you agree with me that those are forms of a cost-benefit analysis?
Those are tests that are used in cost-benefit analysis, yes.
Staff would like to move for the admission of hearing exhibit 701.
Is there any objection?
Yes, Commissioner Plant, the company objects. There is no authenticity of this document. Mr. Murphy just explained he's never seen this, doesn't know what it is. The first page shown by staff doesn't say this was on behalf of the company. It says it was provided in Minnesota. Mr. Murphy has no awareness of this. It's not authenticated. We don't know what this is.
If I may respond, Commissioner Plant.
Yep.
This is a form of a business document, and the questions that I asked laid the foundation that Xcel Energy, in some capacity, was a participant in creating this study. Under Commission Rule 1501, this provides that the Commission is not entirely bound by the rules of evidence, and you can include reliable and probative value for the hearing commissioner's benefit.
All right. Mr. Foreman, any recommendations?
Uh, Commissioner Plant, you can, if you'd like for more foundation to be laid, you can ask for that. If you think this is relevant and you'd like to admit it, you can do that and give it the appropriate weight. You can overrule the objection and say you'll give it the appropriate weight in this proceeding.
All right, thank you. Yeah, the objection is overruled and we'll give it the appropriate weight and admission. Thank you.
Thank you. We can go ahead and take this exhibit down. Mr. Murphy, the company did not conduct a cost-benefit analysis in any capacity for this on-bill finance program in Colorado, right?
That's correct. Company has designed its program where CCEF will be providing the capital for the funding of this program. The company's costs are administrative in nature, and we've limited those to the extent possible so as to not impact non-participating customers. And so, it's not very clear why this program would not be cost effective from the company's perspective, nor how we would conduct such an analysis, given that all of the costs on the company are administrative costs to support the program.
Okay. But would you agree with me that the eligible upgrades under this program have the potential to provide customers with energy savings?
Yes, outside of a couple of foundational measures that we've included through rebuttal that further support the measures that we've put forward in this proposal, the company is putting forward beneficial electrification and energy efficiency measures that have been fully vetted and approved through our existing DSM and beneficial electrification plan.
Okay, and speaking of your DSM program, didn't the company originally propose that the energy savings that resulted from DSM measures in this on-bill finance program could count towards the DSM PIM? That was your original proposal, correct?
Not entirely. Actually, our proposal was initially indirect, was that for those projects that do not receive rebates, those savings could be accounted towards our PIM. However, after receiving feedback from parties in answer testimony, the company decided to not move forward with that proposal.
Okay, so these were measures that did not receive rebates.
Correct.
Okay, so doesn't the company's since withdrawn proposal specific to the rebates to count those energy savings towards a PIM suggest that there are quantifiable economic benefits associated with those measures?
Yes, I mean, similar to how we conduct savings for, or attribute savings for any of measures that are supported through our DSM and BE plan.
Okay. Now, Mr. Murphy, I like to turn to another topic with you today. Did CCEF intervene in this proceeding?
They did not.
So CCEF does not have a witness present here today?
That is correct.
And they did not provide any testimony, isn't that true?
That is correct.
And specifically, CCEF did not provide this commission with any evidence of the source of its funding, did they?
I think the company provided some evidence of the source of CCEF's funding in consultation with CCEF, but as stated, CCEF is not a party to this proceeding, so no, they have not.
Okay. And I understand that they provided some comments last week, but these comments were not submitted as pre-filed testimony, were they?
No, they were filed as public comments, and they were supportive of the company's rebuttal testimony. And I would encourage the commission to review them.
But there's nobody here that could be cross-examined about the comments that they made.
That's correct. Similar to other public comments that are provided in other proceedings.
Now, I want to touch on something that you mentioned earlier on how the company has provided its understanding of CCEF's funding. If we could please pull up what has been marked as the attachment 8 to hearing exhibit 700, the answer testimony of staff witness Gebregzaber. If we could please scroll down to the very bottom of this document on page 3. Who appears as the sponsor to this answer?
I'm the sponsor.
Thank you. And if we could please go back to page 1, and I'd like to take a look at the question under subportion A. Do you see where this discovery question asks for the source of CCEF's funding?
I do.
And if we could scroll to the bottom of this first page, please. And you see where the answer that you provided states and starts with, it is the company's understanding that CCEF.
Yes.
If we could scroll down a little bit more to the top of page 2, thank you. And you see that the answer that you provided to subpart B also starts with, it is the company's understanding that CCEF intends to commit 10 million.
That is correct.
So all evidence in this record of CCEF's financial commitment has been presented by public service. Isn't that true?
I'm not remembering the exact details of what was in the public comments provided, but yes, we have provided in rebuttal testimony and through discovery the source of funding for CCEF.
Would you like to look at the comments to confirm whether or not they've provided evidence of their funding?
Sure, we can do that.
Okay.
I'm not entirely clear, so
We could please pull up what has been marked as hearing exhibit 704 that's in staff's box. Oh, I apologize. I got the wrong.
Is it 703?
It is 703. I apologize. So, Mr. Murphy, if you look at that second paragraph there, where it describes some of the funding that CCEF has, can you please tell us if there is anything that describes the funding in relation to public service specifically?
does not.
Okay, we can go ahead and take this exhibit down. Now, I want to focus a little bit more on the amount of funding that CCEF has. CCEF has committed to provide $10 million to launch the financing program. Is that your understanding?
That is correct, yes.
Okay. And the company has proposed that they have an initial capital amount of 25 million, right?
Up to 25 million. That's
Up
correct.
to 25 million. But CCEF has yet to confirm their ability to provide $25 million of capital. Isn't that true?
In every conversation that we've had with CCEF, they see every opportunity to, similar to what they did with the grant funding that they received from the energy office, is, reinvest some of that capital, grow their balance sheet, and are comfortable providing up to $25 million to support the initial launch of this program.
Did you provide any evidence in your rebuttal testimony or attachments to confirm that CCEF is able to fund this up to $25 million?
I think, if I'm remembering correctly, I believe we just talked about how they have grown their balance sheet with the current funding or the grant funding that they had in place. They also still have, they're conducting outreach to also raise additional capital, and may have the opportunity to use the greenhouse gas reduction fund.
So I'm not questioning that their ability to try and raise funds on the side. I'm wondering if there's any evidence that right now they have the ability to launch this program with $25 million.
Objection, asked and answered.
I don't believe that he has answered that specifically.
Yes, he just laid out the evidence as rebuttal testimony towards that end.
It's overruled. Could you answer, Mr. Murphy?
Can you repeat the question, Ms. McLaughlin?
Yes, I understand that CCEF has provided the company with evidence that it plans to continue growing this program, but has public service provided any evidence here that CCEF has the ability to launch the program with $25 million?
They are launching the program with $10 million as discussed, and they have the ability to grow that to support up to $25 million for the initial program offering. And that is discussed in my rebuttal testimony.
Okay, let's go ahead and bring up your rebuttal testimony. It's going to be hearing exhibit 103, and I'd like to look at page 27. And I want to focus your attention on lines 8 through 10. If we could zoom in a little bit, that looks just a little small. Thank you so much. If you could start on line 8 and let me know when you get to line 13.
Good.
Where does this state that CCEF has the ability to launch the program with $25 million?
I don't think we've said anywhere that they have the ability to launch the program with $25 million. They're launching the program with $10 million and will continue to grow their balance sheet to support up to $25 million for the initial term.
It's the company's understanding that they could grow and launch it with up to $25 million.
No, it's the
Correct?
company's understanding that they're going to launch it with $10 million and then grow that to support up to $25 million.
We don't have any evidence in this record that CCEF has committed to $25 million, do we?
Objection asked and answered about the third time now.
Okay, I will move on. We can go ahead and take this down. Now, I want to touch on something that you mentioned earlier, Mr. Murphy. Isn't it true that CCEF is a recipient of the federal funds from the Environmental Protection Agency's Greenhouse Gas Reduction Fund?
That is true.
And you just mentioned that if CCEF were to scale this on-bill finance program beyond the $10 million committed, they plan to use a portion of this funds, the federal funds.
That is their plan. Yes, they would, they may be able to access those funds to support this program.
Are you aware that those federal funds have been frozen?
I don't know the current status of them, honestly.
So you're not aware that there's active litigation at the federal level about these federal funds?
I'm not close to it, but yes, I'm aware that there is active legislation. I don't know what, the portion that has been provided to CCEF, where that currently stands.
And do you know when there might be some sort of resolution for the federal funding that has been committed to CCEF?
I do not know.
Mr. Murphy, we discussed that CCEF is not a party to this proceeding, but did the company discuss any intervener proposals with CCEF?
We did, and we heard from some parties of an interest to have CCEF become a party to this proceeding. It was their decision to not become a party to this proceeding. I don't think that, in conversations with them, I don't think they were in the position of committing significant legal expenses to, litigate and further support this program.
Okay, but I want to focus on a particular proposal from staff. We're going to discuss the per premises maximum. In your rebuttal testimony, the company proposed reducing the per premises maximum to $50,000, right?
Correct. In direct, we suggested a $75,000 cap and moved to $50,000 based upon party input in their answer testimony.
And you recall that staff recommended a lower per premises cap, correct?
Yes, that is correct. I don't remember the exact level, but it was lower.
Did the company discuss per premises caps with CCEF?
We did, yes.
Has CCEF provided any evidence that it would be unable to proceed with the financing program if the per premises cap was less than $50,000?
Objection, asked and answered. Ms. McLaughlin already asked the company if CCF put any evidence in this record. Mr. Murphy already explained they're not a party. They put no evidence in the record. It's asked and answered.
If I may respond?
Yeah, please.
The questions that I was asking earlier was specific about the funding level that CCEF. Now I'm asking about specific party proposals.
Again, they're not a part of this record. They put no evidence in the record, period. Mr. Murphy's already explained that.
If you can rephrase the question, Ms. McLaughlin.
Mr. Murphy, do you know if CCEF would provide funding for this program if the per premises cap was less than $50,000?
I do not know. We haven't had that specific question or conversation with them.
And if the per premises cap was reduced to, let's say, $25,000, wouldn't you agree that this would potentially increase the number of customers that could be eligible for the program?
Potentially, but sitting here today, we do not know what participation in this program looks like. And we think that the 50,000 level is more appropriate to support some of the more expensive measures that we have proposed to be available through this program, and also supportive of multiple measures that customers may look to install at their homes.
If more customers were eligible for the program, wouldn't you agree that there would be more data that the company could receive about what customers are deciding to do?
I think, again, it would depend highly on participation levels.
Okay. Would you agree that having more data would be beneficial about potential future modifications to the on-bill finance program?
I think more data is helpful, yes, and informative.
And I know that I'm almost at my time, but Mr. Murphy, I have just a couple more brief questions that I anticipate will take 2 to 3 minutes. In your rebuttal testimony, the company is no longer seeking incremental funding for the finance program and instead proposes to recover costs of the program through the current approved DSM-BE budget. Is that a fair summary?
That is correct.
And you're referring to the company's 2024 to 2026 DSM-BE plan budget.
That is correct.
And if we could please pull up what has been marked as hearing exhibit 704 in staff's box. And I'd like to turn to page 19. And let's look at paragraph 13. Could you read this to yourself, Mr. Murphy? And when you're finished, let me know where in this paragraph of the settlement agreement this commits DSM-BE budget to a tariffed on-bill financing program.
This specific term does not commit any budget. However, it's not clear to the company. It seems appropriate to the company to recover these costs through the DSM and BE plan, since this is a term that we agreed to make this filing through our settlement in the DSM and BE plan. And without, certainty of cost recovery, it's not clear to the company how costs could be recovered or what budgets they would come from.
Okay, but it's not included in this provision of the settlement agreement.
No, it is not. This talks about the function of the requirement to make this filing 60 days after a final commission decision.
And if we could go ahead and take this exhibit down, when is the company planning on filing another DSM application?
Summer of next year.
And when does the company anticipate that it will reach an executed contract with CCEF?
We do not have a firm date right now, but we are, again, actively engaged in negotiations and making good progress with CCEF. I think the majority of the terms of the contract have been agreed to, and we're just finalizing some final items.
Is there anything that you know of that prevents the company from including the on-bill finance costs in the next DSM budget?
Company anticipates having this program up in market prior to making the filing in our next DSM plan. So it's unclear to the company for the costs that we incur setting up the program, administering the program, and the payments to CCEF, how those costs would be recovered in the interim.
But there's nothing preventing you from including the costs in the next plan.
Nothing preventing us, but we just don't know what we would do with the costs incurred in the meantime.
Okay, Mr. Murphy, I think that those are all of my questions for you. I really appreciate your time this morning. Thank you.
Thank you.
Thank you, Ms. McLaughlin. I have next Boulder for 60 minutes.
Thank you, Chair. Good morning, Mr. Murphy. I'm Gabriella Stockmeyer on behalf of the City of Boulder. Nice to see you today. This morning, I'd like to talk with you about several areas of your testimony and the Tariff on-bill financing program, which I will refer to shorthand as TOBF at times, okay? So for the company, my understanding is that one of the primary considerations of the TOBF proposal is to minimize impacts to non-participants. Is that correct?
That's correct.
And by that, I understand that the company means not overly burdening non-participants to the program with program costs, right?
Correct, yes.
And you have raised this consideration as an argument against several program designs that have been raised. For example, eliminating a requirement that TOBF debt be subordinated, right?
That's correct, yes.
And you also suggest in your rebuttal testimony that lowering interest rates too much could amount to subsidization from non-participants, right?
Yes, that's correct. The company has not proposed any sort of interest rate buy down, and I know that we've had some suggestions from parties, including Boulder, but some of those suggestions were not very clear where the actual funding source will come from to support such a buy down.
I appreciate that, and I will we will discuss in a bit the issues of subordination and interest rates more specifically, but first, just more broadly, I'd like to talk about impacts to non-participants of a TOBF product. Mr. Murphy, would you agree with me that the purpose of the TOBF is to help provide greater access to energy efficiency and beneficial electrification offerings of the company?
Yes.
And you testify that a customer that makes use of TOBF will reduce its energy or demand or increase BE as a result of the efficient upgrades. Does that sound familiar?
That does. Can you show me that portion of testimony?
I can. We can pull up hearing exhibit 101. That's your direct testimony.
It sounds familiar. I just want to confirm.
Okay. Sure. And if we go to the bottom of page 39 and on to page 35, excuse me, 34 to 35. There we go. Thank you. So here at line 19, you say a customer that makes use of the financing will receive the benefit and will reduce its energy or demand or increase beneficial electrification as a result of the efficient upgrades. Do I have that right?
That's correct. Thank you.
Okay, no problem. And when you're the efficient upgrades will also produce system benefits. Do you agree?
I do.
Okay. And by system benefits, am I correct that those include reduced greenhouse gas emissions, reduced potential need for new resources, reduced system costs?
Potentially, yes.
Okay. And would you agree with me? I think, you know, we can leave this up for a minute because I'm going to refer to it in a minute. So I know, Ms. Kunkel, you do a lot of driving, so appreciate you. would you agree with that non-participants of the TOBF are anticipated to experience these system benefits that are achieved when other customers participate in the TOBF?
I think that's fair. Yes.
Okay. And in your direct testimony here, you liken TOBF to rebates that are provided within the context of a DSM or BE plan, at least with respect to the end result of assisting a customer in undertaking efficiency upgrades, and in turn, adding system benefits. Do I have that right?
Just reading the testimony.
Sure.
Yes, I would agree that we talk about the efficient upgrades providing system benefits.
And that in this way, the use of the TOBF is somewhat like a rebate, correct?
Somewhat.
Right.
But I would just say, and yes, there are the benefits to the system. What we've tried to do is design a program that does not provide does not put additional costs onto non-participating customers, at
Sure.
least to the extent possible.
Absolutely. I appreciate that. So many of the rebates offered in the DSM, and we can go ahead and take this down. Thank you, Ms. Kunkel. Many of the rebates that are offered in the DSM BE plan are currently being increased by the Clean Heat Plan, which were also approved by the Commission. Is that your understanding?
Many of our gas energy efficiency and beneficial electrification rebates have been enhanced through clean heat funding, yes.
Thank you. And all ratepayers, including non-participants, pay into the DSMCA, right?
That is correct, with some limited exceptions.
Okay. Would you agree that the company also funds through the DSMCA indirect activities like marketing and education, as well as third-party implementers to help drive participation in the DSM and BE programs?
Yes, and we've proposed to do that with CCEF in this filing.
Right. And so in this way, is TOBF also akin to marketing or other such indirect activities?
Yes, we plan on marketing the on-bill financing program.
And would you agree, though, that TOBF is different from use of a rebate in that the rebate reduces the overall cost of a DSM or BE measure, whereas TOBF reduces the upfront costs and allows a customer to pay over time?
Yes, I would agree with that.
Okay. I would like to for us to consider an example, and bear with me, there may be some simple math. I will represent to you, and Ms. Elam has as an attachment to her testimony a list of 2025 rebates. I will represent to you that the current rebate with the Clean Heat Plan augmentation, I think is the word you use, enhancement, for a cold climate heat pump is $2,250 per heating ton. Does that sound familiar?
Subject to check, but yes, that sounds familiar.
Okay, great. So if a home, say a medium-sized home, gets a 3-ton cold climate heat pump, by my math, they would get a rebate of about $6,750. Does that sound right?
The rebate is $2,000, did you say? I'm sorry. And
sure, it's $2,250 per ton.
Okay, sorry. Okay, yeah, sorry, I missed
Yeah.
the 250. Yes, that seems accurate.
Okay, great. So they get a rebate of a little bit less than $7,000. And then let's assume that with insulation for this home, the cold air clean heat pump is in the range of $21,000 installed. Okay, so here's the math. If you take the rebate from the $21,000 total, subject to check, that's an amount of $14,250 that the customer needs to pay. Does that track?
That sounds accurate, yes.
And if the customer gets the rebate, they have to wait between 6 and 8 weeks after the project is complete and the application is submitted to get that rebate. Is that your understanding?
My understanding is that our terms and conditions, commit to getting the rebate in that time frame. If I recall correctly, last year, outside of some of the heat pumps that were impacted by a settlement term, that we had to update some of the terms, that we averaged about 2 weeks in processing our residential rebates in 2024 outside of those heat pump, which I
Okay,
think
all right.
now have been incorporated better.
Okay, I appreciate that clarification. But in any event, do you know whether an average customer may be more inclined to finance a loan in the amount of roughly $14,000 using a traditional 10-year home equity loan at 8%, or finance the full $21,000 at a lower interest rate through a TOBF?
I do not know every customer's decision making, so I can't state with certainty anything there.
Has Public Service surveyed customers about which they would prefer?
We have not. No. I mean, as we showed earlier with Ms. McLaughlin, we had 60 days to pull this filing together. I know we've done work in prior years, but we have not done specific surveying around that topic.
Sure. Is it possible that TOBF costs less to participants to promote the investments in DSM and BE measures than upfront rebates that have already been approved by the Commission as just and reasonable?
I'm sorry, can you restate that question? Sorry.
Sure. Is it possible that the use of low interest or no interest financing through a TOBF could cost less to participants than a high upfront rebate?
Well, we have not proposed, any sort of interest rates beyond what CCF has committed to, but I think generally, yes, lower interest rates, customers have an interest in.
Okay. Let's go back to our example. If a customer goes ahead and wants to finance their roughly $14,000 loan for their cold climate heat pump in our example, for a 10-year loan at 8%, I have looked online, subject to check, would you agree with me that there is interest of roughly $6,500 and a monthly payment of $173 a month?
Subject to check, yeah, that sounds to generally align, but I have not seen this math, nor have I done any sort of analysis similar to it.
I understand that and appreciate your participation in my my experiment here. So financing the full $21,000 for 10 years at 0% results in no interest payments, but ends up at roughly the same payment of $175 a month. Subject to check. Does that sound reasonable?
Again, subject to check. I have not done this analysis, but it does sound reasonable. And again, the company has not proposed a 0% interest rate for this on-bill financing program.
Right. So in that scenario, if the rebate that the customer received, well, let me back up. So just again, going to customer preference, the company isn't aware whether a customer who would effectively pay the same payment over a home equity loan versus using TOBF, the company isn't aware through surveying which one a customer would choose, right?
We have not conducted that type of survey. Yeah.
Right. But would you agree that if the rebate were less than this enhanced roughly $7,000 rebate that's available now under the Clean Heat Plan, the customer could save more by using the TOBF with a 0% interest rate than using the rebate?
I guess I don't understand. The rebates are at the levels that they're at, so the customers are not going to be in that position.
Well, you proposed a 3-year program, correct?
Yeah, the initial term of the program is 3 years.
And my understanding is that at this point, clean heat enhanced rebates are not guaranteed through 2028 at this point, are they?
Believe they're guaranteed through 2027, and we will also be filing our next clean heat plan next summer.
Okay, so you can disagree with my premise, but I guess what I'm getting at is that, and we've already kind of asked and answered. You don't know what a customer preference is going to be, but it is possible that a customer could pay less using TOBF through a very low or no interest rate than if they had than if they received high upfront rebates. Would you agree with that?
I have to object that there is just a level of speculation here that is really giving Mr. Murphy an unanswerable question. There are too many assumptions driven into situations that don't currently exist for there to be any reasonable response.
Ms. Stockmeyer, could you just rephrase your hypothetical in a way that Mr. Murphy can just directly answer? Thanks.
Okay. Well, let me move from the customer experience, which the company isn't necessarily aware of at this point, to the non-participant impact. So where if an interest rate of 0%, if that was available to our customer who wanted to have a loan of $21,000, if a 0% interest rate was available to them, we just talked through an example where if they received a high rebate, they would basically be paying the same amount if they financed a home equity loan but got a high rebate, and if they got a 0% TOBF. Do you recall that example?
Yes, I do.
Okay, so if the company could make a 0% interest loan available for less than the cost of that enhanced rebate, which in our example was roughly $7,000, wouldn't you agree with me that ratepayers would pay less for the same result?
Potentially, I think that would be dependent on participation in either program.
Sure. So generally, it's possible that TOBF could cost less to non-participants to promote investment in DSM and BE measures than large upfront rebates that this commission has already approved as just and reasonable and in the public interest. Isn't that correct?
I'm sorry, can you restate that question? Apologies.
Sure. Let's go ahead and so I'm getting back to the cost to non-participants to end up at the same result of promoting DSM and BE. So for what the company has proposed, you proposed a 3-year program. And my understanding is that the administrative costs total about 1.25 million. Does that sound right?
That's correct.
So, and you proposed to limit loans to $50,000 per customer, which Boulder thinks is reasonable, and set a max financing budget for the 3 years of 25 million. Do I have that right?
Correct.
So, assuming every participant uses the max loan, which would you agree that's probably unlikely?
I think that's highly unlikely, yes.
Okay, but let's just assume that. Then there would be a participation of 500 people in this program. Does that sound correct? 25 million at $50,000 each?
Yeah.
Okay.
Sorry, I was thinking of the former proposal that we made of 75,000, but yes, that sounds correct.
Okay, so then the administrative costs of 1.25 million, if you divide that over these 500 participants, that is a maximum participant administrative cost of $2,500. Do you agree?
That sounds accurate.
And this is notably smaller than the rebate we were just discussing. The single rebate for a cold air climate heat pump at $6,750, correct?
It is, but these rebates that we have in market have been, as you stated earlier, have been approved by the commission.
Absolutely, I agree. But would you agree with me that a $50,000 project likely would involve more than a single measure?
I think that's likely, yes.
And let's just take another, just a quick sidetrack. I understand from staff's questioning of you, they have concerns that a $25 million budget might not be feasible. Let's say that the budget was 10 million for some reason. Would you agree then that we would only have 200 participants at 50,000? And so by my math, that would be $6,250 a person administrative costs. Does that sound right?
That sounds directionally accurate.
Okay.
Yes.
So that's again, that's equivalent to one enhanced rebate that customer might be able to obtain, right?
Yes, given the math that you presented earlier, that's correct.
Okay. Mr. Murphy, are you aware of how much the company has been approved to make available for enhanced rebates just in 2025 through the Clean Heat Plan?
I do not have that number right now in my head.
Sure.
I know the overall approval was a little over 400 million, but I don't know specific to 2025.
Okay, and if we could pull up Ms. Kunkel, hearing exhibit 800, attachment CCE 16. And this has been admitted into the record. It's the 2025 Interim Clean Heat Plan Report. Could you please turn to page 6? Excuse me, there's a table 2. And so the vertical 1 additional gas DSM and BE under the budget for 2025 added together, those are roughly $70 million, correct?
Vertical 1, yeah, 76, I believe is what I see there.
Okay, and are those those are the budget that are available to enhance DSM BE rebates through this Clean Heat Plan?
Outside the recovered methane portion, yes.
Okay, so in the ballpark of $70 million, right?
Yeah, correct,
okay.
Yes.
Thank you, Ms. Kunkel. You can take this down. Did the company conduct any analysis, Mr. Murphy, to determine how TOBF could be used in conjunction with lower rebate amounts to achieve comparable participation in DSM and BE, but at lower cost to ratepayers?
We have not conducted that analysis, nor have we proposed to adjust any sort of rebate levels for Clean Heat or DSM at this time. It's very early in the implementation of the Clean Heat Plan. I think we'd need to fully understand customer uptake and participation in our programs before we begin to contemplate any sort of changes to those rebate levels.
Sure. And you've established that these rebate levels have been approved as in the public interest by this commission.
The augmenting of the rebates have been approved by the commission. We worked with stakeholders over the fall and winter of last year to determine appropriate levels. We did not get any pushback from any stakeholder. And we filed with the commission an informational filing on, I believe, January 2nd to show the levels that that us and stakeholders agreed to.
Sure. And just for all of these tools, for rebates, for marketing, for TOBF, we've established at the beginning of our conversation, the company is undertaking these because there are system benefits that benefit all customers, correct?
Yes, I believe that's accurate.
Okay, let's go ahead and talk next about the issue of subordination. So Public Service's position is that any debt financed through the TOBF must be subordinated to Public Service's utility bills. That is the company's position, correct?
That's correct.
Okay, if we could turn to the proposed tariff language, that is your attachment PJM1 under Hearing Exhibit 103. And under, if you could scroll down just a little bit more, this provision shows up under the monthly billing section here, right? Beginning with the language, all payments received by the company will first apply towards those charges. That's the subordination language, correct?
That's correct.
Okay. You can go ahead and take this down, Ms. Kunkel. As an initial matter, Mr. Murphy, my understanding from your statement of qualifications is that you previously served as the manager of clean transportation policy and strategy for Xcel Energy. Is that correct?
That's correct.
And in that position, you were the regulatory lead in the company's TEP's transportation electrification plans?
Correct.
So you then are familiar with the EV Accelerate at Home service offered by the company?
I am, yes.
And under this product, my understanding is that that a customer pays monthly payments along with its utility bill for 10 years for a level 2 EV charger, after which time it takes ownership of the charger. Is that accurate?
The customer takes ownership of
the
charger.
The customer. Yeah. Thank you. And this allows a customer to pay for efficiency upgrades over time. Would you agree?
It pays for electric charger, electric vehicle charger. I don't know about efficiency payments over time.
Would you agree that EV is a type of beneficial electrification?
Yeah, I would agree that it is a form of beneficial electrification.
So, per your testimony, an efficiency upgrade includes DSM and BE, right?
Yes, that is correct, but I mean, I don't know that an electric vehicle charger adding service, adding additional electric load to the customer's home is actually energy efficiency.
Okay. Sure. Sure. Would you agree that this product is akin to a TOBF in that allows a customer an upgrade that they pay for over time on their utility bill?
Yes, I think it's similar, a very similar structure.
Okay. And does that product include a subordination requirement?
Not that I'm aware of. But I would point out that this is significantly different. This is a approximately $13 monthly charge to customers, where in this on-bill financing program, we're talking, as we've discussed, we're talking about the ability of a customer to take out a finance debt up to $50,000.
Okay. I appreciate that clarification. And just to complete the record, Mr. Murphy, I'm going to have Ms. Kunkel please pull up what is in Boulder's boxes Hearing Exhibit 808. And Mr. Murphy, this is the EVC tariff. It's sheets number 119 to 119C. Would you agree this is where the product we just talked about for EV chargers shows up?
Yes, it's a residential home charging service line item.
Okay. And I would go ahead and move for admission into the record of this under administrative notice. It is a tariff of the company within the commission's files.
Any objection? So admitted.
Okay, thank you. We can go ahead and take these down. So, Mr. Murphy, you're aware that Boulder's position is that the utility bill should not subordinate the financing here. But are you aware that its position is that neither should be subordinated, but that they should be treated equally on the bill?
Yes.
Okay. So if a customer makes a partial payment the payment will be prorated between both the utility bill and the financing bill. Is that your understanding?
That's my understanding of the proposal put forward by Boulder. But the company has concerns with that position as it could potentially lead to customers going into our disconnection process rather than having the ability to work with CCEF on addressing any financial hardships they may be experiencing and helping to get their account back in good standing rather than go through disconnection.
Sure. And I can appreciate that. In terms of why Boulder is proposing this, do you understand that they believe eliminating this subordination requirement could have the benefit of reducing interest rates that CCEF can offer?
I think that's Boulder's position. I don't know that that's accurate, and I don't know that we've heard anything from CCEF to indicate the impacts that it would have to interest rates.
Okay, and so that was my next question is, do you agree that removing subordination lowers CCEF's, well, back up, put aside the interest rates, do you agree that removing subordination lowers CCEF's risks?
Potentially, I suppose, but again, regarding interest rates, we don't know what the impact would be.
Sure. And the company hasn't asked CCEF what removing the subordination requirement would do, whether it would allow them to offer lower interest rates. Has the company?
I don't know if we've had that specific conversation. CCEF has been fully supportive of the subordinated position and, obviously responded to our RFP and to set up the program in that way. Sorry.
Yeah, no, I appreciate that. And in your direct, we could, if you want to pull that up, but I can just quote you. You say the program's design places the debt in a subordinate position, and the company sought to ensure a third-party capital provider could accept and manage this design. Do you recall that testimony?
It sounds familiar. Yes.
So subordination was a requirement of submitting an RFP.
Yes, and CCEF responded to our RFP, and they have been fully supportive of such a program design.
Okay. Removing the subordination, so I'll come back to the risk versus interest rates in a moment, but I want to go ahead and address the company's primary concern that I understand. Is one of the primary concerns is that removing the subordination requirement could increase the risk of the company in incurring higher levels of bad debt. Is that accurate?
That is accurate. And then having the result of increasing costs for all customers.
Okay. Mr. Murphy, has the company performed any studies to estimate what level of bad debt it might experience if TOBF financing debt is not subordinated?
We have not, because it has been our proposal to have the finance debt be subordinated to the company or the utility charge.
Ms. Kunkel, if we could please pull up Hearing Exhibit 800 Attachment CCE 8, please. Mr. Murphy, this was a study that Ms. Elam attached to her testimony that's now been admitted into the record. And at page 24, or excuse me, page 4 of this study, if we could go there and scroll down, please, to cost recovery. There we go. This study analyzed some ongoing utility TOBF programs and reported the results. So here it states one utility reported cost recovery for their TOBF at 99.8%, the others 99.9%. Do you see that?
I do.
And what that means is it goes on to state that that's charge-offs of this scale of 0.1 and 0.2%. Charge-off is the same as bad debt, correct?
I have not heard that term. So
Okay. In this context, well, the prior sentence says that TOB program collection rates exceed those for electricity sales. Do you see that?
I do see that, yes.
So my understanding is that this is talking about defaults, charge-offs, bad debt. I kind of put those in the same category.
I think that's fair.
Okay. So you don't have any information to rebut that these utilities experience these rates, do you?
Objection. This is mischaracterizing the exhibit at hand. The exhibit says one utility. It's not clear, it's vague what other utilities Ms. Stockmeyer is referring to.
So it says one utility reported cost recovery at 99.8, the others 99.9, and the first sentence says of the utilities who have implemented TOB programs and who have reported on cost recovery.
Overruled. You can answer the question.
Can you repeat the question, Ms. Stockmeyer?
The company doesn't have any information to rebut that these TOBF programs experienced charge-offs, bad debt in a rate of 0.1 to 0.2%. Do you?
We do not have any evidence to rebut that, nor do we know which utilities this is even contemplating.
Okay. Well, and this was a attachment to Ms. Elam's answer testimony that was submitted in this proceeding. You're aware of that?
Yes, I'm aware of that.
Okay. We could go to page 10, please. And here are the 4 states that are being reported on. And if we scroll down at the bottom, charge-offs, do you see that? It's 0 for all 4 states?
I do see that, yes.
Okay. And at page 12, the report also reports that, let's see, says that first bullet point, each utility with experience has affirmed no disconnections from non-payment of tariff charges. Do you see that?
I do, but the question is talking about pays systems, which the company has not proposed a pay-as-you-save model for this offering.
Okay. But these are states that have implemented a on-bill finance program that a customer pays back on their utility bill, and none of these have experienced high rates of default or any need for disconnection. Would you agree with me?
Lacks foundation. Ms. Stockmeyer hasn't laid a foundation that all of these utilities discussed have an on-bill financing program, not a pay system.
It's overruled if you could answer the question.
Can you repeat the question, Ms. Stockmeyer?
The company doesn't know what the default rates might be or how much bad debt might be incurred, regardless of how this program is structured. Would you agree with me?
We do not know what bad debt could potentially be incurred, but the company is not comfortable with going forward with the risk of any bad debt being incurred on its balance sheet to support this on-bill financing program.
Okay. If we could go ahead and take that down. Thank you, Ms. Kunkel. And I understand that that's the company's position. It doesn't want any bad debt as a result of this program that it's not putting forward any real capital for. But are you aware that Mr. Berman, your colleague, in his rebuttal testimony suggests a mechanism to potentially mitigate the impacts of bad debt if the commission were to remove the subordination requirement?
I am familiar with what Mr. Berman has said in his testimony, but I think that question is more appropriate for Mr. Berman.
Well, let's go ahead and just identify for the record what he proposes. So in his rebuttal testimony here, Exhibit 104, at page 10, and down at the bottom of the page, starting at line 19, or excuse me, that this goes on to talk about if the company were to require subordination, he says, starting at line 21, the company could seek to mitigate the impacts by proposing a mechanism to allow the company to track, record as a regulatory asset, and defer for future recovery in a rate case the company's incremental bad debt expenses. Do I have that right?
That is what the testimony says, but I am not, I'm not a specialist that knows about bad debt trackers or rate cases, so I think these questions are more appropriate for Mr. Berman.
And I'll be honest, I am not a finance person as well, so my question is pretty a lay question. Given the speculative nature of how much default and bad debt may occur, this solution that Mr. Berman has offered could allow the TOBF program to move ahead without subordination, but address charge-offs and bad debts later in a future rate case, correct?
It would appear that that's how Mr. Berman has presented it, but again, these are questions that are better suited for Mr. Berman.
Okay, thank you. I appreciate that, Mr. Murphy. We can take this down as well. I'm going to move on from subordination to other ways that could potentially be used to lower interest rates of the TOBF product. Public Service's position is that the interest rates being offered in this case, between the range of 5 to 5.99%, are sufficient and that there's no need to lower these rates, correct?
That is our proposal. We've brought forward below market interest rates to support this financing program as proposed by CCEF.
Okay. Would you agree with me that a primary way to reduce interest rates would be to reduce the risk to CCEF in administering this program as a lender?
I think that yes, I would agree that reducing the risk it could potentially have impacts on the interest rate. I do not know what those impacts would be, though.
Okay, I appreciate that. And CCEF is a nonprofit organization, correct?
That's correct.
So it is restricted from earning a profit through financing. Is that your understanding?
I'm not familiar with all the specifics of how their business operates, but that's my general understanding. Yes.
Okay. So their cost of administering the program, would you agree that they're generally their administrative costs as well as any cost that they would incur to address this bad debt issue we've been talking about?
Yes, yeah, I would agree. And I suppose there's other costs that are that CCEF also incurs.
Okay. Would you agree that a primary way to reduce interest rates for CCEF may be to reduce the risk to CCEF of carrying that bad debt or experiencing those defaults?
It may. Again, we don't know what CCEF, we haven't had that conversation with CCEF, and we don't know what, the actual impact would be.
Okay. Mr. Murphy, are you familiar with the term loan loss reserve?
Generally, yes.
Okay. And my understanding is that this is a separate fund that could cover bad debt using an outside source. Is that your understanding?
Yes, that's my understanding.
And a loan loss, the money in a loan loss reserve is only actually paid to the financier if bad debt is incurred, correct?
That's my general understanding, yes.
Okay. So conceptually, there could be a reduction in risk to CSEF if there was a loan loss reserve that could cover costs of its bad debt. Do you agree?
I agree, yes. And I believe we've been working, I believe CSEF has been working to establish a loan loss reserve.
Do you have more information about that to the record? Because that's not in the record in this case.
I do not. It's just in conversations, I understand that they are working to establish that. And I think, through discovery, we've answered that as well.
If that were to be established, could they offer lower interest rates?
No, that they wouldn't. In conversations we've had, that with the interest rates would maintain at the levels that they're currently proposing.
Okay. If the company were to help create a loan loss reserve, for example, through funds directed by this commission, do you have an understanding of whether that could lower CSEF interest rates?
I do not, and we have, and the company has not proposed to put forward any funding to support a loan loss reserve or to, buy down interest rates as proposed by certain parties in this proceeding.
Sure. Let's just talk about what a loan loss reserve might look like, though. So again, going back to the program that the company has proposed, that is for loans in the amount of $25 million over 3 years, right?
Up to $25 million for 3 years, yes.
So let's assume a default rate of 10%. Would you agree that that would mean a loan loss reserve of $2.5 million?
Yes.
And as we've talked about, at least some other states' utilities have had much lower default rates in programs they've offered. Lower than 1%, let alone 10%, correct?
In those examples you've shown, that has been the experience of those utilities. Again, it would appear as if at least some of those utilities you showed are putting forward a different model than what the company has proposed here.
Sure. So let's assume a $2.5 million loan loss reserve. Back to our good old cold climate heat pump. If the company were to bonus 500 of those at an average cost of $6,750, that would significantly exceed a loan loss fund of $2.5 million. It would be about $3.5 million, subject to check, right?
Subject to check, yes. There's been a lot of math this morning.
Okay. If providing a loan loss to eliminate CSEF's risk and result in lower interest rate could achieve the same or comparable cost savings than just large rebates, and would reduce the cost to all ratepayers, is that something that the company would support?
The company is supportive of the rebates that we have in market. The Clean Heat is a new offering, right? We have provided significant rebates to really encourage our customers to move towards fuel switching and electrification as directed by state policy and the commission. So we're supportive of the rebates that we have in market.
Okay. Just very briefly, Mr. Murphy, I have a question with regard to the company's position. Are you familiar? Ms. Elam proposed in her testimony a protection for renters, a guardrail that goes along with this program. Her position was that for certain measures, a landlord should be obligated to pay part of the cost. Are you familiar with that testimony?
Yeah, yes, I am familiar with that recommendation. And just to be clear, in our rebuttal case, the company made clear that we are requesting participation from renters to be approved through this proceeding. However, we do have some work still to do with CCEF to determine appropriate guardrails for such customers. So in the initial launch, we will not be including renters so that we can develop some guardrails that help protect those renters.
I'm sorry, you're saying you will not include renters in the initial launch?
Well, the program will not be available to renters as we initially launch because we need to do some additional work to understand, put the appropriate protections in place for those customers.
Okay. I was not aware of that through your rebuttal. Is that a new position that the company has made since rebuttal?
No, I believe that's in my rebuttal testimony.
Okay. Well, I guess let me ask hypothetically, if the company goes forward and does make the program available to renters, would the company at least agree to track measures so that stakeholders can see, for example, what kind of measures renters are including in the financing and allow further discussion about whether those might be better shared as between renters and landlords?
I think we have to develop, as I've talked about, previously, we need to figure out more fully how to allow renters to take part in this program. We've asked for the commission to provide us the permission to move forward with a program that allows renters to do so, but we admit in my rebuttal that there is still some ongoing work that needs to be done to make sure appropriate guardrails are in place to protect these customers. So I don't know that I don't know that we're in a position right now to commit to any specific sort of tracking.
Can we turn to your rebuttal at page 51, please? That's hearing exhibit 103. Actually at page 52, lines 1, I read your rebuttal as saying that the company continues to recommend the commission approve the ability of the program to serve eligible rental customers. Has that changed?
No, we are asking for the permission to do that. However, if you continue to read on, that it will be a phased approach into the program after program launch. It's company's understanding that CCEF and Tri-State are working on a similar approach, and that CCEF has agreed to incorporate the company's program into how they approach this specific customer group as well.
Okay. Do you have any estimate of how long after program launch we could expect to see inclusion of renters?
I do not know, but I know that the work with Tri-State has been initiated, and again, the CCEF just plans to incorporate the company's proposal into that work as well.
Is the company amenable to committing to a certain time frame in which to make the program available to renters?
Not at this time. We don't know the specifics of the complications that CCEF is experiencing. They have a similar option that they're working through with Tri-State. They apparently do not have the experience serving this specific customer group, and so they're trying to develop an appropriate process to make sure the appropriate protections are in place.
Would the company commit to providing updates on that issue in this proceeding?
The company has committed to provide updates through its quarterly DSM stakeholder roundtables, and we can certainly provide updates on progress made here.
Okay, I appreciate that, Mr. Murphy. I just have one more topic to discuss with you, and that is the company's position that TOBF should be available to electric only or dual fuel customers and not gas only customers. That remains the company's position, correct? And Ms. Kunkel, you can take this down, please.
Yes, that for the launch of the program, that does remain the company's position. I would add that the company is not fundamentally opposed to including gas-only customers, but in conversations with CCEF, they have some very real concerns over launching the program and allowing such customers to take part.
So my understanding is PSCo has 440,000 gas-only customers at this time. Does that sound right?
That sounds accurate.
Okay. And all of these over 400,000 customers pay into the DSMCA. Agree?
Agree.
And the company is not proposing to exclude these customers from payment into any portion of the DSMCA. Is that correct?
We are not.
Okay. And let's go ahead and discuss the concerns then that you have raised, which you're suggesting are CSEF concerns. You've identified that customers seeking to reduce or eliminate gas service may have concerns or frustrations about receiving a monthly gas bill. Do you recall your testimony from your direct?
I do. The concern there is that for customers that fully electrify, it again would essentially be an unsecured debt that is out there that raises concern for CCEF that they may not be able to collect on that debt.
So I understood that as a second concern. This first concern is your testimony raises concerns or frustrations customers might feel. Do you recall that testimony?
I do, yes.
And do you agree that that appropriate marketing by the company could address that concern?
I don't know that marketing could fully address that concern. I don't know to the full extent of what may or may not frustrate customers.
The company attempts to address customer concerns or frustrations, for example, at billing issues through its marketing, does it not?
Yes, it does.
Okay. So let's talk about this unsecured issue. First, the assumption that a gas-only customer will fully electrify. Does the company have any data about how many gas-only customers can use up to $50,000 to fully electrify their home?
We do not, but I would again add that company and CCF share the concern that that is a possibility and could then lead to an unsecured debt. That CCF would be in a position to not have any collateral with which to collect that debt.
Okay, so it is a possibility, but let's first address the fact that, would you agree with me that customers have an incentive to pay their bills for reasons other than having their power shut off? Mr. Murphy, do you track your credit report or your credit score?
Not actively.
Okay. Would you agree that that delinquency on a bill can contribute to a lower credit score or credit history?
I'm not sure if that would be the case in here, since the eligibility is 12 months of utility on-time payment. There is no credit checks or anything like that. So I'm not sure if it would have impacts in this instance.
I'm suggesting that a customer that moves forward with TOBF and doesn't pay their bills, is there no risk that that would impact their credit history?
I do not know.
Okay. Mr. Murphy, isn't it true that public service regularly refers delinquent utility accounts to collections?
That's correct, yes.
Okay. And so you don't dispute, do you, that delinquency resulting in collections could factor into a customer's credit history or credit score, do you?
No, in that instance, I suppose that that's accurate. Again, we've designed this program to try and avoid going to that full disconnection policy, and CCF has established a process where they can work with the customer ahead of time to help address some of those issues they may be facing.
Sure. And I'm getting at your premise that the only way to avoid the potential risk that some gas-only customers may fully electrify and not pay their bills is to fully exclude them. So that's what we're focused on. So we've talked about that customers have an incentive to pay their bills, period. In your experience, or in public services experience, isn't it also true that there are very few connections when a customer disconnects from utility service and then leaves a fully outstanding bill?
I think that's accurate.
Okay. And in fact, in a discovery response in the last year, there have only been 2 customers out of the company's entire service territory who disconnected, didn't reconnect, and didn't pay their final bill. Does that sound correct?
That sounds familiar. Can we pull that discovery up?
Sure.
Thanks.
If we could go into box.com, please, Ms. Kunkel. This is hearing exhibit 805. And this is the request that you answered in response to Boulder 2-2, Mr. Murphy. And if we scroll down, you are indeed the sponsor, correct?
That's correct.
And the question is asking about customers who have voluntary disconnected services, don't reconnect, and fail to pay their final bill. Do you see that?
I do.
So your answer to in the last year was 2 customers, correct?
Correct.
And in the last 5 years was 12 customers, correct?
That's correct.
Am I correct that thank you. Am I correct that the company's service territory has approximately 1.5 million electric customers and 1.5 million gas customers?
I think that sounds accurate.
Okay, I would move for the admission of this hearing exhibit.
I think I would just add that I don't think that any of these customers were potentially experiencing, finance debt of $50,000.
Okay, I appreciate that.
Is there any objection to admitting?
No objection.
All right, it'll be admitted. Thank you.
Thank you. And we can go ahead and take that down. And I appreciate I'm nearing time, so I just really have a couple more questions, if you'll bear with me. Mr. Murphy, one proposal that was made in answer testimony to address these concerns about potentially having a gas-only customer who would then have an unsecured debt was to limit the type of measures that customer could access. Do you recall that?
Yes, I do.
And you respond in rebuttal that it is unclear how that limit would be enforced. Do you recall that?
I do.
So my question is, how does the company intend to enforce that a customer may only use any eligible measure as opposed to, say, buying a new car?
With the funding made available through CCF?
Correct.
Yeah, well, the CCF has a process where they confirm the actual installation of the measures.
So wouldn't that same process apply to a gas-only customer that's limited to solely installing envelope measures?
It would, and we took that feedback from parties in answer testimony, and we had dialogue with CCEF. They were still not comfortable designing the program in such a way.
Mr. Murphy, I apologize. first, I think you answered my question. Second, we've established that CSEF is not a party to this proceeding or available for cross-examination. Do you agree?
Yes, I agree.
So I'll leave it there. Just last, for these 440,000 gas-only customers that the company is proposing to exclude, going back to where we started, those are customers who, if they had access to the TOBF product, would potentially be incentivized to undertake efficiency upgrades that benefited the entire system, potentially at a lower cost to ratepayers than existing products. Would you agree with me?
I think that's a potential outcome. I would just note though that for some of these, it's not the entirety of the 440,000 customers that do not have a non-bill financing program available to them. It's my understanding that there is some overlap with the company's gas-only customers in tri-states electric service, and those customers would then have that access to tri-states on-bill financing program.
Okay. Thank you, Mr. Murphy. I appreciate your time this morning, and that's all I have, Commissioner.
Great. Thank you, Ms. Stockmeyer. Let's go ahead and take a 10-minute break, and we will come back at 11 o'clock with CEO.
Yeah.
Hey there. All right, we're back. Mr. Mitchell, there you are. And we're up with CEO for, I believe, 45 minutes.
Yes, thank you, Commissioner. Can everybody hear me?
Yes.
Yep.
Okay. Good morning, Mr. Murphy. I'm Jessica Lowry, Counsel for the Energy Office. Good to see you.
Good morning.
I have 5 topics to discuss with you. Eligible measures, renter protections, the ability for customers to pay down their financing obligations, the total amount of program capital allotted for this program, and then public services contract. That's just to give you an idea of where we're going. First, as to eligible measures. The company initially proposed including measures listed in the company's current or future DSM and BE plans and clean heat plans in its request for proposals to find a vendor contract. Is that right?
Correct, yes.
Okay. Could we bring up hearing exhibit 1001, which is in CEO's box? And do you recognize this as discovery request CEO 31, which you sponsored?
Yes.
Okay, thank you. And then could we go to the next page, which is the attachment? And do you recognize this as the RFP that the company issued to find a program administrator?
I do, yes.
Okay, I would like to move for admission of exhibit 1001.
Any opposition?
None.
All right, it's admitted. Thanks.
Thank you. Okay, and now I would like to turn to hearing exhibit 103, attachment PJM2, which is the eligible measure list. Okay, this list doesn't include battery energy storage systems, does it?
Does not. We have not proposed to support those through the on-bill financing program.
Okay, but they were included in the company's 2024 to 2026 DSM plan, right?
I'm not clear on that. I know that we have our Renewable Battery Connect program through our Renewable Energy Plan. Yeah.
Okay, could we bring up hearing exhibit 1002 from CEO's box, please?
Sorry, it's just taking a minute to open.
No problem. It's big. It's
Oh,
a big one.
I was just going to say that's because it's 625 pages.
To give you a heads up, this is going to be your 2024 to 2026 DSM BE compliance plan. Could we scroll down just so Mr. Murphy can see that title?
Thank you.
Okay. Could we turn to page 10, please? And then about halfway down, do you see it list commercial battery pay for performance?
I do.
Okay. And then could we turn to page 306, please? And that talks about Renewable Battery Connect, right?
It does, but again, Renewable Battery Connect is an offering through our Renewable Energy Plan, not our DSM and BE plan.
Okay, is that why it's not included as a measure or a product?
Correct.
Okay, and how about the commercial battery pay for performance? How come that's not included?
Don't know that that pilot has begun yet at this point.
Okay, thank you.
And
oh, go ahead.
Sorry. Well, and I would also say that we, as far as commercial participation, we have proposed to limit that to small business customers.
Okay. I'd like to move for the commission to take administrative notice of this exhibit, please.
Any objection?
No objection, but could we see the date, the first page? Ms. Lowry, I know you said it's the compliance version of this. I was wondering if we could just
Yeah.
make sure that's the case. But if there is no date, I'll just reserve my my thoughts till for an SOP. So no objection.
Okay,
Okay, it's admitted. Thanks.
okay, thank you. Yeah, and that one, this document doesn't have a heading from the company showing what date it is. Okay. All right, now I want to talk about EV charging equipment. Do you recall that, and you can take this document down, Ms. Kunkel. Do you recall that in the 2024 to 2026 Transportation Electrification Plan, the Commission required public service to utilize its future on-bill financing program to support participants in the EV Accelerate at Home Backup Power Option program?
Can we bring that up?
Sure. So that has been marked as hearing exhibit 1003. So this is decision C24-0446 in proceeding 23A-0242E. It's the decision on R in the 2024 to 2026 Transportation Electrification Plan. Is that correct?
It is, yes.
Okay. And then let's turn to page 18 and paragraph 40. And if you want to just read through that paragraph.
Thanks.
Okay. And is it correct? There's a sentence that says, once the company has established the on-bill financing program discussed in paragraph 101 of the decision, we direct it to utilize this new financing mechanism to support participants in the EVAAH program, which I will submit means EV Accelerate at Home Backup Power Option, in place of the utility ownership model used thus far in the EVAAH program. Is that correct?
That is correct.
Okay, can you briefly, if you know, describe what that program is?
Yes, that program is where the company provides level 2 chargers to participating customers for a monthly fee of approximately $13 over a 10-year period. After the 10-year term of the contract, the ownership of the charger is turned over to the customer. During participation in the program, the company has the ongoing maintenance and support for the charger while the customers are participating.
Okay, and so is it correct that what the commission is directing the company to do here is to stop using the utility ownership model, allow customers to purchase this equipment themselves, but that the company should include this equipment in the on-bill financing program?
I think that was the intent of the commission here, but I think, again, we find that we have proposed to support DSM and beneficial electrification permanent measures that are installed at participating customers' residences in this first iteration. We see the option to evolve over time. And so we did not include EV chargers as a part of that, since they are not vetted and approved through a DSM or BE plan. And I don't know that they're entirely permanent in nature, as they could be moved to a new residence.
Okay, is the company planning to include these in the financing for these types of systems in its next TEP?
We have not decided what we are or are not including in our next TEP. So I think it's a little early to say.
Okay, does the company have any plans to include these products in the financing, in the on-bill financing program?
Not at our initial launch, but as we've made clear in rebuttal testimony, we are open to, continuing dialogue with stakeholders through our DSM roundtable discussions, including talking about the potential to add additional measures or remove measures if necessary over time through either the 60-90 day notice process or an appropriate filing.
Okay, thank you. I'd like to move for the commission to take administrative notice of hearing exhibit 1003.
Any objection? All right, so admitted.
Okay, thank you. Finally, I want to talk about, and you could take this down, Ms. Kunkel. I'd like to talk about the company's energy efficiency financing program, its efforts towards that in the past. Are you familiar with the company's 2003 DSM plan?
I am not.
Okay. Could we bring up what's been marked as hearing exhibit 1004, please? Okay, and so this is the 2003 Demand Side Management and Beneficial Electrification Plan. This is also the compliance plan filed in proceeding 22A-0315EG, and it does have a date on it.
That's correct. One point of clarification, I believe I heard 2003 DSM plan and not 2023 DSM plan. This is our
Sorry.
2020. Well, I was going to say 2003 is a little bit too far in the past for me. So the 2023, I was not a part of that proceeding, but having been in this role as we were still implementing the 2023 plan, I have some level of familiarity with it.
Great, thank you. And yes, I meant 2023. Okay, could we look at page 19, please? And if you could zoom in to the top part of that table, can you see that the company lists energy efficiency financing under indirect products and services, education/market transformation?
I do see that, yes.
Okay, and then could we turn to page 11, please? And this describes market transformation and customer education. Would you agree that energy efficiency financing fits under the definition of market transformation?
I think that's accurate, yes.
Okay. And then based on your knowledge of this program that's in the 2023 DSM plan and the program that's being proposed, can you describe how the two are similar?
I do not have enough information on what was proposed in the 2023 plan to be able to answer that with accuracy.
Okay. And then do you see where it says that activities for which the company will not attempt to measure savings have an assumed modified total resource cost MTRC ratio of 1.0?
Yes, I do.
Okay. And so do you recall that in past proceedings, the commission has directed public service to presume that indirect market transformation programs have an MTRC ratio of 1.0?
I believe that's accurate, yes.
Okay. And I would move to have the commission take administrative notice of hearing exhibit 1004.
Any objections?
None.
So admitted.
Okay, great. Thank you. All right, I'm moving on to my second topic, which is renter protections. Do you recall that CEO made several recommendations related to renter protections, including providing clear communications to renters about their repayment obligations?
I do remember. I do recall that CEO made recommendations. The exact specifics I don't recall
Okay.
in their entirety.
Okay, if we could pull up hearing exhibit 1000, which is Ms. Durke's answer testimony, please. Thank you. And if we could turn to page 42, starting on line 9. Okay, if you want to refresh your memory about Ms. Durke's recommendations, you could read from lines 9 to 24.
Great, thank you.
Okay, and am I correct in summarizing these as the recommendations are that the financing agreement between CSEF and the customer should require the building owner to sign an affidavit affirming that they will provide notice to current and future renters that they will be charged monthly until the financial obligation is repaid or until their lease ends. Also, that the financing agreement should provide the building owner with language that can be added to the lease agreement. And finally, every time a new public service electric account is opened at a premise with on-bill financing, the company should notify the account holder that a financing obligation charge will appear on their bill.
I think that
Summary.
captures the recommendations. Yes, I don't know that the company agrees that, us or CCEF should be involved in lease agreements between renters and landlords. We agree that proper protections need to be put in place, and we agree to work with stakeholders on what those protections may look like, but we do not want to be positioning ourselves to be involved in lease agreements between landlords and renters.
Okay, thank you. And you also said that it would add unnecessary complexity to the program and increase the program's administrative costs, right?
Yes, I think that's accurate, and I don't know how we could accurately track when renters are coming and going amongst our 1.5 million customers as well.
Okay, thank you. Could we bring up hearing exhibit 103, attachment PJM1, please? And this is the proposed tariff for the on-bill program. Okay, thank you. And if we could turn to page 2. And then down under repayment recording. In the second paragraph, starting on the second sentence, it says, all responsibility for outstanding repayment obligations belong to the customer or any successor party to the customer, including any subsequent owner or otherwise. Failure of a customer to provide disclosure and notification of the existence of the program repayment obligation in real estate property transactions, including sales, leases, or rentals, shall not affect the company's ability to continue monthly billing obligations pursuant to this program. The authorized servicer has owner disclosure forms available for customer use in the program agreement. Is that correct?
That is correct.
Okay, I have a question about each one of those sentences. The first sentence that talks about the responsibility of outstanding repayment obligations, does this mean that any tenant who opens a new account at the premises is responsible for repaying financing obligations?
I will object with a minor objection.
Mhm.
This is a tariff. These are legal provisions. To the extent the council seeking a legal opinion, we would object to that. From Mr. Murphy's non-legal expertise, we're comfortable with those responses.
Thank you, that's fine.
Yeah, please go ahead.
I'm sorry, can you restate the question,
Sure.
please?
Does that first sentence mean that any tenant who opens a new account at the premises is responsible for repaying the financing obligations?
I think this is consistent with how we've framed the program where the debt remains at the meter. So the account holder will be the individual responsible for repayment of the finance debt.
Okay. And then the second sentence that talks about failure to provide disclosure. Does this mean that the company will not take responsibility to disclose the financing obligation to new account holders?
The notification that we've proposed is through a land record notice. But we've also stated in testimony, I believe, but if not in testimony in discovery, if, in the instance of a landlord tenant situation, it is the responsibility of the landlord, if their occupants change, to communicate the debt that is on the property.
Okay. And then the third sentence there that talks about the authorized servicer has owner disclosure forms. Does that mean that CSEF will provide the building owner with language that can be added to a lease agreement that will disclose the financing obligation?
My understanding, well, I guess to start, I think, as I discussed earlier in testimony, we're seeking approval to include renters in this program. However, we understand that there are additional protections and just program specifics that need to be further developed. In my understanding and working with CCEF, they are not requiring a disclosure form. I think this is, again, getting at the land record notice that will be made available to the county.
Okay. Would you agree that in most rental situations, the renter is the utility customer and responsible for paying the utility bill?
I think that's likely generally the case.
Okay. I want to talk about a situation where the renter installs an applicable measure, gets on-bill financing after getting permission from their landlord, and then moves out before the financing obligation is repaid. In that situation, the renter is the utility customer, not the landlord. So the landlord does not have a financing obligation, right?
That's correct. It's the account holder.
Okay. But the company believes that the landlord needs to be disclosing that obligation?
If the landlord is the one who has taken, well, I guess as the property owner, I think it's the landlord's obligation to provide the or CCEF will provide the land record notice, but it is the landlord's obligation to communicate to the renter or future renter the obligation of the finance debt.
Okay. And the company is not willing to inform a new customer of the financing obligation when the new customer requests service?
We have not proposed to be the entity to inform future renters. Again, I think these are some of the details that we can probably work through with stakeholders as we more fully develop this portion of the program.
Okay. Does the company send standard communications to new customers?
I believe we do, yes.
Okay. And does the company's billing system or customer record system, could it be configured so the customer's premise ID includes information about the financing obligation?
I suppose it could, but that would add additional costs that have not been contemplated in this proposal.
Okay, thank you. All right, I would like to turn to my third topic, which is the ability for customers to reduce their financing obligations. Do you recall that CEO made several recommendations for ways that program participants could make a larger payment than what is due and pay down the principal on their financing obligations?
Generally, yes.
Okay, and the first one was for the customers to be able to use DSM and BE rebates to reduce their financed amount. And the second one was that customers could pay a larger amount than is due each month, and that would reduce their total amount due.
That's correct.
Okay. Yeah. So in your rebuttal testimony, you responded to these and said that the company intends to promote rebate integration in 3 ways. One is communication from the company and CSEF, educating customers about applicable rebates. The other is netting rebate amounts out of the total financed amount. And the third is for the company to continue to work with CSEF to discuss whether there are unique solutions for financing applicants that would expedite rebate approval. Is that right?
That's correct, yes.
Okay. But you note the complications of the timing of the current rebate process, which requires customers to install the rebates or install the measures before they can get the rebates, right?
Yes, we acknowledge that.
Okay.
Maybe in certain circumstances.
Okay. Wait, what do you mean by that?
We just acknowledge the timing of the rebate processing and the need to get the financing may not perfectly align.
Okay. And your solution is to potentially assign the rebate directly to CSEF, who would apply the full rebate amount to the financed amount. Right?
That's correct, yeah.
Okay. Now I want to ask some clarifying questions about the current rebate process, and then we can talk about the proposed potential new rebate process. You already testified that it takes residential customers about 2 weeks to receive DSM rebates after their application is complete, right?
That was, if I'm recalling correctly, that was the average in 2024, again, outside of the adjustments to heat pumps that were made through a 60-day notice as agreed to in the DSM and BE plan settlement agreement.
Okay. And the company requires that the rebate measures or the DSM and BE measures are installed before processing a rebate application, right?
That's correct.
Okay. And currently the financing obligation, the customer would get the financing obligation before the measure is installed and before the rebate, right?
Currently that's how the structure is set up. Again, the company is continuing to engage and work with CCF to see if we can identify ways that we might be able to find ways to address that time difference.
Okay. Can we pull up what's been marked as Exhibit 1008, please? Okay, and this is Public Services response to Discovery Request CEO 4-2, right?
That's correct.
Okay, and you were the sponsor of this exhibit or this response?
Yes, I was.
Okay, I would like to move for the admission of hearing Exhibit 1008.
Any objection?
None.
It's so admitted.
Thank you. And for the record, this is talking about the current steps for the verification process for DSM and BE rebates, right?
That's correct.
Okay, thank you. Okay, you could take that down, Ms. Kunkel. Then I would like to pull up again, hearing Exhibit 103, Attachment PJM1, which is the tariff, proposed tariff. Okay, and if we could go to page 2 again and look at qualifying measures. Okay, and this states, if eligible, projects may receive a separate rebate or incentive payment from the company under the requirements of the relevant rebate or incentive program. Rebate and incentive payments are issued separately from the financing disbursement under the program. Is that correct?
That's correct.
Okay. A couple questions here. Could you confirm whether the customer will be required to apply the rebate to the financing obligation? In other words, they can't just take the rebate money as cash.
I don't know that we've spoke of specific requirements. However, how we have discussed this is we will be marketing our rebates to customers to make them aware that to help further reduce the finance debt they may need to take on, they can apply for company rebates and apply those rebates to the principal, helping to reduce the level of finance debt.
Okay, but that's not a requirement at this point, right?
It's not a specific requirement, no.
Okay. And as we discussed, neither Public Service nor CSEF is proposing a process right now that would allow the rebate to be processed before the customer undertakes the financing obligation, right?
That's correct. That's not how our current system works. But again, we are working with CCEF to hopefully identify ways that we can help to alleviate some of these timing concerns.
Okay. And then could you clarify under the company's proposal to assign the rebate to CSEF that CSEF would apply it to the principal of the financing obligation, which would decrease the total amount owed and the time that the customer needs to repay the financing obligation, and it would not lower the monthly payment for the customer?
That's accurate. Yes, it would just be applied to the overall principal and reduce the debt owed.
Okay. Do you know of any reason that it could not be used to decrease the monthly payment for the customer?
My understanding in working with CCEF is that would cause them additional administrative processes to be deployed and increase costs. So, yeah, that's my understanding.
Do you know how much that would cost?
I don't have an estimate now.
Okay, thank you. And you can take that exhibit down, Ms. Kunkel. Thank you. Okay. I would like to look at one specific statement in your rebuttal testimony. So could we pull up hearing exhibit 103? Thank you. And page 50, lines 6 through 8. Okay, so here it says, customers that participate in the TOBF program will have the ability to contact CSEF and make larger payments than their agreed to monthly payments that will be applied to the total finance debt. Is that right?
That's accurate.
Okay, so this makes it sound like if a customer wants to make a larger payment, they need to contact CSEF and make that payment to CSEF. Is there a way that the customer could just make a larger payment to Excel that would go towards the financing obligation?
My understanding, and as we've discussed this with CCEF, is that, and also internally, if a customer makes a larger payment, it wouldn't be abundantly clear to the company when we receive the payment where it's expected to put those additional dollars. And so therefore, customers will need to contact CCEF to make clear that they want to provide additional payments. Then CCEF could then communicate that to us.
Okay, thank you. I'm finished with this exhibit and I'm ready to move on to the next topic, which is the total amount of program capital. As you discussed with, I think Ms. McLaughlin, the total that CSEF has right now budgeted for this program is 10 million and it's hoping to get up to 25 million, right?
That's correct.
Okay. Do you have any knowledge of examples of funds running out in DSM programs, RES programs, or TEP programs?
I am familiar with budgetary issues we encountered in some programs in 2024.
Okay. Ms. Durkay made a couple of suggestions in her testimony to prevent that kind of thing from happening in this program, and the company didn't address those in rebuttal. So I wanted to ask you about them and whether you'd have any concerns with the commission adopting them. And these are, if you want to look at hearing exhibit 1000, which is Ms. Durkee's answer testimony on page 39. Okay, so these are basically from lines 5 through 22, and I'll just summarize them really quickly. The first one was to ensure that CSEF clearly communicates to customers that receiving pre-approval for financing doesn't mean funding's guaranteed until they have signed a program agreement with CSEF. The second one is for public service to implement a reservation system where the customer has 30 days to initiate a project after they receive approval for financing to ensure funds would remain available. And the third one is for the company to require CSEF to approve financing for up to 115% of the project quote given from a contractor to account for changes in costs. Do you have any concerns with the company adopting any of those proposals?
The company received nearly 100 individual recommendations through party answer testimony. And although we did not directly respond to each and every recommendation from parties, I believe that I did make a statement that if the company did not address parties' issues or recommendations in my rebuttal testimony, then the company generally does not agree with those recommendations.
Okay, go ahead.
And I think here the concern is this adds additional complexity, which then will add additional costs to the program.
Okay. Does the company have any proposed solutions to ensure that the funding does not run out while the customer is in the process of securing financing or purchasing the measure?
My understanding in working with CCEF is they will be closely monitoring their budgets. We discussed programmatic budget issues that did occur in 2024. Those were the company's issues, and we addressed them and we worked through those, and we are managing our budgets appropriately. The up to $25 million is capital that CCEF will be providing, and it will be their responsibility to manage their budgets.
Okay, thank you. And you can take down that exhibit, Ms. Kunkel. I've gotten my last topic, which is the company's contract with CSEF. As you probably recall, CEO asked Public Service to file the contract, the final contract at the end of this proceeding, so interveners in the commission can ensure that the contract terms are consistent with the commission's orders. And in rebuttal, you said that it was not appropriate for the company to file a contract with a third-party vendor, but that the contract would comply with the commission's decision, or the company would walk away from the contract and the program. Do you recall that?
I recall not agreeing to file the contract with the commission, as this is a normal course of business for the company to work and negotiate with third-party vendors that we engage with.
Okay, but do you recall also saying that if mutual agreement can't be reached in 30 days, the agreement will terminate?
Yes, that will be a term that will be in the contract, something similar to that language.
So is the company saying that if it doesn't like a term in the commission's decision, that it will just walk away from the contract and have no program?
Company is saying, well, I guess first, I'm not an attorney, but the company is saying that any modifications or changes to the program as it's been proposed through our rebuttal testimony will require renegotiation with CCEF to make sure that both the company and CCEF are amenable to any of these changes. In the event that either party cannot agree to the terms, there is that provision that either party can walk away.
Okay. And I have a slightly modified proposal regarding the final contract that I wanted to see if you would be amenable to. And that is for the company to file it as highly confidential, where only staff and the commissioners have access to it, so that staff and the commission can ensure that it complies with the final commission decision. Would that be amenable to the company?
I would object. Of course, this contractual negotiation is an issue of legal interpretation and legal analysis. Mr. Murphy's already testified. He's not a lawyer. The legal issues can be addressed in Ms. Lowry's statement position.
Overruled. I think you can answer the question, and if you need to clarify the legal concerns you have, you can do that in your cross.
The company's position does not change, just given that the suggestion is to file as highly confidential. Again, I am not an attorney, but it's my understanding that this is not the normal course of business for the company to be required to file contracts with third-party vendors with the commission. And I think further legal issues could be addressed through our subsequent filings.
Okay, thank you. One more question, another different proposal. In order for interveners and other stakeholders to understand the program elements that the company and CSEF have negotiated that are not in the tariff, would the company share CSEF's program documents with parties or make them available on their website?
I'm sorry, like are you referring to like marketing materials, et
I'm
cetera?
assuming that there's some kind of program design document that CSEF is going to create that is going to have the program elements in it that have been agreed to through the contract, part of the commission decision. Basically anything that relates to program that's not in the tariff. So eligible measures, any interest rates, things that are not in the tariff that maybe have been agreed to in the contract. Will there be any public facing document that contains that information?
There will be public-facing materials that are used to communicate how the program works to customers. So that will be publicly available. Interest rates approved, eligible measures, et cetera. Those will be part of the marketing materials that CCF creates and also the company creates.
Okay. And just one more thing, if we could pull up your rebuttal testimony again, hearing at 103. And page 59, line 7, talks about CSEF's program documents. That's what I'm talking about here.
Yeah, and I think that's getting at, sorry, and I think that's getting at the marketing materials that we're discussing.
Okay, great. Thank you. That's all the questions I have. Thank you, Mr. Murphy.
Thank you.
Thank you, Ms. Lowry. And now we have Clear for 30 minutes.
Good morning, good morning, Mr. Murphy. For the record, I am Sarah Judkins representing Clear, and I would first like to focus my questions on the availability of authorized contractors under the program. So first, in order to participate in the TOBF program, the company has proposed that customers must use a CCEF authorized contractor, right?
That's correct.
I have a few questions about rural parts of the company's service territory. When I use the word rural in this conversation, can we agree that we're generally talking about areas of the company's service territory that are not located in the Denver metro area?
Sure, generally.
So how many of CCEF's authorized contractors provide service in rural parts of the company's service territory?
I do not have that exact number, but given that CCEF's approved contractors support the Tri-State on-bill financing program, it's my expectation that some level of those contractors are supporting rural communities as well.
And are there authorized contractors located in the Denver metro area that are available and willing to provide service to customers located outside the Denver metro area?
I don't have knowledge into the specific business decisions of independent contractors within the Denver metro area.
So based on these two questions and answers, it's uncertain whether customers in all parts of the company's service territory will be able to access an authorized contractor as is required to participate in the TOBF program, right?
I can't state with any level of certainty whether customers will experience difficulties or not. I will say that the company and CCEF are continuing to further align both of our approved contractor networks to provide even more coverage throughout the service territory.
You. And in your rebuttal testimony, you stated that, in your opinion, CCEF is well suited to promote a contractor network for the company's rural customers. And I think you were just addressing this as well.
I'm sorry, can we pull that up?
Sure. So this is hearing exhibit 103, Mr. Murphy's rebuttal testimony on page 56, please. And if you can scroll to look at lines 15 and 16, I think we might need to scroll down. Thank you.
Yes, this is what I was discussing previously.
Right, and that statement was based on the fact that CCEF is working with Tri-State to provide similar services for its on-bill repayment program, right?
Correct.
And are you, I think we can take this down, thank you. Are you aware that Tri-State provides on its website for the Electrify and Save program information and links to CCEF's website regarding how a contractor can become an authorized contractor?
I'm not familiar with all of what Tri-State has on their website.
Well, if I were to represent to you that they do in fact have this information on their website, would the company be willing to commit to providing similar easy to access information for contractors on how to become an authorized contractor?
I think we want to provide our customers with the information that they need to get to be able to take part in this program, including contractors that can service this program. So I don't know in what form we'll make that available here today, but I think we want to be as transparent as we can so that customers throughout our service territory are aware of which contractors they can work with to qualify to take part in the Tariff on-bill financing program.
Thank you. And would that extend to helping make sure contractors have the information that they need to become an authorized contractor under the program?
Yes, and I think we're trying to do that now. We are working with CCEF to better align our contractor network along with CCEF's as well.
And are you aware that Tri-State also has an incentive or bonus program for contractors who participate in certain trainings and then install upgrades that are eligible for the on-bill repayment program?
Again, I'm not familiar with all the specifics of how Tri-State's program works.
Okay, that is reasonable. But if I were to represent to you that they indeed have this incentive or bonus program, would the company be willing to implement a similar type of incentive or bonus program that would incentivize contractors to participate in workforce training and become authorized contractors for the TOBF program?
We have not proposed something of that nature specific to the Tariff on-bill financing program. So, while not generally opposed, I would point out that there is no specific budget to support such a suggestion. And if such a modification was made to our program proposal, it would mean additional costs and specific to company costs if you're suggesting that the company pay these incentives, or additional costs for CCEF if you're suggesting they should pay the incentives.
But expanding the geographic reach of authorized contractors would help customers throughout the service territory, and especially in rural areas, access TOBF opportunities, right?
I'm sorry, can you restate that?
Yeah, of course. So expanding the geographic areas covered by authorized contractors would help customers across the company's service territory have access to the TOBF program, right?
Yeah, I think providing more opportunity across the service territory will be helpful to customers that are looking to take part in the tariff on bill financing program. And that is what we're working with CCEF to do.
And one method to achieve this expanded geographic reach would be to help existing contractors, particularly in underserved areas, become authorized contractors through workforce training, right?
That is one possible route, but again, we have not proposed any sort of workforce training budget. We do trainings for our existing trade network to help them more fully understand program offerings that the company has in place, and we will incorporate tariff on bill financing into that trade network training. And we're looking to align better with CCEF's contractor network to expand access for customers across our service territory.
So based on that, it sounds like the company is actively engaging and is planning to provide opportunities to expand the contractor network to make sure, or to help make sure, that contractors are available throughout the service territory.
We are always looking to expand our contractor network. And better aligning with CCEF is only going to be more supportive of this program.
Moving on to the company's plan and CCEF's plans for outreach and marketing of the program. In your direct testimony, you stated that the company will conduct outreach and provide information on the TOBF offering through its website and customer-facing materials, as well as channel outreach campaigns, right?
Correct.
And you stated that the company is also planning to work with CCEF on marketing and customer outreach, right?
Correct.
Has the company, or the company in conjunction with CCEF, developed any plans to conduct outreach specifically to rural customers in its service territory related to the TOBF program?
We haven't developed any of our marketing materials at this point, since we do not have an approved program by the commission, so we do not know the specifics of what this program will look like.
And has the company discussed with CCEF the importance of planning a marketing campaign or outreach to rural customers?
I don't know that that's been a specific topic that we've talked about, but in working with CCEF, we both understand the importance of effectively marketing this campaign or this program across the entirety of our service territory, whether that be in the Denver metro area or the rural areas of our service territory.
And has the company considered the fact that there might be marketing measures that are more effective in rural areas, or might be needed in rural areas that are different than those in the Denver metro area?
Again, we have not begun to develop any of these marketing materials, as we do not have a final approved program at this time.
Thank you. And you reviewed the answer testimony of CLEAR witness Alice Laird in preparing your rebuttal testimony, correct?
Correct.
And I understand there were a lot of recommendations made in this proceeding, but you did not address Ms. Laird's testimony related to specific outreach measures that can be effected with rural customers in your rebuttal testimony, correct?
I think that's accurate.
And do you recall that her testimony included recommendations related to partnering with local nonprofit organizations and local governments, specifically through rural regional energy networks, or RENs?
I remember some discussion. However, I also recall that there was actually no actual budget proposed to support such efforts, nor was, it was somewhat unclear on how or who was going to actually fund this type of outreach. So we're not sure if it was recommending that the company conduct such outreach, in which case we do not have specific budget set aside for such specific outreach as outlined in the testimony. And if it's CCEF, I cannot speak to that.
But the company has included marketing and outreach costs in
Correct.
its budget, right?
Correct, yes, and that will be throughout our service territory.
Understood. Would the company be willing to commit to putting some of that budget towards working with nonprofit organizations and local governments in rural parts of its service territory to ensure that outreach, marketing, and education is conducted in an effective manner for those customers?
The company has not made such a proposal in its testimony.
I understand that, but can the company commit to doing so?
The company is committed to what it has put forward in its rebuttal testimony. We think we have a reasonable program that we have put in place and proposed for the commission's consideration. We are committed to creating marketing and outreach efforts throughout our service territory, but we have not committed to put any specific budget towards addressing some of the issues you've raised here.
Great, thank you. Moving to a new topic, to level set, you've discussed several times this morning that the company has proposed an initial budget for the program of $25 million, right?
Yes, up to $25 million over the initial 3-year term.
And over that initial 3-year term, that would average to approximately $8.3 million per year. I understand it's not on an annual basis, but on average.
Yes.
And in your direct testimony, you testified that it's important to have sufficient funding available to meet customer interest, right?
I believe that's the case. Can we pull up the testimony?
Sure. This is hearing exhibit 101, please, on page 20. And if you can look at lines 6 through 8, please.
Yes, that is what the testimony says, but I would also point out that the company makes clear that we do not know what customer uptake will look like as we look to launch this program. We think that up to $25 million for the initial 3-year term is a sufficient level of funding.
You anticipated my next questions, that the company didn't conduct any customer interest surveys to understand potential customer participation, right?
As discussed earlier, we did not conduct any surveys regarding the on-bill financing program.
So you cannot know with certainty whether the proposed budget is sufficient to meet customer interest, right?
In working with CCEF in their experience implementing similar programs, both the company and CCEF agree that up to $25 million for the initial 3-year term should be sufficient to support customer needs.
And in setting this initial budget, I understand that there wasn't a customer survey, but did the company or CCEF look at on-bill financing program budgets for other utilities?
I did not specifically.
And did the company or CCEF look at on-bill financing programs, actual program spend for other utilities?
In working with CCEF, I believe one of their programs that has been in market has I'm not remembering the exact level, but I think in the first few years has issued approximately $10 million in funding.
Thank you. And that is slightly above the average of 8.3 million over the first 3 years.
But it's over a multi-year offering.
Sorry, I misunderstood you. I thought I heard you say $10 million annually. Did I
Not
misunderstand?
annually. Yeah,
Okay.
not annual. In the first few years of implementing.
Thank you for the clarification. And did the company conduct any other analysis in setting this initial budget?
No, no specific analysis, just engagement with our third-party capital provider.
And so because the company did not conduct customer surveys or another analysis to support the proposed initial budget, there's no way for the commission or the company to be sure that 25 million is sufficient to meet customer interest as compared to another amount.
This is the level that both the company and CCF are comfortable with launching the program at for the initial 3-year term.
But it is possible that that proposed budget is too low, correct?
We don't know what program uptake is going to look like, so it could potentially be too high. It could, to your point, potentially be too low.
And moving on to my last topic of interest rates. The company has proposed interest rates ranging from 5 to 5.99%, depending on the repayment duration, correct?
That's correct.
And the company stated in a discovery response that it did not seriously consider potential options to reduce these interest rates, right?
Can we bring up the discovery response, please?
Sure. It's hearing exhibit 500, which is the answer testimony of sweeps witness, attachment RA-4, please. And on this first page, if you can look at the subpart B and the response to subpart B. Do you see where it states that?
I'm reading it now.
Okay, thank you.
The question is specific to using approved DSM or BE funds or another source of capital, and the company has not considered doing that, no.
And you also stated in the answer to subpart A here that the company believes that the interest rate will affect customer interest in the program as well as the customer uptake rate, correct?
Correct.
And by that statement, you meant that the company anticipates that higher interest rates would decrease customer interest and customer uptake rates, correct?
No, I think we were getting at providing below market interest rates could potentially increase customer interest in this program.
Thank you. But would you agree that, even considering the range of below market rates, that lower interest rates would increase customer interest and uptake?
I think that could be an outcome. However, the company has not proposed any sort of funding to further reduce the below market rates that CCEF has put forward for this program.
And you already testified that the company did not conduct surveys or studies on customer interest in the program. So the company cannot know whether its proposed interest rates, even below market, will advance or hinder customer interest or uptake, right?
I think what we've proposed is a reasonable program to get out into market and understand customer uptake at the proposed interest rate levels.
Wouldn't it have been helpful for the company to evaluate lower interest rates to understand potential impacts on customer interest and funding options?
The company has not conducted that analysis. We have just worked with a third-party capital provider to access interest rates that are still well below market rates. And we think that this approach is a good starting point for an initial launch of our Tariff on-bill financing program. Any further analysis or study is just going to unnecessarily delay the implementation of this program.
Thank you. And to be clear, Clear has not suggested in answer or cross-answer testimony that this type of study be conducted, now or in the future, but just that it would have been helpful to see that. And so without that evaluation or analysis and the company's, general understanding that lower interest rates may increase customer interest and uptake, shouldn't the commission approve the lowest rates possible?
I think the commission, I would like for I think the commission should approve the interest rates that we've proposed, that our third party capital provider has put forward, which are below market and are a great starting point for this program as we get it out for customers.
Great, thank you. Those are my questions, Mr. Murphy.
Thank you.
Thank you, Ms. Judkins. I think we have next, yes, Energy Outreach Colorado, Ms. Camilio.
Thank you, Commissioner Plant. Good afternoon, Mr. Murphy. I will just say my Zoom is telling me I have an unstable internet connection. So if we run into any technical issues, I apologize in advance, and someone please let me know and I'll turn off my camera to see if that helps. So with that, good afternoon again. My name is Casey Canelio and I represent Energy Outreach Colorado, which I'll shorten to EOC. And by my calculation, you're now halfway through your cross, so it's only downhill from here. I'm hoping to talk with you about 5 topics related to the company's on-bill financing proposal, and those are tenant-occupied property participation, income-qualified customers, disconnections, the CSEF debt workout process.
Ms. Canelio, I think you're breaking up, so maybe you've kind of frozen on the screen.
Thanks for kicking.
Ms. Canelio, you've frozen on the screen, so I'm wondering if you might turn off your video.
Can you hear me now?
I can hear you. Yeah, your video's still up. I don't know if you can turn off your video.
I apologize.
And maybe you
can.
There you go.
It is off. Okay, can you guys hear me
Okay.
okay now? And I apologize.
I think you're good now. Thanks.
So kicking us off, Mr. Murphy, you've already gone into this with some of the other parties, but just to clarify, is that right?
Yes, as I discussed with other parties, the company is seeking permission to include renters in the program as we launch it. However, renters actually taking part in the program will be a phased-in approach that, as we further develop with CCEF protections and guardrails to make sure that those are properly in place.
Thank you. Do you think it's possible then that there will be instances where a landlord-initiated home energy improvement will become the tenant's financial obligation rather than the landlord's obligation?
As we've proposed, the finance debt will be the obligation of the account holder. So in the instance where the landlord is the account holder, then that landlord would be responsible for the finance debt. In the instance where a renter is the account holder, then that renter and the subsequent renter would be the individual responsible for payment of the finance debt.
Okay, so hypothetically, if a tenant faced affordability issues and having to pay both the energy portion and the finance portion of their utility bill, do you think it's possible that tenant could become delinquent on their overall utility bill?
I think that is a possibility. But again, we've put forward a process where customers can work with CCEF if they become, we propose to have the finance debt be subordinate to the utility charge. Therefore, and if a customer becomes behind on their finance debt portion, then what we've proposed is an option for CCEF to be able to work with that customer on a case-by-case basis to help them get their account back in good standing.
Okay, great. And we'll get into that a little bit later. But do you think it's possible that falling behind on utility bills could result in a potential eviction for a tenant?
I suppose that's a possibility. I don't really, I can't speak to the specifics of leasing agreements.
Understood. And are you aware that EOC has expressed concerns with possible unintended consequences that tenants could face in this new program?
I know that EOC did raise some concerns with renters taking part in this program if the appropriate guardrails are not in place. And I think that the company has committed to establish such guardrails to help make sure that renters are properly protected.
Thank you. That kicks us off on our next couple questions. So, but the company hasn't specifically proposed any processes or documentation to support renters at this time beyond that landlord notification requirement that you've testified to earlier. Is that correct?
Correct. We are, as we worked through rebuttal and worked with CCEF, we became aware that CCEF has a similar situation that is, that they're currently dealing with their tri-state program, where renters were approved into that program, and now CCEF is trying to establish a process so that the proper guardrails are put in place. And now we'll be also incorporating the public service program that we've proposed here today to have a similar structure or, address any unique needs that our program may need.
Okay, great. If we could please pull up hearing exhibit 901, which is in EOC's box folder. Okay. Mr. Murphy, in Discovery, EOC asked the company to provide information on the CSEF and Tri-State on-bill program renter integration process. Does that look accurate?
That's correct, yes.
And the company answered it does not have any additional documentation or information as of yesterday. Does that also seem accurate?
That's correct.
And you were the sponsor of this discovery response, right?
Correct.
Okay, great. If I could please move for the admission of hearing exhibit 901.
Any objections? So admitted.
Great. If we could now turn to hearing exhibit 902, also in EOC's box folder. So Mr. Murphy in Discovery, EOC also asked the company how it will approach the proposed phase-in process for eligible renters. Do you recall this?
Yes, I do.
And you explained earlier today with Ms. Stockmeyer that the company needs to do some additional work before phasing in renters, right?
Correct.
And the company answered, if you could scroll down to the response, please, a little bit more. Yeah, thank you. The company answered in this response, it'll update stakeholders through the quarterly DSM roundtable discussion process, right?
Correct.
And EOC also asked the company in this discovery request if it would utilize the 90-day notice process for the phase-in, for this phase-in for renters. Do you see that?
I do.
And the company answered no.
Yes, that's currently our position that we don't see, we will be transparent with stakeholders as we work through this process through our quarterly stakeholder meetings. We'll take input from stakeholders as well. But we don't, we're asking for explicit commission permission to include renters in this program. We don't see the need to then issue a 60-day notice to allow for that to occur.
Okay. And you were the sponsor of this discovery response EOC 22, were you not?
Yes, I was.
Okay, great. If I could move for the admission of hearing exhibit 902.
Any objection?
None.
It's submitted.
Thank you. We could take this down. Mr. Murphy, would you generally agree with me that the company uses the 60 to 90-day notice process for new DSM programs?
For new programs and modifications to existing programs.
And as part of this process, stakeholders can provide comments on new programs and those modifications, right?
Correct.
And then public service generally has 30 days to consider those stakeholder comments, right?
Correct.
Okay, great. The last discovery request I want to go over with you on this topic, Mr. Murphy, is hearing exhibit 903 and EOC's box folder. And Mr. Murphy, in this discovery request, EOC asked the company if it would commit to including the issues of renter guardrails and protections at future DSM quarterly roundtable meetings. Do you recall this?
I do.
And the company answered it's open to providing updates on progress for the renter phase-in. Is that accurate?
That is accurate. Yes.
And you were the sponsor of this discovery response, EOC 23, right?
So is.
Great. I'd like to move for the admission of hearing exhibit 903.
Any objection?
None.
It's admitted.
Thank you. So, Mr. Murphy, based on the company's response to EOC 23, the company says it's willing to provide updates on developing renter guardrails and protections, but that doesn't mean that the company is willing to accept any input from stakeholders, or does it?
I believe in an earlier question, I discussed that the company will be providing updates and discussing this topic in our quarterly stakeholder meetings, and we're certainly open to feedback from stakeholders, as with any issue that we discuss in those meetings.
Okay, but the process that the company envisions for this renter phase-in, does it provide the commission or any intervener a chance to modify the company's future renter property proposal as it gets phased in?
Again, we're open to feedback as we discuss this with stakeholders, and I think reasonable feedback that can be adopted the company can consider that, but we haven't proposed any specific process beyond that.
Okay, and just to clarify, hypothetically, if the company were ordered to use the 60 to 90-day notice process for the renter phase-in, the company would be required to consider stakeholder input, right?
It's pretty choppy on my end.
Yeah, it wasn't exactly clear there, Ms. Canelio. I think you were saying if the commission ordered it, then they would do that. Is that what you were? I'm trying to work through the choppiness of your question there, or you could try it again. Did we lose Ms. Canelio?
Yes. I'm still here if you guys can hear me. I'm gonna try to call in, and I'm in New Mexico and I don't have great internet here.
Yeah, you just came back. You were gone for a while, but if you want to go ahead and try and call in, and you can try and re-ask your question while you're doing that, you can go ahead.
Okay. Okay, so hypothetically, Mr. Murphy, if the commission ordered the company to utilize the 60 to 90-day notice process for the renter phase-in, the company would need to consider stakeholder input, right?
Company would consider input provided through stakeholder comments provided through the 60-day notice process in that instance.
Okay, great. Thank you. And again, apologize for my technical difficulties. We're going to turn now to the topic of income qualified customers. Just to level set, if we could please pull up Mr. Murphy's direct testimony, hearing exhibit 101, starting at page 7. Looking at lines 9 to 12, do you see here that the commission held in the company's 2022 strategic issues case that on-bill financing is a cost-effective way to reduce barriers to participation, especially among IQ customers who may lack resources to make costly upfront energy investments?
That's what the cited testimony says.
And your testimony also from this commission decision a little bit further down that the commission encouraged the company to prioritize availability of this financing for IQ customers. Do I have that right?
You're a little choppy, but I think you're referencing these lines 13 to 15. Is that correct? Yes, that is what that says.
Yes. Okay, thank you. Now, under the company's proposal, IQ customers in good standing would be fully eligible to participate in the financing
That's correct.
program. Is that right? But the company's position in this case is that IQ customers are unlikely to need to utilize this program. Do I have that right?
I think that's accurate because we have rebates in market to support these customers, generally up to the full cost of these measures. And it's the company's position that we would rather our income qualified customers take advantage of these rebates that we have in market rather than take on additional debt.
Thank you. Mr. Murphy, do you know how many income qualified customers are in the company has in its electric service territory?
I do not know that number.
If we could please pull up hearing exhibit 905 in EOC's box folder and go to page 10. So Mr. Murphy, this is answer testimony from EOC in a previous phase 2 rate case proceeding with the company. And if we go to page 10 here on lines 8 to 14, EOC's witness, in this case, Dr. Eric Nussbaumer, estimates that the number of IQ households in the company's service territory is likely somewhere between 377,000 and 470,000 households. Do you see that?
I do see that. I would note that I was not involved in this proceeding.
Understood. Do you have any reason to, dispute this general estimate on IQ households in the company's service territory?
I do not know the number of IQ customers in the service territory and not understanding the full implications or issues that were raised in this proceeding. I don't know that I can support or deny these levels. But I would say that the company aims to support all of its income qualified customers through its programming efforts.
Okay. I'd like to move for administrative notice of hearing exhibit 905, which is previous answer testimony from EOC that's in the commission's files.
Is there any objection? So admitted.
Thank you. And we can take this down. Thank you. Mr. Murphy, do you think that the company's currently approved DSM, BE, and clean heat budgets for IQ programming would be able to serve hundreds of thousands of IQ households in the company's service territory?
Well, I would add that it's not only our DSM and BE budgets. We've significantly augmented our rebates as well using clean heat funding. I don't know that they're at levels to support all of our income qualified customers. That said, I don't know that all of our income qualified customers are looking to participate in all of our programs.
So in your testimony, which we don't need to pull up, but you
Miss
quoted
Cornelia, you are breaking up again.
Miss Cornelia, are you still there?
It looks like she dropped. Perhaps she's calling in.
Okay, we'll give it a minute and see if she joins.
Apologies, everyone. I'm Mr.
I think we're at 12:25 right now, Miss Canelio. I'm not sure if you can hear me or not, but let's go ahead and break for lunch. We'll break from 12:20.
Yes, I can. I can. I'm sorry.
Back. Okay, are you on a phone now? Is this a stable line?
No, but I'll be moving to a secure location on the lunch break. So I think breaking now would be great. And I apologize again for all these difficulties, and I'll be ready to go your deliberation
Okay.
at 1 p.m.
Okay. Let's go ahead and break for lunch, Miss Cornelio, and we'll come back at 1:25, and we'll come back to you, Miss Cornelio, if you can try and get a good connection, that'd be appreciated, and we'll just pick up with the end of your cross at that point.
Thank you. And I apologize to everyone and
No worries.
difficulty.
Okay, we'll be on break until 1:25. Just remember to mute your microphones because we will stay live on YouTube. All right, thanks. All right, we're back. Ms. Cornelia, looks like you have a much more stable connection this time.
Yes, I'm hoping that is the case, and I just want to apologize again to Mr. Murphy and the parties for those issues prior to the lunch break. So everyone can see and hear me okay?
Yep, sounds great.
All
And
right.
you still have, I think, 10 minutes left in your cross, and so
Okay.
it's back to you.
Great. Just in case, I might appreciate a couple minutes of leeway with the technical difficulties, but I'll try to keep it to 10 minutes. So, Mr. Murphy, I want to return to a question I attempted to ask you before the lunch break, but in your rebuttal testimony, which we don't need to pull up, you quoted a paper that was actually an attachment to the City of Boulder's answer testimony, in this case from the National Regulatory Research Institute. Do you recall that?
I do.
Great. If we could pull that attachment up, it's attachment CCE 12. That was a part of hearing exhibit 800, and go to page 4. And just to level set, Mr. Murphy, I still have a couple questions for you on income qualified customers. So that's the topic that we're still on. So if we can scroll down to the third paragraph on the left-hand column, the short paragraph, Mr. Murphy, do you see here the paper states that on-bill financing may have risks for low-income customers?
I do see that.
And if we can take this down, thank you. And if we turn back to your direct testimony and hearing exhibit 101, and we don't need to pull it up necessarily, but you state the company will track IQ customer interest in the financing program. Do I have that right?
I believe that's accurate. Yes.
Thank you. And do you recall the EOC's answer testimony recommendations, or that the commission should order the company to create a pilot program for income qualified customers?
Yes, I do.
And the company has other IQ pilot programs currently in place for some DSM offerings. Is that accurate?
Yes, I believe that's accurate. Yeah.
And would you agree with me that EOC's answer testimony states the company should develop certain protections for IQ customers?
I do. I don't remember the specifics of the suggestions on that EOC put forward as far as protections.
Does it refresh your recollection that one of EOC's recommendations is no disconnections for income qualified customers as part of a pilot proposal?
Can we pull the testimony up, please?
Yeah, of course. Yeah, if we could go to hearing exhibit 900. And that's Mr. Ilderton's answer testimony, page 22. And line 18, starting at line 18. So, Mr. Murphy, do you see here that Mr. Ilderton recommends the creation of this pilot program to track participation and assess risks for IQ customers?
I do see that, yes.
Okay, great. And then do you see, kind of going into the top of page 23, that this pilot program could also be a way to help get additional resources to support IQ customers who might be interested in the TOBF product?
I do see that, yes.
Okay, great. We can take Mr. Ilderton's testimony down. And so do you recall that EOC's also recommended that a standalone stakeholder group could allow for discussions on how to deliver this new program to IQ customers?
I know there were several recommendations for standalone stakeholder groups, not only to address income qualified customers, but other issues raised by parties. The company has proposed a more efficient process may be to use the opportunities we have through our quarterly stakeholder roundtable meetings. Because, as we point out in my rebuttal testimony, that these stakeholder efforts do take company resources to staff to prepare for, and we just find that streamlining these processes through existing stakeholder processes is a more appropriate route to take.
Okay, but would you agree with me that there's numerous programmatic aspects of this new program that still need to have their details worked out?
I think the renter issue is one that needs to be worked out. We've agreed to continue discussions around gas-only customers. As far as income qualified customers, I think what we've proposed is that those customers can take part in our tariff on bill financing program, but the company would work with those customers, especially through our outreach and engagement efforts and with the partnership that we have with EOC to direct those customers interested in this program to also take, advantage of the rebates that we have in market as well, so as to not have to take on additional debt.
Okay, thank you. Turning to my third topic, which is disconnections for on-bill financing. You talked with staff's counsel on this already earlier today, but would you agree with me that as proposed by the company, a risk of on-bill financing participation is a utility disconnection?
Company has proposed the use of disconnection as a tool for non-payment of the finance debt portion of a customer's bill. But as I've discussed previously, we've also worked with CCEF, where they have designed debt workout processes to hopefully get in front, work with customers prior to them moving into the company's more formal disconnection process.
Great. And I have a couple questions about that process. But before I get there, if we could pull back up attachment CCE 12, that was a part of attachment or hearing exhibit 800 from Boulder's answer testimony, and go to page 7. So Mr. Murphy, in the first paragraph, on the right hand side of the document, so if you go below these two blue parts of the those two blue paragraphs, do you see here that the author of this paper cautions that implementation of TOB should not result in service disconnection for non-payment of the energy improvement portion of a low-income utility customer's bill?
I do see that, yes.
Okay, and we can take this down now. And we previously just discussed that EOC's preferred approach is there's no disconnections for non-payment of the OBF debt for IQ customers, right?
Correct.
And now turning to that CCF debt workout process for customers who fall behind on their OBF payments, your rebuttal testimony discusses this, right?
Correct, yes.
And you mentioned that CCF can allow a customer to have their repayment obligations paused for up to 3 months. Is that accurate?
Yeah, I believe the 90-day pause is the primary tool that we anticipate CCEF will deploy. However, as we've worked with CCEF and as we've worked through this proceeding, again, they would look to work with customers on a case-by-case basis, understanding that each customer's situation may be unique, and again, company nor CCEF want to see customers moving into disconnection because of falling behind on the finance debt. So yes, the primary tool will be the 90-day pause. However, CCEF is open to considering other options on a case-by-case basis.
Great. Does a customer, backing up, what's the company's current late fee policy?
I don't know. I mean, a late fee is assessed upon, I don't know the exact days, but a late fee is assessed upon non-payment of the energy service charge.
Do you know what amount the late fee penalty is?
I don't know that exact amount.
Okay. If we could pull up last hearing exhibit for me, hearing exhibit 904 in EOC's box folder. Mr. Murphy, this is from the company's website for what it charges for late fees. And do you see in the column for Colorado that the company assesses a late payment fee of 1% per month for residential customers?
I see that, yes.
Okay, great. Could I move for the admission of hearing exhibit 904, please?
Any objection?
And there's one other page, Mr. Mansell, if you
would
want
you
to check that
just
out.
scrolling through it if you wouldn't mind? And I'm sorry if you wouldn't mind back to the very top. I apologize. Yeah, no objections.
All right, so admitted. Thanks.
Thank you. So I just have a couple questions now about how the company's late fee policy might interact with the new OBF program. Can you elaborate whether the company or CSAF is proposing additional late fees associated with underpayments or non-payments of the OBF portion of the customer's bill?
Yeah, so in the event that the finance debt is not paid in full, is my understanding that CCEF would be applying a late payment fee to the customer.
So CSAF has its own late payment fee that it could assess separate from or in addition to the company's 1% late fee that it has already in place.
I believe that's accurate, but I think that they are looking to align those fees, is my understanding.
Align the fees with the company's current 1% late fee?
Correct. Correct.
Okay. So hypothetically, if a customer takes out a $50,000 loan, would that 1% late fee penalty kick in to create a possible $500 late fee for that month?
That is my understanding, yes.
Okay. And the company does believe it's appropriate for there to be this additional late fee as for the TOBF portion of the bill.
That is, yeah. In working with CCEF, that's what we've established. And they, the company agrees with that process.
Okay. Last set of questions for you, Mr. Murphy, and thank you everyone for your time and patience for this cross. If we could pull up attachment PJM5, which was a part of Mr. Murphy's rebuttal testimony. So Mr. Murphy, this is going to be the CCF bill payment flow chart that was a part of your rebuttal.
Give me 1 second. I'm just getting an error message on that.
No problem. I'm just happy not to be frozen, so I have all day.
Sorry, I have to grab it another way. Hold on.
No worries. And as we're waiting, I just have 2 more questions for you, Mr. Murphy, and then I'm wrapped up.
Sorry, I had to pull that from e-filings. It wasn't opening on the spreadsheet. Here it is.
Okay, great. If we could zoom in a little bit more but still we get the full chart. Great. So Mr. Murphy, this is the kind of a visual representation of the CCF. Well, I guess it's both the company's bill payment process for the energy portion of a customer's bill, but then below is the potential process for a customer on the TOBF portion of their bill. Is that accurate?
Correct.
Okay. Can you briefly describe what the remediation process is that's reflected in the purple diamond on this chart, about halfway down?
So
Maybe we can zoom
that,
in a little.
sure. So that is in the event that a customer has not paid the full portion of the finance debt on their monthly bill, CCEF, as we see here, would contact the participant. If they're able to make contact with the customer and get the account in good standing, then the process ends there, right? So if the customer is able to pay the full portion of the bill and get their account back in good standing, then the process ends there. If not, and the customer is experiencing financial hardship, then as we see below that, CCEF would then go into the, attempt to do the debt workout process with the customer.
Okay, I appreciate that. Thank you. I was a little confused by the chart. And then, so my last question is, what does the PMI stand for in that remediation process that you just described, where the customer would, be able to settle up and pay that obligation in full and go back to the regular monthly process?
I believe it's paid monthly installment, I believe.
Okay.
And I
Thank
think, and just to clarify one thing on the late fee, I believe you asked if the late fee would be applied to the entirety of the finance debt, and I don't think that's the case. I think the late fee would be applied to the payment, the monthly payment that the customer is responsible for, and not the entirety of the finance debt.
Okay, thank you. That is an important clarification. So it would be 1%. It'd be I guess you said CSEF's trying to align their late payment policies with the company on that 1% threshold.
That's my understanding. Yes. Yeah.
Okay, so it would be 1%, just to clarify. And last question, 1% of the monthly finance obligation and not the overall finance debt amount.
That is my understanding how it would work. Yes.
Great. Thank you so much, Mr. Murphy, for your time and patience. I have no further questions for this witness.
Fantastic. Thank you, Ms. Canelio. It's perfectly clear.
Yay. Thanks.
Okay. Let's see. Next up, we have sweep for 40 minutes.
Commissioner
Yep.
Plant. During the break, I did have a chance to discuss some cross waves with some of the other council.
Okay.
And if now's an okay time you'd like to hear about it, I'm happy to do so to allow the other council to excuse their witness if possible.
Sure.
Number one, I've got Denver's witness Vince Fugetta. The company is Waving Cross.
Okay.
Of Denver's witness, and I think we were the only one on the schedule that had a time reserved.
And I don't have any questions for Mr. Fugetta, so that witness is excused.
And also in regard to both of Clear's witnesses, the company discussed introducing a discovery response into the record through an agreement with Clear to avoid the need to do any cross-examination. And that hearing exhibit is in my box.com file as hearing exhibit 105. And so if we can enter into the record hearing exhibit 105, the company can waive both of its cross-examination times for both of Clear's witnesses.
Okay, and we'll leave it up here for a second for folks to take a look at, but if anybody has any objections to this being admitted into evidence, let me know. Okay, I think there is no objection. If no objection, then that will be entered into evidence.
Clear does not object.
Great, thank you.
Yeah, so we'll waive cross of both of Clear's witnesses, and at least for Clear's witness, Brissette, we were the only person with time reserved.
Okay, the clear witness Brissette is excused.
I would note that staff still has time reserved for Clear's witness Laird. And lastly, we will excuse EOC's witness Luke Ilderton. And we're the only one that time reserved for EOC's witness.
Commissioner Plant, you are muted right now.
Sorry about that. I may wait to excuse EOC's witness. It's possible that I may have a question.
Sounds good. Thank you.
You bet.
And that's all of our excusals for now.
All right, great. Ms. Stockmeyer.
Thank you, Commissioner. We also have an update from the city of Boulder. Boulder is willing to waive the cross that it had reserved for company witness Berman, 15 minutes.
Okay, Boulder 15. Okay, thank you. And Ms. Crampton.
Thank you. UCA had reserved time for Boulder witness Miss Elam. We will waive that cross. And likewise, we'd reserve time for CEO witness Mr. K. We will waive that cross as well.
Okay. Noted. And Mr. Barroso.
Yes, thank you, Commissioner. WA will be waiving our reserved cross time for both UCA witnesses, Fernandez and Kuykendall.
Okay. I didn't have you down for Kuykendall. Oh, no, wait a minute. I see it. Okay, sorry about that. All right. Anyone else? Okay. I think we're up to date. Now, sweet. You're ready to go. Go for it.
Thank you, Commissioner Plant. So good afternoon, Mr. Murphy. My name is Michael Hyatt. I'll be asking you questions today on behalf of SWEEP. So I plan to have 4 topics to discuss with you, but I think I'm down now to about 1.5 topics based on what's been covered earlier. As Ms. Judkins and Clear covered the issue of the overall side of the financing program I plan to discuss with you. And Ms. Stockmeyer and Boulder covered the issues of gas-only customer participation. So what I do want to do is pick up with the discussion you had this morning with Ms. Stockmeyer about the subordination of debt. So to quickly just set the stage here again for this discussion, company proposes that the loan repayment on a customer's bill would be subordinate to the monthly utility charges in the bill, correct?
That's correct.
And would you agree that this subordination issue is primarily about whether the company or CSEF will bear a greater risk of non-payment from the customers that participate in the program?
The position of the debt being subordinated to the utility charge is the company reducing its risk of accumulating bad debt that will impact all customers, but also reflects the essentials, the essential nature of utility service, rather than a voluntary financing program.
And by reducing that risk to the company, doesn't that mean that the subordination shifts more of that non-payment risk to CSEF?
It does, yes.
And you're aware, aren't you, that SWEEP proposes the opposite scenario where the utility charges would be subordinate to the loan repayments?
Yes.
And in that scenario where the utility charges are subordinate to the loan repayments, the company would then bear a greater risk of non-payment than CSEF. Is that right?
The company would, and all of our customers would bear greater risk as well.
Okay, we're going to talk about that. So it's going to focus first on that issue and the kind of company side of this issue, of which party will bear a greater risk of non-payment. So as you explain your rebuttal testimony, and I think you just hinted at now, the company opposes SWEEP's proposal because it would increase the risk that public service incurs higher levels of bad debt. Is that right?
That's correct.
And that means that if the company faces a higher risk of bad debt, it could lead to higher costs for non-participating customers through future rate cases. Is that right?
That's correct. And there is also the potential to impact things like credit scores.
All right, so I'd like to talk briefly then about how many customers may actually participate in this financing program and how this impacts this non-payment risk. So as you've established this morning, the company is proposing to make $25 million in financing available through the program over 3 years, correct?
Correct.
And you've also testified, I think, earlier this morning that the company has not quantified how many customers will likely participate in this $25 million financing program. That's right, correct?
That's correct. Yeah, we have, at this time, we do not know what participation and customer uptake will look like in the on-bill financing program.
And so the highest amount that each customer could borrow from CSEF would be $50,000, right?
That's what we've proposed in our rebuttal case.
And Ms. Stockmeyer saved most of the math I was going to have to do with you, so to make my job easier. But if each customer borrowed, say, that full $50,000, CSEF could provide 500 loans with that $25 million in capital. Is that right?
I believe that's the math that Ms. Stockmeyer reviewed with me earlier as well.
Yeah. So one question, the very, very similar math, but to kind of follow up, as an example, maybe on the other side of that spectrum. If each customer borrowed only $5,000, say, through the program, then that $25 million in capital could provide loans for approximately 5,000 customers then, right?
Correct.
So as a rough estimate, the maximum number of customers that could participate in the program over this 3-year period would likely be somewhere between 500 customers on the low end to approximately 5,000 customers or so on the high end. Would you agree?
I believe we proposed a minimum level of financing of 1,500. So I think that would increase the number of potential participants.
Okay, so the company expects then that most of these 500 to 5,000 plus, can we just agree for that for this discussion?
Absolutely, sure.
Okay, so the company expects most of these 500 to 5,000 or more participating customers would in fact fully repay their monthly bill and their loan repayments, correct?
I'm sorry, can you repeat that, Mr. Hyde?
Company expects that most participating customers would in fact fully repay their loan repayments and fully pay their monthly utility bill, right?
Yes, I think we would expect that most customers taking part in the program would aim to do so, but we can't say with any certainty that that will happen.
All right, so this morning you discussed also with Ms. Stockmeyer how in other jurisdictions that have financing programs, at least there, less than 1% of those participating customers had defaulted on their loans. Do you generally recall that discussion?
I do, and as I brought up with Ms. Stockmeyer, I wasn't clear whether all of those programs were the PAYS model, and in that instance, I think it would make sense that you would see a low default rate since the savings achieved would tend to lower the utility bill for the customers participating.
Okay. So if we have here approximately 500 to 5,000 plus customers participate in public services program, and if say approximately 1% of those customers do not pay their bills, then we're looking at about 50 customers, maybe 60, 70 customers or so, or less, who would actually be failing to pay their full bills, correct?
In that example, that's correct. However, having not implemented this program yet, we do not know what the actual rate of default will be. And the company does not see it as appropriate to potentially expose the rest of our customers to bad debt on our balance sheet, which will cause increased costs for those non-participating and participating customers.
So as far as those other customers, company has approximately 1.5 million electric customers, doesn't it?
That's correct, yes.
And do you know off the top of your head how many of those 1.5 million electric customers fall behind on their monthly bills in an average year?
I do not.
But the company is concerned here that if some proportion, as to say, of the 500 to 5,000 plus customers who participate do not pay their bills, that bad debt expense would substantially increase costs for the other $1.5 million customers. That's your core concern, right?
That is a concern of ours, and that I would also say that, the 25 million is for the first 3 years of the first 3-year term of this program. The company does not know what participation in this initial term will look like, and the company does not know how this program will continue to evolve and potentially grow, increasing that risk over time.
Okay, let's talk now about the CSEF side of this issue regarding which party is going to bear greater risk of non-payments. So just to level set here, under the company's subordination proposal, CSEF is a party that's going to face that greater risk of bad debts, correct?
CSEF would be the one incurring that bad debt, correct?
And you testified earlier this morning with Ms. Stockmeyer that the company does not know if CSEF would lower the interest rate it charges to customers if the loan repayments were not subordinate to the utility charges. Do you recall that statement?
Yes.
Okay. If we could please now pull up here in Exhibit 103, which is Mr. Murphy's rebuttal testimony. If we could go to page 21, please. Thank you. If you could scroll down the Q&A at the bottom of this page, Mr. Murphy, can you see that you discuss here your concerns with SWEEP's proposal for reversing the subordination of debt? Do you see that?
There's beginning on line 13. Is that where you're talking about, Mr. Hyatt?
Yes.
Okay. I'm just reading that now.
Yeah, take your time, please.
Yes, I see that.
All right, if we can scroll down to the next page as we see the rest of this answer. Let's look now and focus at the last sentence of this answer, which begins on line 8. You with me there?
Yes.
So in this sentence, don't you state that, quote, additionally, it is important to reaffirm that CSEF's offered interest rates have priced in the risk it assesses associated with the finance debt being in the subordinated position. Did I read that correctly?
Yes, you did. And I would just say that that is a portion of the interest rate. However, we just haven't had that conversation with CSEF, what the impact to the interest rate, if any, would occur if that subordination was reversed.
Appreciate that. Based on this statement, if subordination was reversed, CSEF then should offer lower interest rates to customers, shouldn't it? Because that risk it had priced into the 5 to 5.99% interest rates, that would be reduced, right?
I suppose that's a reasonable assumption. We just don't know what that impact would be.
Okay. We can take down this exhibit. I'm going to move on to my last topic or half topic here, which you've also discussed at length this morning, which is interest rates and origination fees. So before the company filed its application here, it convened a stakeholder group to study on-bill financing. Are you aware of that?
Yes, I was leading those stakeholder groups.
And are you aware then that in 2021, a group of 9 different local governments and other organizations submitted recommendations to public service for an on-bill financing program as part of that stakeholder process?
Sorry, to correct my prior or clarify my prior statement, I was speaking about the 2 engagements that we agreed to prior to making this filing in our DSM and beneficial electrification plan, which were conducted over the fall of last year. To clarify, I was not involved in the prior 2021 stakeholder engagement efforts.
Thank you. Appreciate that clarification. Sorry for
But
ambiguity.
but I am aware that those stakeholder efforts were conducted.
Okay. And are you aware of the report that some of those participants provided to public service with recommendations back in 2021?
I'm generally aware.
Okay. And Mr. Alatorre with SWEEP attached those recommendations to his answer testimony. So did you review that attachment, or have you ever reviewed those actual recommendations?
I reviewed Mr. Alatorre's attachment, yes.
Okay. So you're aware then, aren't you, that the working group recommended that the financing program have low zero interest rates to maximize program impact and enhance affordability for participating customers? You recall that?
Yes, but I don't know that if I'm recalling correctly, the recommendations were sent to the company by a coalition of stakeholders. That was not the company's recommendation.
Yes, important clarification. That was comments to the company.
Correct.
Okay.
Yes.
And as you noted in your testimony, and the commission's decision and the 2022 strategic issues proceeding, the commission expressed support for on-bill financing as a cost-effective way to reduce barriers to DSM participation. Is that right?
That's correct.
And are you aware that in that same decision, the commission also stated its preference that an on-bill financing program should have zero or very low interest rates for IQ and DI customers?
Can we bring that decision up?
Sure. This is attachment or hearing exhibit, 501 in sweeps box. Mr. Murphy, if you want to just quickly review the date and title here to orient yourself to what this decision is. Do you see that this is the commission decision you referenced in your testimony from the strategic issues proceeding?
I do.
All right. If we could go now to page 69 and paragraph 169. It's a short paragraph, so let me know. Take a time to review it. Let me know you're done.
Great. Thank you. I've reviewed.
Okay. So as you can see in this paragraph, back in that strategic issues decision, didn't the commission state that it has a preference that an on-bill financing program should have zero or very low interest rates for IQ and DI customers?
I do see that was the commission's preference at that time.
But in this case, company is proposing that customers would pay interest rates ranging from 5% to 5.99%, correct?
Correct. Those are the rates that our third-party capital provider, CCEF, has brought forward. And again, the company's position is that it would prefer to work with income qualified customers to take part in our rebate offerings, where for the most part, the full cost of these measures are accounted for, rather than going through an on-bill financing program where customers who may already be experiencing difficulties paying bills are taking on additional debt.
Okay. So in addition to that interest rate, customers would also have to pay a 2% origination fee that would be included in the monthly loan payments. Is that correct?
That's correct.
So when the company filed this case, it decided to not follow those recommendations we just discussed from that stakeholder group and the commission, calling for zero or very low interest rates, did it?
It did not propose what the commission has stated it prefers here. We don't see this as a directive to the company to provide such rates. However, in the time since this decision has come out and to now, I think things have dramatically changed where we have rebates in market that aim to pay the full cost of measures, especially those that have been enhanced using clean heat funding. So in my opinion, things have changed somewhat dramatically from a rebate availability perspective.
So you're aware, aren't you, that Sweep, Boulder, and other parties recommended the company buy down the proposed interest rates in this case, right?
I'm aware of that, and the company does not support that.
And you've reviewed Mr. Alatore's testimony in this case on buying down interest rates.
I have.
So do you recall his testimony showed that for the company's proposed $25 million program, it will cost between $1.9 to $6.8 million to buy down the interest rates to 0%? Do you recall that?
That sounds, I don't remember the exact figures, but that sounds generally what I recall. Again, though, the company has not proposed that and has not put forward any specific budgets to do what Mr. Alatore has suggested.
Okay. And in your rebuttal testimony, you didn't dispute this conclusion that it would cost between $1.9 to $6.8 million to buy down interest rates to 0, did you?
We did not specifically dispute that, but again, as I discussed with CEO's attorney, we did make a statement in my testimony that among all the recommendations that have been provided to the company in this proceeding, if they're not directly addressed in my rebuttal testimony, the company does not agree.
So were you aware before the company filed this case that it had $21.6 million in unused clean heat plan budget for the year 2024?
I'm not. Can you bring up a table showing that budget? I'm not sure of the exact amount.
Sure. I think it's probably easiest to bring up here in Exhibit 500, which is Mr. Alatore's answer testimony. Thank you. Let's go to page 24. If we go down to lines 14 and 16. I guess so, Mr. Murphy, can you see here Mr. Alatore's testimony that the company stated in the Mountain Energy proceeding that it has $21.6 million of unused 2024 Clean Heat Plan Vertical 1 budget? Do you see that?
I believe that says that the company is proposing to repurpose 21.6 million of the unused 2024 Clean Heat Plan Vertical 1 budget. And I will say that I'm not a witness in that proceeding, so I can't really speak to the specifics of Mountain Energy.
Understood. So I get the question for you is when the company filed this case, was it aware that it had this unused Clean Heat Plan budget for 2024?
Yeah, I mean, the company was aware that, due to the timing of the decisions in both clean heat and our DSM and beneficial electrification plan and the launch of the combined plans or augmented rebates on January 1 of 2025, that there were dollars that the commission approved in 2024 that, were not spent.
So the company could conceivably have used $1.9 to $6.8 million of that $21 million unused clean heat plan budget to buy down interest rates to 0%. It could have done that, correct?
The company did not consider such an approach. We think it's reasonable to provide the below market rates that we've proposed here, and we have not proposed to buy down any level of interest rates using any funding source the company may or may not have access to.
Okay. Instead of proposing to do that, in fact, the company proposed to use $21 million of those unused clean heat plan funds to help fund the Mountain Energy project. You are aware of that, right?
That is what the statement says here. Again, I'm not a witness in that proceeding, so I don't really want to speak to the specifics of that proceeding.
Okay, and I'm not going to ask you specifics, so I think we're good there. Let's please pull up here in Exhibit 103 again, which is Mr. Murphy's rebuttal testimony. Thank you. Let's go to page 30. So if we scroll down at the bottom of this page, can you see that you explain here that the company opposes SWEEP's proposal to buy down interest rates using that unused 2024 clean heat budget because the company, in fact, already requested to use that unused budget in the Mountain Energy proceeding?
I
See
do.
that?
Yes.
And on the next page on line 1, you stated that company cannot support proposals that would overcommit funding from unused 2024 Clean Heat Plan budget amounts. And it expects the Mountain Energy project proceeding to substantially address available funding issues from the Clean Heat Plan. Did I read that correctly?
Yes.
So, Mr. Murphy, it sounds to me like the company is understandably reluctant to support any proposals in this case that would result in the company essentially double counting how it would use those unspent clean heat funds. Would you agree?
I think that's accurate. And again, that, this proposal was made in the Mountain Energy project. We have not proposed to use any clean heat funding to buy down interest rates in this immediate proceeding.
Yeah, and with that understanding, and also the sense that the company is not opposed as a matter of principle to using the unspent clean heat funds on the financing program, it just cannot do so because I already proposed to use those funds elsewhere. Would you agree with that?
The company has not considered using such funds to support this program. And I would point out that, we are proposing to use some electric or support electric energy efficiency measures in this program, which is not a clean heat resource.
I know you are not participating in the Mount Energy project proceeding, but are you generally aware it's currently pending that proceeding for the commission?
Yes, I know that the proceeding is ongoing.
And are you generally aware that it's on a similar procedural schedule to this case with an evidentiary hearing scheduled for next month? Did you know that?
I believe that's correct, yes.
So while the company does not support allocating the unused clean heat funds to the financing program, commission would have the ability in these two pending cases to make a decision for itself on how to best allocate those unused clean heat funds between the financing program and the Mount Energy project. Has that ability, doesn't it?
I have to object. One, it's speculation. There's also legal conclusion involved. I think most importantly, we're really starting to wade into commission decision-making into an open commission litigation that I would request that we try to stay as far away from as possible.
Thank you, Mr. Mitchell. Yeah, if you could avoid talking about a specific proceeding, I don't see any problem with getting the witness to opine on various possibilities.
Okay. So Mr. Murphy, in this proceeding, this financing program proceeding, commission could, if it wished, order public service to use some of those unspent clean heat funds to help buy down interest rates, couldn't it?
I suppose that's a possibility, but again, the company has not put forward such a proposal and does not support such a proposal.
Okay, thank you, Mr. Murphy. That is all the questions I have for you. Mr. Commissioner Blank, just on the issue of waiving witnesses and cross, given that question and answer, I sweep will waive the cross at reserve for company witness Berman.
All right, thank you, Mr. Hyatt. We will note that. Let's see, who do we have next? WRA, Mr. Barroso. You have 20 minutes.
Thank you, Commissioner Plant. All of my questions have been asked by counsel that's come before me, and so we will be waiving our cross of Mr. Murphy. And while I'm here, we will also be waiving our cross of Mr. Berman.
Okay. Well, that was quick.
Thank you.
All right. Next up, I'm sorry.
I'm sorry, Commissioner. I would note that all of the cross reservations have now been waived on my matrix for Mr. Berman. So I think it's now just up to you to decide whether you'd like to excuse him or not.
Not ready to excuse him yet, but thank you.
Thank you.
Ms. Crampton, UCA, we have you for 60 minutes.
Thank you. I expect this will take significantly less time based on the discussion we've already had today. Good afternoon, Mr. Murphy. My name is Kate Crampton. I'm an attorney at the Attorney General's office representing UCA. I don't think we've met before, but nice to see you this afternoon.
Afternoon.
I don't think this has been asked, Mr. Murphy, but is it fair to say you're the lead witness for public service in this proceeding?
I think that's fair. Yeah, I was the only witness that provided direct testimony in this proceeding.
Okay. And in your role as a lead witness, have you read and reviewed all of the answer testimonies of interveners and reviewed their attachments?
I have read all of the answer testimony. I will say that there's probably one or two attachments that I have not read in full.
Okay. And is it fair to say that you reviewed all these answer testimonies and attachments in order to prepare your rebuttal testimony?
Yes, and to prepare for this hearing today.
Great, thank you. I want to pick up some of the conversation around disconnections that we've had today. And you noted in your rebuttal testimony that there are several parties to this proceeding that were seeking clarification of the contemplated disconnection process. Is that fair to say?
Yes, that's fair.
And then there were some parties like Boulder, Sweep, and UCA that altogether oppose the use of a disconnection policy in order to address non-payment of the finance debt, correct?
I believe that's accurate, yes.
And in your testimonies, in both direct and rebuttal testimony, you indicated that the company believes that disconnection for participant non-payment is an important piece of the OBF offering, correct?
It is. We see it as a necessary tool to incentivize customers to pay their finance debt. It also has been incorporated into the interest rates that CCEF is able to provide in this proceeding as well. So it's a pretty key factor in that.
Okay. And you said necessary tool. If we could pull up hearing exhibit 101 at page 21, please. And I'm sorry if we could scroll down. And I guess really it's the bottom of page 21 and page 22. But Mr. Murphy, I'm showing you your direct testimony, and I know you just stated that you view disconnection as a necessary tool. And is it fair to say you view it as a necessary tool because you believe that essentially the threat of disconnection can be a tool to lower the customer defaults? Is that right?
Yes, I think that's right. And as we've continued to work after filing this direct testimony, and as we continue to work with CCEF, it became very clear to us that this tool provides CCEF with the necessary comfort that they have that the debt is not unsecured. And this provides them that level of comfort and is then incorporated into the rates that they're able to put forward.
Okay, and that's maybe what you went on to say in the testimony, where you say lowering such defaults could support the ability of the capital provider to focus its resources.
Is that, yes, sorry, thank you. Yep.
Okay. And so the company views disconnections as a lever it can use to lower defaults and allow CCEF to focus its resources.
It's one of the tools, right? I think I've talked extensively today about the debt workout process that CCEF is also has developed and is willing to engage customers with in the event that they get behind on their finance debt. We're looking to provide an additional option for them to find avenues to hopefully get their account back in good standing and not go into the formal disconnection process.
Okay. And Mr. Murphy, you indicated that you've read the answer testimonies. You read the answer testimony of UCA witness, Mr. Kirkendall, correct?
Correct.
Okay. And in answer testimony, Mr. Kirkendall noted a study out of Connecticut that found that on-bill financing programs that had the highest default or delinquency rates were those on-bill loan programs that had disconnection policies, as opposed to other types of energy efficiency loans. Is that correct?
Can we bring the testimony up? Just
Sure, if it's helpful.
Thanks.
Hearing exhibit, if we could pull up hearing exhibit 301. And page 14. And if we could just scroll down to lines 13 through 24, or really 10 through 24. And Mr. Murphy, let me know when you've had a chance to refresh your recollection.
Thank you. I've read that.
Okay. And you agree this is part of Mr. Kirkendall's testimony where he cited to this study from Connecticut that noted that the programs with the highest default rate was programs involving termination authority, correct?
Correct.
Did you have an opportunity to review that study that Mr. Kirkendall cited to in his testimony prior to you testifying here today?
I have not. There was a study attached to Mr. Kirkendall's. I think that's a different study, so I don't believe I've reviewed this specific study.
Okay. And I think maybe you're referring to the National Consumer Law Center study.
Yes, that's correct. Thank
We're
you.
going to get to that as well. But with respect to this Connecticut one, it sounds like you haven't had a chance to look at it.
I have not had the opportunity to review that study.
Okay. And in your rebuttal testimony, you did not dispute the findings of this Connecticut study.
We did not, but as I stated before, we had a lot of recommendations put to us in answer testimony, and those that we did not address, the company generally does not agree with.
So just sort of the absence of any evidence to the contrary is meant to support that position? Is that your testimony here?
Objection. Calls for a legal analysis conclusion. Mr. Patrick Murphy is not an attorney. He's not testifying to what evidence is or is not.
Can you rephrase, Ms. Campton?
Sure, and I can move on. Mr. Murphy, the company in its rebuttal testimony did not provide any information to demonstrate that on-bill financing programs that have a disconnection policy as proposed here actually have the intended effect of lowering customer defaults of their repayment obligations, correct?
We did not address that directly in my rebuttal testimony, but further emphasize the need for such a tool to support this program and to support our third-party capital provider in implementing this program and administering this program.
Okay. But no study that you attached to support that, correct?
I did not attach any study addressing this to my testimony.
Okay. If we could pull up and Mr. Murphy, we're going to turn to that National Consumer Law Center report. If we could pull up hearing exhibit 301 attachment KK11, please. Thank you. And Mr. Murphy, this is the this is the report you did have a chance to review prior to testifying here today, correct?
That's correct, yes.
And this is a report from the National Consumer Law Center discussing on-bill financing programs, in particular the risks for low-income consumers. Is that right?
That's correct.
Okay. And if we could scroll to page 2 of that report, please. And if maybe just scroll down the page just a little bit. That's great. Thank you. And Mr. Murphy, you agree and you had a chance to review that what the National Consumer Law Center has identified as a risk for low-income consumers with respect to on-bill financing programs are programs that have a reliance on service disconnection, like the one proposed here, correct?
That is one of the bullets there, yes.
Okay. And what they concluded is that these programs rely on the threat of service disconnection, which significantly reduces the risk for the capital provider while failing to adequately shield consumers from the risk of service disconnection, correct?
That's what that sentence says, correct.
And in your rebuttal testimony, you did not dispute these claims of or conclusions of the National Consumer Law Center, correct?
We did not. I did not.
You did not, and no other witness for the company disputed these claims. Okay.
Correct, correct.
If the commission is to approve the proposal of the company that includes disconnections, how does the company intend to measure the defaults that result in disconnections from the OBF program?
I think we will track those disconnections the same as others, but the company will certainly track those that are associated with the on-bill financing program as well.
And if defaults that result in disconnection for non-payment of their on-bill financing obligations go up, as the studies cited by UCA suggest could happen, will the company consider the OBF program to be a success?
Company does not want to disconnect customers for non-payment of its finance debt, and we've put some level of protections in place through the debt workout process with CCEF. We will monitor and track any such occurrences and determine, have the ability to determine appropriate ways to potentially address such defaults.
Okay, I appreciate that. That wasn't quite my question. If defaults resulting in disconnection go up, will the company consider the OBF program to be a success?
I think we'll have concerns if we see, disconnections go up specifically because of this on-bill financing program. So it would cause concern for the company.
Okay, thank you. And we can take this exhibit down. Thank you. Mr. Murphy, in your rebuttal testimony, several interveners, several parties noted the lack of risk that the company carries with respect to this OBF proposal. Do you recall those claims made by interveners?
I remember some of those claims, yes.
Okay. And you specifically noted that staff, City of Denver, and UCA all raised these concerns about the lack of risk for the company, correct?
I believe that's accurate, yes. I don't know that the company agrees with those positions, but yeah, they've been raised.
Okay, and some of the concerns raised by the interveners was the obligations that non-participants would have if they are essentially obligated to pay for program activities through the DSMCA, correct?
Specifically, the administrative costs that we've put forward, is that what you're referring to?
That's what the company proposed, but the concern was essentially the obligation this places on non-participants to pay through the DSMCA the administrative costs, correct?
Yeah, yes, and the company has designed this program to limit the impacts to non-participating customers to the fullest extent possible. However, like with any program we offer, there are administrative costs that are associated with implementing that program. And so, yes, the company has proposed to collect those costs through the DSMCA.
Okay. And I think you've kind of anticipated maybe where I'm going, but the company did scale back some of those administrative cost requests in rebuttal, correct?
Well, they're spread out. What we initially proposed was an incremental budget ask of approximately $700,000 on top of our existing 24 to 26 DSM and VE plan budget. Through ongoing work with CCEF, we've been able to establish a process where what was going to be a one-time $700,000 cost to CCEF to help assist them in standing up their program on their side, that'll be spread out over the 3-year initial term of the program.
Okay. And so I think you've kind of touched on this, but essentially there are remaining administrative costs that non-participants will effectively pay for through the DSMCA under the company.
Yeah, correct. There's that cost that I just discussed, the payment to CCEF. There is also the cost to set up the necessary IT to be able to actually implement this program. And then similar to other programs that the company offers, there's some level of ongoing administrative costs for, program implementation on the company's side.
Okay. And the concern with this by some interveners like UCA was that this assigns costs to non-participants in the program, correct?
Correct, but this is not an unusual occurrence. We have many programs that the company offers, and there are costs associated with administering those programs, and not all of our customers are taking part in those programs.
In terms of the company's risk, you alluded to this, but you disagree with that characterization that the company carries no risk, correct?
Correct.
And I think what you noted in your testimony is that the company has the risk of administering the program.
Could we bring up where I discussed this in my rebuttal testimony?
I'm not sure that I have that citation handy, so let me just move on. One of the things you discussed was the risk of essentially ill will for potential customer disconnections, correct?
Yes, there's reputational risk, there's customer satisfaction risk, there's the risk of using budget to support this program that may have otherwise gone to support beneficial electrification or energy efficiency projects that the company may be able to count towards its performance incentive mechanism as well.
Okay. And you had the opportunity to review the answer testimony of Mr. Alatorre from SWEEP.
Correct, yes.
And in Mr. Alatorre's testimony, he discusses some programs in other states. Do you recall that part of his testimony?
I remember the discussion. I can't say that I remember the specifics of it right here.
And do you recall Mr. Alatorre's discussion of the Massachusetts program, which essentially removes the utility from the equation for their essentially energy efficiency financing program?
I do not remember the specifics of that portion of testimony.
Okay. I want to talk about, we've talked about risk to consumers, risk to the company. I want to talk about risk to CCEF. And I know that you're not a CCEF witness and we're not going to get a CCEF witness, but I'm going to ask you some questions that hopefully you can answer to the best of your ability. I think you testified with staff that this is the first time that the company has worked with CCEF to provide the capital for a program. Is that correct?
I believe that's accurate. Yes, I think this is our first engagement with CCEF.
Okay. And CCEF is a 501c3 nonprofit green bank, correct?
That's my understanding, yes.
Okay. And I think you went through this a little bit with Ms. McLaughlin from staff, but it's your understanding that CCEF was essentially created by legislation, correct?
I don't think I did go into this with Ms. McLaughlin. Subject to check. I'm not entirely clear of the creation of CCEF.
Okay. It's your understanding that CCEF was funded through funds from Senate Bill 21230, correct?
Correct. Yeah, they received grant funding through that.
Okay. And if we could take administrative notice of Senate Bill 21230, please. I hear no objection, but.
Sorry,
Needed to say-
any objection? No objection, it's so admitted.
Okay. And it's your understanding, Mr. Murphy, that CCEF received essentially an infusion of funding from that Senate Bill 21230, correct?
Yeah, it's my understanding that they received grant funding that became available through that legislation.
Okay. And it's some of that funding that they intend to use for the capital in this proposed project.
They have recycled that funding and grown their balance sheet and now are able to support an initial launch of $10 million and then up to $25 million.
And because CCF received this essentially infusion or grant funding, CCF did not have to raise this capital, correct?
That portion of the capital, I think that's accurate.
And under the proposal, as we understand it, CCF is poised to earn a profit at that 5 to 5.99% interest rate, correct?
I don't know that that is all profit. I think that some of that interest rate pays for ongoing administration of their program as well. So I'm not sure what portion of that is actual profit for CCEF.
Hard to say as you sit here as a witness not from CCEF.
I don't know the specifics of CCEF's business model.
Okay. And you don't know if that proposed interest rate is tied to any borrowing rate of CCEF, correct?
I do not know that.
Okay. One of the things that came up in your discussion with Council for Boulder is that a lower interest rate could potentially foster consumer interest in this program, correct?
Yes, we had that discussion, yes.
Okay. And you don't know whether CCF could offer a lower interest rate to potentially foster increased interest, correct?
CCEF has put forward the interest rates that I've reflected in my testimony, and I believe one of UCA's witnesses was very supportive of the interest rates.
That was not my question, Mr. Murphy. My question is, you don't know whether CCF could offer a lower interest rate.
We have no knowledge that they could offer a lower interest rate. We have the interest rates that they've proposed.
Okay. Or whether if they offered a lower interest rate, that could potentially result in fewer defaults and disconnections.
Potentially.
One of the I want to shift gears here a little bit. Thank you. In your rebuttal testimony, you noted that one of the critiques from UCA was that the application in this proceeding appeared to UCA to be premature, correct?
Yes.
And part of UCA's critique or recommendation that the application was premature was the lack of a contract finalized with CCF, correct?
I believe that's accurate. Yes.
And part of the critique that UCA made, or the concern raised by UCA, was the background and context in which this application was filed, and specifically the timing of this application. Do you recall that?
Not specifically. Can we take a look at that testimony?
Sure. If we could, if that would be helpful, if we could pull up hearing exhibit 301 at page 9, please. And apologies, if we could maybe scroll to the bottom of page 8, top of page 9, I think that will be more helpful for Mr. Murphy.
Thank you.
Okay. And UCA noted that the company did not submit its request, its RFP, until about 2 months before the filing deadline, correct?
That's correct. And we had to do our stakeholder engagement that we agreed to in the DSM and B plan settlement agreement. If I recall correctly, we waited until final approval of that plan before issuing our RFP, and that did not occur until November of 2024.
Yeah, and I think you had said earlier in discussion with another council, I don't remember who, that essentially the company had about 60 days to pull this application together. Is that right?
That was the term agreed to in the settlement agreement in our DSM and BE plan.
Okay. And as UCA noted, the RFP was only held open for 25 days, correct?
It was held open for 25 days, yeah.
And there was only one bid that the company received, which is the bid from CCEF.
Correct. But we were happy to receive a bid from CCEF since they have experience implementing these programs elsewhere.
Okay. And we can take down this exhibit. And actually, that's a nice segue you've provided, Mr. Murphy. You said CCEF has experience with this type of program elsewhere, and specifically with Tri-State, correct?
Correct.
And in the course of this proceeding and discovery, you were asked to provide information about any similarities between the Tri-State OBF program and the company's proposed OBF program here. Do you recall being asked about that in discovery?
I recall being asked about it. I can't say that I remember the exact response.
Sure. And if we could pull up hearing exhibit 301 attachment KK8. And if we could just scroll, I think this is a 2-page response. And Mr. Murphy, do you see you're the sponsor of this response?
I do.
Okay. And if we could just scroll back up here, just to the top, please. Thank you. Mr. Murphy, this was a discovery response or a discovery question posed by WRA regarding what information the company has about Tri-State's OBF program. Is that right?
That's correct.
And here the company stated that it does not have any insights into the performance. I'm sorry, I'm looking at the response A through D. You stated that the company does not have any insights into the performance of the Tri-State OBF program, correct?
Specific to these requests in subparts A through D.
Okay. And so kind of breaking those down, as you testify here today, the company doesn't have any information about the number of loans expected to be issued under the Tri-State program, correct?
Or similarities that, yeah, that is correct, or any similarities in that public services program may have in the future.
Okay. And you don't, as you stated, have any insights into the performance of the Tri-State program, correct?
That's correct.
And that the information that the company does have is just information that's publicly available on Tri-State's website, correct?
I believe that's accurate, yes.
And this is the other program that CCEF administers here in Colorado.
Correct.
This discovery response, if we can scroll back down, this was dated April 17th of 2025. Is that right?
Yes.
Since this discovery response was provided on April 17th, has the company met with Tri-State to gain any insights about their performance of their OBF program?
Not to my knowledge.
And so if the commission is to approve the OBF program as proposed here today, they would do so without the benefits of insights from the performance of the Tri-State OBF program, correct?
Yes, I think that's accurate. I don't know if the commission needs that information. We're proposing a program for public service customers. I don't know why they need more information around Tri-State's programming.
But as it stands here today, they would not have the benefit of that information in making the decision.
That's correct.
Kind of on this idea of things we don't yet know. One of the things that UCA also noted in their testimony was that there is not a cost effectiveness evaluation of the proposed on-bill financing program, correct?
Correct. And I believe I discussed this with staff's attorney. The company is proposing to support permanent DSM and BE measures that have been fully vetted and approved by this commission in its 24 to 26 DSM plan. And the costs that are associated, or the company's costs for this program, are administrative by nature, and we just don't see any reason to believe that this would not be a cost-effective program. The capital is coming from a third-party capital provider.
Okay. And you once again are kind of guiding me into the next question, which is you responded in your rebuttal testimony that this type of program is not maybe particularly well suited for a cost benefit analysis because there are not standalone savings in the program, correct?
Correct.
But you do acknowledge that an individual savings tool that considers the effectiveness of the installed measures for individual discussion or individual customers is something that merits further exploration, correct?
The company is not opposed to exploring a tool such as a bill savings tool that could be made available to customers. But as noted in my rebuttal testimony, We have not explored that option at this point, so we do not know things like, estimated costs, feasibility, or timing in such a tool.
Okay. And if we could pull up hearing exhibit 301 attachment KK11 once again, please. And if we could, I think it's the next page, please. And I'm sorry, if you could, page 4, if we could scroll to page 4, please. I'm sorry. And Mr. Murphy, I'm showing you again that National Consumer Law Center report that you reviewed. And I appreciate your comments just now that exploring this bill savings, exploring individual customer bill savings is something that the company thinks has merit. That belief of the company is sort of consistent with the recommendations of the National Consumer Law Center, that the opportunity essentially to save should be something that's explored in order to protect low-income consumers, correct?
That is what this paper has put forward. The company is supportive of providing a tool so that customers may be able to see if, in fact, they may achieve bill savings. However, it's important to note that we haven't put forward like a specific pay-as-you-save model type program.
Okay. And you haven't proposed pay-as-you-save and not even requiring that as sort of a threshold for implementation of the program. There's just not a bill savings evaluation under the company's current proposal, correct?
We have not put forward a pay-as-you-save proposal. That's right.
And so if the commission approves the OBF program as proposed, they would do so without the benefit of an understanding of whether there are individual cost savings or bill neutrality for any individual participating customers, correct?
Yes, we haven't put forward a requirement of bill neutrality or, again, a pay-as-you-save model.
Okay. Another thing that sort of remains unknown as we sit here today, and you've touched on this a little bit, so I'll move through this quickly. But the company has not completed an evaluation of customer interest in an on-bill financing program, correct?
Yeah, I think I've responded to several questions around this. We have not conducted any surveys or anything of that nature, if that's what you're referring to.
Okay, and so if the commission approves the on-bill financing program as proposed, they would do so without the benefit of understanding whether there is customer interest in this program, correct?
That's correct. And the company has brought forward this program first to comply with our settlement term in the DSM and Beneficial Electrification Plan settlement agreement. However, we have also heard from the commission and from stakeholders a desire for such a program to be made available for our customers.
Thank you, Mr. Murphy. I know you've talked a lot about the contract and the sort of lack of access to the contract for everyone else except for you, essentially, at this hearing. But you noted in your rebuttal testimony that, in your opinion, it's common, essentially, for this contract to not be finalized prior to the resolution of the case, correct?
I think that's accurate, yes.
Or prior to the commission issuing an order?
Yes. However, in this instance, and I aim to be more efficient, the company has been working towards finalizing this contract while also litigating this proceeding and expect to finalize that contract with CCF in the in the coming months.
And I think you noted that there are other scenarios where the vendor contract isn't complete until after a final commission decision, correct?
That's correct.
In those scenarios, did the contract between the company and the third-party vendor include terms that would dictate disconnection for customers?
I cannot state with any accuracy whether we have any offerings out there that have contract terms that speak specifically to that outside of what we've proposed here.
Okay. And if the commission is to sort of accept this trajectory of not having a finalized contract, and approve the on-bill financing program proposed here today, the commission would do so without the benefit of reviewing the contract between CCF and Public Service, including those terms of the contract that could lead to customer disconnections, correct?
Yes, we are not proposing to file with the commission or provide review of our contract with the commission or any parties to this proceeding. We think that's outside of our normal course of business, and we expect our legal briefing will take up such issues.
Okay. And so kind of put differently, the company doesn't ever intend for anyone else to see this contract.
That it's a contract between the company and CCEF, so the parties to the contract will have access to it.
But on the flip side, you noted in your testimony that while the parties and the commission may not have access to the contract with CCF, the company suggests that any material changes to this OBF proposal, and in particular financial terms, could frustrate and upend this contract, correct?
Yes, because the company expects, that if significant or modifications are made to its proposal, it would then need to go back, renegotiate specific terms, or whatever suggested modifications are out there, with CCEF, and that could potentially lead to frustration between the parties' negotiations.
Okay. And so is it the company's position that the commission and interveners should trust that the contract with CCEF that we do not get to see is in the public interest?
The contract will reflect what we've proposed in rebuttal and any modifications that the company and CCEF can agree to.
Mr. Murphy, one aspect of the unfinalized and unknown contract is a concern about what could occur with the interest rates that are currently proposed, correct?
I'm sorry, can you restate that, Ms. Crampton?
Sure. One aspect of the unfinalized and unknown contract with CCF is the interest rates that contract will mandate, I guess.
I think that's one portion of the contract, yes.
Okay. And that's that 5 to 5.99%, correct?
That's correct, yes.
And do you recall in answer testimony, UCA witness Mr. Fernandez raised the concern that interest rates are dynamic and can change over time?
I do recall that.
And would you agree essentially with his proposition that if interest rates go up, the proposed 5 to 5.99% could become a rate that is untenable for CCEF?
I suppose that's a possibility, but it's my understanding that The initial thought is to have those 5 point, for the interest rates as proposed, would be, to the extent possible, held consistent.
Well, on the flip side, would you agree that if interest rates fall, that 5 to 5.99% could be a windfall for CCEF?
I suppose that's a possibility.
Does the contract that is currently unknown and in progress with CCEF have provisions that account for changing interest rates?
I don't recall the specifics of that sitting here right now.
Okay. Whether there's a provision that accounts for changing interest rates is unknown.
Right now, yes, I can't think of all the specifics of the contracts at this time.
And does the contract have provisions that protect consumers in the event of increased or lower interest rates?
I believe as the company proposed it, that we have proposed that any potential changes to the interest rates could potentially go through the 90-day notice process, or obviously be addressed in a future filing with the commission.
And at that point, would the contract be available and known?
The company does not plan to make this contract, available to parties or the commission, or file it with the commission.
And so is it your testimony that the commission and interveners have to rely or trust that there may be provisions that protect consumers in the event of increased or lowered interest rates?
I have to object on asked and answered about on multiple occasions now. Mr. Murphy's been very clear that he's not proposing to file the contract to the commission or the parties.
Could you rephrase, Ms. Crampton?
Well, respectfully, I disagree that my question has been asked. I recognize that he's not intending to file it as he's testified, but my question was whether the commission has to trust that this contract has provisions to protect consumers in the event of changed interest rates. So I think that's a different question.
The company will, sorry.
No, it's good. Go ahead.
The company will not be making the contract available to the commission or parties, is what our current proposal is.
Understood. Thank you, Mr. Murphy. I don't have any further questions.
Thank you.
Okay, I think that's the last cross. All we have left is my questions, and we'll take a little break and start it in 7 minutes at 3:10. Thanks. Hey, we're back. There's Mr. Menschelt. Good afternoon, Mr. Murphy.
Good afternoon, Commissioner.
I know you've had quite a day. Try and get through this as quick as possible. In your negotiations with CCEF, have you discussed at all measures to reduce the interest rates for customers?
We have not discussed any sort of reduction in the interest rates. We have, again, the CCEF brought forward the interest rate, the below market interest rates that they could support, and the company is supportive of such rates.
So this was a part of their original RFP. They just came forward and said, this is the interest rate that we would charge.
Correct. And it's my understanding that those rates are locked for the 3-year term of the initial 3-year term of this program.
Okay. And do you know what the interest rate is going to in the CCEF program?
It's my understanding it's going to, expenses that CCEF incurs, administrative costs, marketing materials. I'm sure there's some level of revenue generated for CCEF. I don't know the specifics of what that is. So
You've mentioned that you're starting with 10 million, hoping to grow the balance. Do you know, is any of this percentage going into sort of a revolving loan program where money is put back into the corpus of the money that's available to be loaned?
I don't think that's how it's structured. But I don't think that's how CCEF has structured it.
Do you know what the 2% origination fee is going toward?
That's just the, fees to originate the debt, things that, making the appropriate filings to initiate the finance debt with the customers.
So more as administrative costs again.
Yes, yes, administrative.
And my understanding is you're trying to align your program as much as possible with Tri-State. Is that right? In order to facilitate sort of streamlined programming within CCEF?
I think to the extent possible. I don't think they perfectly align, but to the extent possible.
And you've mentioned that subordination of the loan debt is critical to achieving those lower rates. Is that right?
Yes, that's correct.
And that was in the original, was that in the original things that CCEF proposed in their RFP that was attached to the rate that they offered within that RFP response?
The company had that in our scope of work for the RFP, and CCEF was comfortable with that design.
Okay. And are you aware that Tri-State also has subordination of the loan debt in their program with CCEF?
I don't know if it's the same setup as what we've proposed here. I'm not. Sorry.
And are you aware that the top rate for Tri-State customers is 5%?
I am. Or is it 5 or 4.99?
Yeah, basically 4.99.
Yeah.
So it's about 1% below what is being proposed for Excel customers.
Correct.
And are you aware that there's no origination fee for Tri-State customers?
I was not aware of that. No, I was not aware of that.
So what I'm getting at is I'm not sure what I'm missing here. It seems that Tri-State customers have the same program structure, same third-party administrator, and they're getting a much better deal than the customers for Excel by 2% for origination fee plus 1% lower. Why?
It's my understanding that one of the driving factors of that is Tri-State is using its own capital. So they are not sourcing their capital from CCEF. I believe it's been the capital that they're using is through a loan through the Department of Agriculture. that is 0% interest loan. So I think that's one of the driving factors there.
So Tri-State is capitalizing its own funding
Correct.
in their situation.
Correct. So CCEF, I think, is primarily administering the program.
Okay, are you aware, and I know you weren't involved in this proceeding, that in the most recent JTS proceeding, there were allocated, there were pretty low managed charging rates that were allocated to the modeling. It was about 10% managed charging. And the TEP program is trying to increase participation in those managed charging programs. Is that correct?
Yes, we're always looking to increase participation in our programs, but certainly our managed charging programs in our TEP.
But then as Ms. Lowry pointed out, in opposition to the commission order in the last TEP, you decided to not include EV chargers in this program. And I was just wondering why that is.
That's correct. And as I discussed with Ms. Lowry, our intent here was to remain consistent with how we've discussed this program with both stakeholders and the commission. We think that starting with DSM and BE approved measures is an appropriate starting point. We're certainly, open to ongoing discussions and evolving this program over time, including the measures that are supported.
And are you aware that the Tri-State program does include EV chargers?
I am aware of that, yes.
So one of the things that's come up a few times, and you've mentioned that this is Excel's position, is that non-participants should not pay or should pay very little, just the administrative costs into this program. I'm wondering why that is.
We just wanted, this is a voluntary financing program that does not provide any incentive to the company at this point, since we removed our proposal to account for some savings towards our performance incentive mechanism. So as we were designing this program, we thought that it was the appropriate stance to take to protect non-participating customers for such an offering, and we've tried to do so to the fullest extent possible.
I mean, I'm really having a hard time understanding this because other than, capital investments in transmission, generation, distribution system, pretty much all your programs are voluntary, right? I mean, you don't have to take a rebate. You choose to take a rebate. There's DSM rebates, TEP rebates, BE rebates. They're paid for by the entire base of ratepayers and made available to incentivize people to be able to help to afford these things that we've acknowledged are benefits to the system. So I'm wondering why this is different.
I'm sorry, Commissioner Plant, you froze on my end for about 30 seconds there. I heard about the EV rebate and DSM rebates, but you froze, so I didn't get the entirety of your comments.
I apologize. There's a fire down here and our power went out, and I think it just came back on. So that might have been the problem. I'm trying to understand, other than investments in capital infrastructure, generation, transmission, all the programs that go into the rates of ratepayers, they're all voluntary. I mean, DSM rebates are voluntary, TEP rates are voluntary, BE rates are rebates are voluntary. These are all funded by the rate base because these measures are things that either the state or the utility has a priority of trying to accomplish, and that we recognize that many of them provide direct benefits to the system. And I'm wondering why this one's different. Why in this particular case are we saying this shouldn't be ratepayers shouldn't pay to make this program more cost effective for customers?
I agree with you that our programs are voluntary by nature. But as we continue to implement programs, we certainly have affordability in mind. And we want, in this instance, we thought it was appropriate to make attempts to limit the impacts to non-participating customers. And I would also say that through our stakeholder efforts, we've heard from stakeholders that, you know, from certain stakeholders that they would like to see the impacts of these programs, you know, limited or in some instances, no impacts to non-participating customers.
So it's basically been that you've heard from some stakeholders that they didn't want to have the costs socialized like we do with all the other programs.
Yeah, and I think the company thought it was a responsible way to design the program in this instance.
Is it true that if, things are, for example, I'll use BE as an example just because it's probably one of the more expensive things that the utility and the state and everybody's trying to get people to do more of. That's going to be more affordable for the customers if they can get some way of financing that $15,000-$20,000 investment spread out over time at a low interest rate. Wouldn't you agree?
I would, excuse me, I would agree that does make that more affordable for customers. And then I would add to that with the addition of our rebates could make those measures even more affordable for customers.
And if you can make those things more affordable, then we probably, I would say, have maybe a better chance of achieving our various different programmatic objectives, and that feeds into the PIMS as you mentioned earlier.
Yeah, I mean, I think that's certainly a possible outcome. I think, as I discussed earlier, we're still in the very early stages of implementing our most recently approved clean heat plan. We're still trying to gauge what, participation looks like, but a program like this could, to your point, further support the potential for customers to become more interested in such measures.
Okay, thanks. On page 40 of your testimony, you pointed out that fuel switching could lead to disconnection, which I understand would be an issue. And then at the bottom of page 40 and into page 41, when contemplating envelope improvements, so weatherization improvements that would reduce energy usage, you opine that they could still pursue fuel switching and be in the same position. I mean, I think that they could do that on their own anyway. I mean, if we're talking about envelopes, we're not talking about fuel switching, right?
That's correct. And we, in working with CCEF, it was another issue, another concern that they raised, like, that they won't know if those customers fully, on their own or through some other financing mechanism fully electrify. And then in that instance, as I've discussed earlier, there's the potential to have an unsecured debt out there.
So this is one of the things I was trying to understand. Since the debt attaches to the meter and your concern is around having these customers that no longer are, getting a bill basically from the company for the service, if the debt attaches to the meter, when that meter is discontinued, wouldn't that just point to the debt coming due? I mean, isn't that how, if it's attached to that thing and that thing goes away?
It's an interesting point. I don't know that we've considered that as an approach. The way that CCEF has designed the program are the specific terms of, I believe it's 3, 5, 7, or 10-year terms of these loans. And so in their view, the customer would be obligated to comply with the terms that they've agreed to, and not, in any instance that I've heard, would it mean that the debt has come due sooner than that? unless the customer decides on their own to pay down the debt in a more rapid fashion.
Yeah, I can see how it wouldn't have come up with Tri-State because they're an electric utility. So I'm just wondering if in your negotiations over the structure of the contract within CCEF, they could attach not only the debt to the meter, but then say if that meter goes away, then the debt becomes due. And that can be a part of the agreement with the customer.
Well, I guess first, if I said Tri-State in my last response, I meant CCEF.
No,
So
no. I was saying
okay.
Tri-State because CCF only has Tri-State as far as I
Gotcha.
know, right? So
Okay. That has not currently been contemplated in the negotiations. Again, as we reviewed answer testimony, the company engaged with CCEF, and they had real concerns that allowing gas only customers to take part in the program, at least at the initial launch, raised real concerns for them and would cause not only more administrative costs on their end, but also likely higher interest rates for those customers. So, we had very engaging conversations, but CCEF was concerned with allowing these customers to take part in the program.
in PJM4, you outline the contractor relationship. And while that document identifies ways in which the contractors will qualify under CCEF and the EM&V process, it doesn't discuss contractor facilitation process with customers to qualify and enroll in the financing program. And I think in our original discussion around this, the creation of an on-bill financing program, one of the things that the commissioners were asking for is a streamlined and easy way for if I'm a customer and I'm talking to a contractor and I want to do this thing, I can easily get enrolled in this program and get the work done and that sort of thing. So I was wondering if you might be able to speak to that process as you envision it, in which what's the consumer process going to be like with the contractor when they decide they want to put in this e-pump? What happens?
Yeah, I mean, I believe that as we've contemplated it, and I think I discussed this a bit in my direct testimony, that we will certainly contractors that are within CCEF's trade network, and as we continue to align our network with CCES network, we will certainly educate them on the offering. And I think, we've talked about the potential for opportunities to have contractors actually have the potential to, have applications available when they're talking with customers. But it is our we want to make this as easy for customers as possible. And we want to make the process as streamlined as possible. And we think that by working with our contractor network to make sure that they're fully aware and educated about the program and how it works, we can accomplish that.
Okay, great, thanks. We've had a little bit of discussion today about loan loss reserves, which are a pretty standard way. I think that a number of different programs and states, utilities have tried to reduce rates. And you mentioned on page 22 of your rebuttal that CCEF has priced its rates commensurate with the risk, in that, and on page 23, that the debt is unsecured and the only way to incentivize the payment is with that threat of disconnection, basically tying it to the bill and having it be subordinated. Have you had discussions with CCEF regarding the potential of lower rates if there were some sort of a loan loss reserve or some other kind of credit enhancement mechanism that could reduce that risk, and what the percentage impact would be of something like that?
It's actually my understanding now that the loan loss reserve that CCEF is developing has been incorporated into the interest rates that they have proposed.
And do you know how that loan loss reserve works?
I don't know the exact details of how it functions.
So one of the reasons that these default rates, one of the loans, the rates can get low on these is that basically any default is covered by that loan loss reserve, and then that that reduces the cost of money basically for the lender because they are relieved of that risk. One of the things, and this is, if you want to kick this to Mr. Berman, I understand. One of the things that Mr. Berman suggested when he was opining, and I think you talked about this with somebody, I can't remember who, but when he was opining on if the commission decided they did not want to make the debt subordinate to the utility bill, that there could be created basically a regulatory asset. And I was wondering if we could use that same process as a means of creating a loan loss reserve. So, for example, to get a lower interest rate, I mean, one of the things that we understand, and there's been some discussion about whether it's below 1% or if it's 3% or whatever, but the default rate on these on-bill financing programs is historically very low. I think some of that is because some loan programs, have credit limits. Some of them are, lower amount. I don't know, but they're all different, right? But what I'm wondering is if a component of that 5.9%, 5 to 5.9%, is basically to cover losses. Let's say it's 2%. I have no idea what it would be. If we covered losses in that way that I'm proposing, where we would basically create a regulatory asset on defaults, if we were to be able to cover the losses that way, and that would presumably lead to a lower rate that would be available for everybody. If it were that 2%, then it could come down to, say, 3.9% as opposed to 5.9%. And then, as was proposed by Mr. Berman, that could become a regulatory asset, and we could cover those losses within that process. It seems to me that doing something like that would accomplish two things. Number one, we could lower the interest rate that's available to everybody. And number two, we could essentially remove a risk of disconnection. And that's been another one of the complaints of a number of the parties here, is that makes people nervous that there's a risk of disconnection. So I'm wondering if you can give sort of your perspective on that now. I know that you may want to just think about it for a little while, but I'm wondering what your sort of response to some sort of an approach like that might be.
I will say first that I think Mr. Berman is probably better suited to answer such a specific question. I understand, what you're proposing, not knowing how exactly the loan loss reserve functions within CCEF's proposed rates. It's hard to give a definitive answer. But, I think the company maintains that the subordination of the finance debt to the utility charge is really a critical thing for this program. But as far as, the regulatory asset and those proposals, I think Mr. Berman is probably better suited to answer those questions.
Okay. One of the other things that's been brought up by a number of the parties, and certainly it was one of the things that the commission was interested in when we gave the initial order, is the opportunity to buy down debt for all customers, certain customers, income qualified, maybe, those areas where there's high energy intensity. I think another party has suggested maybe in areas where there were air quality concerns or things like that. And so the one sort of question I have, and maybe you can include this in your SOP, is I don't think you'll have these numbers at your fingertips, but I'm just wondering what it would cost. Basically, if you were to get a 10-year loan for $10,000 to get it from 5% to 4%. And what would the cost of that be? That would be important information for us to have in order to make any kind of a determination. The other thing is whether or not that buy down is linear. I don't know if that's a per point number to zero, or if there's added costs as you get closer to zero. I'm just not sure how that works. And so I was wondering if you can maybe have those conversations with CCEF and find out what that cost might be.
Certainly. Yeah, I think we'd be open to having those conversations with CCEF. And I think the cost would also probably be highly dependent upon participation as well, right? So it's something else to consider. And I think we've made that point several times that, sitting here today, we don't know for sure what participation will look like. And I think, we would like some time to gather experience and lessons learned with this program, but we can certainly have those conversations with CCEF.
Okay, and also if you could include in the SOP what that kind of a credit enhancement mechanism, and I can talk about it a little more with Mr. Berman, but what that type of credit enhancement mechanism would have on the rates that are being offered by CCEF, if you could include that as well.
Sure.
Mrs. Stockmeyer, yes.
Yes, Commissioner. I feel like I have to raise the elephant in the room, or not in the room. There has been no participant from CSEF in this proceeding. Mr. Murphy has repeatedly used hearsay to give summaries of conversations he may have had with representatives from CSEF. You're now asking, understandably, for more information from CSEF in the record. My concern is if that goes in an SOP, there's no opportunity to ask CSEF specifically those questions, cross-examine them, or any of that. And so I'm as I'm sitting here, I'm wondering, yeah.
I understand and share that frustration. I just don't know. Do you have a solution?
And I'm raising this to make an objection in the record. But I almost wonder, I don't know if it's procedurally appropriate to see if somebody from CSEF could be available tomorrow to take the stand, basically a subpoena of CSEF representative tomorrow.
I do not know if that's possible. Mr. Wyatt, do you have any thoughts around that?
Can I maybe suggest one alternative while you're thinking about it?
Yeah.
If there is specific direction from the commission of exactly what you're looking for specifically, and either from this hearing or you're putting out in a separate decision, certainly CCF through public notice can file, like it has done already, a public comment letter providing you its signed responses if you don't want to hear it from us. That's another and much less expensive way. I think it would be possible to get you the same amount of quality of information.
Okay. Well, we'll consider all these things. Thank you, Ms. Stockmeyer, and these options, and come back with any decision around that. Let's see where I was. Okay. All right. You mentioned in your testimony that we're on a bit of a staggered schedule. We're getting kind of used to this at the commission. Not that we enjoy it, but it happens that we have a variety of proceedings going on that are on different schedules, and one informs another. And, And you have also mentioned that you would be proposing this on-bill financing program within the context of the DSM BE CHP consolidated proceeding that's going to be submitted next summer. So understanding that that's going to take about a year ish. We'll make a decision on this, and if we go forward with the program, I would imagine it would be, available sometime early in 2026. So we're kind of looking at 18 months, basically, between this decision on an on-bill finance program and any changes that happen within the DSM CHPBE consolidated proceeding, which would probably not take effect until the following June of 2027. So I'm wondering if it would make sense to think about this as an 18-month rather than a 3-year proposal that would then get modified within the consolidated proceeding, and then basically go, beginning in July or June of 2027 would become whatever's decided within that consolidated proceeding. So I think that it wouldn't make sense to have another year and a half of this after there's decisions made in the DSM proceeding. I just wanted to get your thinking on how these all integrate.
I mean, the company and CCEF have agreed to a 3-year initial term, and we've agreed that, this initial payment to CCEF from the company would take place over that 3-year term. I think that there could be changes that come out, obviously, based upon the decision in that next combined filing, that impact this program, and at that point, the company would look to re-engage with CCEF. But yeah, I understand what you're saying. I just, as we've discussed this and set up some of the payment obligations that the company has, it's been contemplated more over a 3-year term rather than an 18-month term. And I just add, that by not asking for this incremental budget in our current DSM plan, we believe we're able to effectively manage, what those payments will be to CCEF over the 3-year term. And if that gets accelerated to 18 months, that, raises some level of concern from a budget perspective.
Yeah, I appreciate that. And I wanted to also ask you about you've got the 700,000, which is that one-time payment, which you're saying would be spread out over 3 years.
Correct.
And then you've got, $50,000 for admin and $500K for upgrades to IT, billing, etc.
Correct.
Would that $500K be the first year sort of expense?
I don't expect that we'll spend the entirety of that $500,000 in late 2025. I think some of that will spill over into 2026.
But it's not an annual cost of the program's $500,000.
Correct. We expect that 50,000 ongoing program administration fee or cost to be the only component to go beyond the initial 3-year term if when the program is extended.
So there's basically your startup IT, set up all the stuff you need cost, which is between the third-party payment and that it's 1.2, but the cost of this program going forward you expect would be somewhere around $50,000 a year.
To administer the program internally.
Gotcha. Okay, that helps. So you talked a little bit about EECF's process working with customers that are having difficulty making payments. I think Boulder suggested the ability to defer some of the payments and extend the end of the repayment period, or allowing refinancing, and or basically refinance the loan and extend it for a longer period of time for chronic issues. Is that something that either you support or you've discussed with CCEF?
We've discussed such an approach, and I think, in working with CCEF, what we've heard is that, again, as I stated, like the primary tool that they see themselves employing is that 90-day pause to help customers, get back within good standing in their account. But their approach is going to be more of a case-by-case basis. In some of those discussions, the recommendations by Boulder, I believe it was Boulder, there could be additional costs to refinance that loan and make those adjustments. So there is some concern on that front, that it would create added costs to the program.
Okay, thank you. CEO proposed to expand the list of programs. I believe you agreed with some of them in your rebuttal, but I wanted to specifically get to your position on the list. So, with respect to electric panel upgrades that are needed to facilitate BE, I think you agreed that would be something that would be amenable. We've talked about electric vehicle chargers, windows and doors that meet Energy Star standards.
We did not agree to that. They're not an approved measure. I believe we have storm windows, I believe, is one of the approved measures, if I'm remembering correctly, but not windows and doors specifically.
Okay, battery energy storage systems.
We did not include that in our measure list as well.
And then I think you agreed with the health and safety upgrades that are needed to facilitate.
Correct. Yes.
Do you think, this is just a general sort of, and the last question, do you think it's appropriate to tie incentives to specific other programs? So for example, being able to get rebates or being able to get financing for various programs that would require participation in one of the programs that are facilitated through that purchase. So for example, EV charging, you get an incentive if you enroll in the managed charging program. Or if there were a battery incentive, you would get the incentive if you participated in the Battery Connector VPP sort of program. Really tying these two benefits to the actual system. Is that something that you've thought about within this program or other programs, so that the incentive, whether it's a rebate or financing, whatever it might be, the incentive that's being proposed would be tied not only to getting that equipment, but also enrolling that equipment in programs that benefit the overall system?
I think we have designed some of our incentive programs in that way. As an example, our home wiring and charger rebate in our TEP, there is a requirement for customers taking those rebates to enroll in one of our managed charging offerings. So I think yes, the company sees the benefit in offerings that align not only with an incentive to both the company and the customer, but also supports overall system benefit as well.
And I know I said that was the last question, but I like the other thing that I'm interested in is with the AMI meters, are you able to identify where there might be customers that are particularly energy intensive in their energy use, and perhaps marketing focused on those customers where the system might achieve the greatest benefits?
I don't know the specifics of that. I know, we've had discussions in multiple proceedings over companies' desire to, for example, be able to disaggregate load, and especially things like electric vehicle load that could really help with system planning efforts. Currently, we do not have those capabilities. I know it's something that the company is certainly interested in and would really help refine, or potentially refine our planning efforts.
Okay, thank you. Those are all the questions I have. Mr. Mansfield, over to you for redirect.
Thank you. Thank you, Mr. Murphy. Thanks for being here. We'll start with just one issue from Commissioner Plan's questions. In terms of incentive mechanisms you have regarding demand management, do you recall whether the company has an existing PIM that regards demand management programs?
We do in our most recently approved DSM and beneficial electrification plan. We did get approved for a demand management PIM.
Could that be someplace to start re-examination if the commission was inclined to think about other ways of encouraging demand management participation?
Yes, I think that seems like an appropriate place.
Thank you. Can we please pull up now from box.com an exhibit staff previously put on the screen, which is staff hearing exhibit 703. And just what is this again, Mr. Murphy?
This is the public comment letter submitted by CCEF.
And with staff, you read into the record portions of this letter as concerns CCF's funding levels and funding sources.
I'm going to object to the way that that question was phrased. We didn't have Mr. Murphy read anything into the record from this letter.
I'm not sure what the basis of that would be an objection. Ms. Murphy could say yes or no to my question.
Yeah, it's objections overruled.
I did not read the specific letter into the record, but rather confirm that the funding levels for the company's program are not spoken to in the second paragraph of this letter.
Given the discussion about this letter, as well as other issues raised during this hearing about CCF's participation and comments in this proceeding, we would ask the commission to add this hearing exhibit to the record, and to the extent there's any confusion about the hearing exhibit numbers, if we don't want to use the staff number, and we also have our own version in box.com, but substantively, I think it's the same to use this version because it was already brought up, which is marked as staff hearing exhibit 703.
Commissioner Boulder would object to admission of this document as hearsay. And we understand in the commission's practice, public comment is sometimes considered, but here where CCEF is such an important party to this proceeding and has not been made available, we would object.
Yeah, my response to that would be, we've already had questions about what's in this letter, and that's already been put into the record in this part of this hearing. Additionally, we've already allowed in a document from staff that's outside of the rules of Colorado civil procedure with no authentication, as staff acknowledged that it's appropriate to allow things that are relevant to come into the commission's record, even if it does not comply with the Colorado rules of civil procedure. On a similar basis, this document is highly relevant. We believe it'll assist the commission, and it should be allowed into the record.
Ms. Crampton.
Just want to make the same objection as Boulder. We would object. I think what's problematic about this letter, but also some of the discussion that's been having, is that there is not a CCF witness. The company's witness has been allowed to testify speculatively to what CCF might be thinking or planning or doing or committing them. And parties have no opportunity to cross-examine a CCF witness. So we would join in Boulder's objection. I will note my recollection of staff's cross-examination is that this letter was not put into the record. And so I would also join staff's previously lodged objection.
Yeah, this is not from the company. This is from CCEF. So it's not our words of what they're saying. This is their words as they filed in this docket. And I would further note that to the extent we're trying to get more interest rate information from CCF into the record, I don't know how you want to do so if you won't even allow a document like this into the record. That basically would defeat the process I encouraged earlier.
Mr. Barroso, did you have?
Yeah, thank you, Commissioner. WRA shares the same objection raised by Boulder and by UC. I think it's clearly distinguishable to ask questions about a document during cross and not seek to admit it versus seeking to admit a document during redirect examination after all cross-examination has already concluded.
Okay, for now, I'm going to rule that this not be admitted into evidence in this case, but we may revisit this tomorrow.
Shouldn't we also then strike from the record the testimony about what's in this record, what's in this letter during staff's questions?
Well, no, I mean, it was submitted as public testimony. I think that that's available for discussion among the parties in the hearing. I've certainly discussed other public testimony that's come in from a variety of parties in the past, so I don't see any problem with that. It's a little bit more complicated in this case just because they're such a central part of this proceeding and they're not available either to represent themselves or to respond to questions. So it's a little stickier than most situations like this, but we can revisit this in the morning. I'd like the opportunity to talk to counsel.
I guess I would just conclude, and I appreciate the guidance, that if we can't put in the record, we'd at least like the opportunity, like staff had, to ask questions about the document.
Certainly.
Well, then, if that's the case, can we please go to one second, please. Just the first paragraph of that document, then, just one question. Mr. Murphy, is it your understanding that CCF's letter filed in this proceeding explains CCF's position that they agree with the company's financing program proposal as submitted in its rebuttal case?
That is my understanding, and they respectfully recommend the commission issue an order in this proceeding that approves it.
Okay, no further questions on that document then. On to a next subject. You recall having discussions with staff about its cost recovery recommendation?
I do.
Just for some background, can you please discuss at a high level your understanding of staff's cost recovery proposal?
Certainly, it's my understanding that staff is suggesting that the company not be allowed to recover costs associated with standing up and administering this program with CCEF, and to bring such costs forward in a future DSM plan.
Is it your position that the company can take the administrative costs you've identified and defer them for recovery into your next DSM plan?
We have not proposed such an option. However, and it's my understanding that a deferral of these costs would, take approval by the commission. I don't know that the company is opposed to such an approach. However, we will have costs that are incurred likely this year into 2026, and as discussed with Commissioner Plant around the timing of our next combined filing, we likely will have some costs incurred in 2027. But as staff has proposed, there's no certainty of that cost recovery. So company is open to, an approach where we can recover those costs through the DSMCA, which we see as appropriate. But if the commission acknowledges that a deferral of those costs until the next DSM plan is more appropriate, then we would certainly be open to that.
Well, without commissioner approval of deferral, could you recover your expenses in years 25 and 26 and a portion of 27?
No, we could not.
Thank you. And we'll move on to another topic. With Boulder, you were discussing the EV Accelerate at Home program. Do you recall that conversation?
I do.
And you were talking about the differences between the subordination of debt aspect of that program. Do you recall that discussion?
Yes, I do.
Do you have a sense of what the general cost of a EV charger is in the EVA program?
I don't know the exact cost, but I would say approximately $800.
Is that cost much different than the maximum program debt in the tariff on-bill financing program?
Yes, it's significantly less than the proposed $50,000 cap for the tariff on-bill financing program.
Do you have thoughts on whether there's a higher risk of customer defaults for a debt up to $50,000 versus a debt of $800?
I think the likelihood of default is higher with the higher cap in the finance program that we've proposed, rather than a $13 a month charge on customers' bill to support EV Accelerate at Home.
Could we please open up hearing exhibit 800, attachment CCE8, please? And do you recall having a conversation with counsel for Boulder about default levels by certain utilities as discussed in this report?
Yes, I do.
Can we please turn to page 10? And can we show that full table on the screen, please? Does this table indicate that some or all of the utility programs examined are in the PAYS program?
Yes, Rose 3 would, in my opinion, shows that at least some portion are in the PAYS program.
And would you expect bad debt to potentially be lower in a PAYS program as compared to an on-bill financing program? And if so, why?
Yes, I would expect that to be the case, and that's because the basic structure of a PAYS program requires that the customer actually achieves savings on its utility bills through the measures that are supported through the PAYS program.
Okay, thanks for that. We're going to move on to another topic and done with this attachment. Thank you. And you discussed a little bit with EOC's counsel about the late fee process. Do you remember that discussion?
I do.
And just to clear up the record a bit, the late fee that would be applied to this new financing program, would it be the company's existing late fee process or a new or different CCEF late fee structure?
It would be the company's existing late fee process.
So what exists today would also apply to the new financing program charges on a monthly bill?
That's correct.
And the late fee would be regarding the amounts on the monthly bill or the total financed amount in the financing program?
It would, the late fee would apply to the monthly bill.
And do you have any thoughts about how charging a late fee can encourage timely payment in the financing program?
It's an attempt to, send a signal to the customer to, come to get their account back in good standing.
Or perhaps not to be delinquent or late?
Correct. Yes. Yeah.
And when discussing with sweep issues about the total range of bad debt exposure, you kind of remember having that discussion?
I do.
Does the company feel as though it's important to lay out the fundamental financial structure of this program so that it can not just work in the first few years, but into the long term be set up for success?
Yes, I think that's a pretty key component. I think I've said several times, we don't know what program participation will look like as we launch this program. However, the intent is to grow this program. And so I think it's important to get the structure of the program right from the outset.
Okay, thank you. And I think my last question concerns some of the contractual discussion with counsel for UCA. I think the record's a little bit unclear of the interest rate offering by CCF, whether you understand that the interest rates are locked in for the first 3-year term or whether they're variable. Could you please have more discussion on that issue?
Yes, it's my understanding that for the initial 3-year term of the financing program, the rates that CCEF has put forward are locked.
Okay, thank you. No further questions.
All right, thank you. Mr. Murphy, you are excused.
Thank you, Commissioner.
Thank you. Appreciate it. Long day. And Mr. Berman, I think it's just me.
All right, I am here and ready to go.
All right. Oh, wait a minute. Hold on just a second. Okay, Mr. Berman, do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
And is it anyone communicating with you or assisting you in any way?
No,
And if that changes, you'll let us know.
I will.
All right. It's yours,
Mr. Berman, could you please state and spell your name for the record?
Yes, Stephen Berman, Steven Berman.
By whom are you employed in what capacity?
I'm employed by a public service company in the capacity of Regional Vice President of Regulatory and Pricing.
And you sponsored hearing exhibit 104 in this case?
I did.
That's been entered into the record and he's available for Commissioner Plant's questions.
Thank you, Mr. Manchel. Mr. Berman, you probably heard what I'm going to ask you, so just get right to it.
Yep.
Just as some context, loan loss reserves are used in many cases to try and lower the cost of capital being loaned in an on-bill finance program. Generally, that entails taking a big bunch of money and sticking it somewhere and saying, we'll pay for defaults if they happen. And by taking that risk off of the lender, you can get a lower interest rate. You had mentioned in your rebuttal testimony that it's the preference of the company to have the debt of those loans subordinated to the utility bill But if the commission were inclined to not do that, that what could happen is the creation basically of a regulatory asset if there were issues around non-payment of a utility bill. And what I'm wondering is, could we basically use that same model, but rather than having a big bunch of money that sits there and waits for any potential default, have that as a mechanism for paying off any defaults, taking that risk off of the CCEF in this case, and basically do the same thing, create a regulatory asset and cover the costs of that default. I think one of the things that's been testified in a number of different ways is that the on-bill finance default rates are generally very, very low, but nobody ever knows what they're going to be until you run the program. And so, there's an assumption that it's going to be, higher. And that leads to higher interest rates. And so what we're trying to do in this case is create a mechanism essentially for a loan loss reserve fund without putting a bunch of money in a bucket, and cover that risk using that regulatory asset. Is that something that the model that you posed would be able to be used for?
So I think I understand the concept, and let me just preface it with a couple things. Number one, I don't know how this would impact the rates that CCEF would
Right.
charge.
Yeah, we've asked for that in the SOP, and we'll hopefully find that out.
Number two, I think as Mr. Murphy just talked about, some of the principles the company is asking for here, like the subordination of debt. I recognize that in the near term, it's likely not that material of an impact, right, that bad debt would have, which is quite frankly why the testimony I provided is like, let's see what happens, and we may bring a proposal like that forward in a future rate case. But in the long term, if this program grows, it could get larger. So, I mean, the short answer to your question, I think, is yes. I don't know that that changes the rate, but if in the short term, certainly, I wouldn't expect those costs from the loan loss to be too large that they would concern the company to defer them and bring them forward in a future proceeding. If we started to see them get larger, then we might make a different proposal, like having them in the DSMCA or somewhere where we're not building up too big of a liability on the balance sheet that we have to bring forward later for recovery. And I think the last piece I'd say is, I would expect that to create some non-participant cost impacts. Again, understand the dialogue you had with Mr. Murphy around that, and maybe the commission would be okay with that. But I do think, it would be very challenging to try to get the program participant customers only to pay for that.
Yeah, I agree. That's all the questions I have. Thank you, Mr. Berman.
No problem.
Mr. Mansfield, I don't know if you had any redirect.
No redirect.
Okay. All right, great. Next up is staff. Or is staff next? I think staff's next, right? I'm sorry, Ms. Vitale.
Thank you. I just wanted to say that the Energy Office is waving its cross of staff witness Gabir before she's sworn in. Thank you.
Great, thank you.
I would also do a timeout on the cross-examination matrix, if that's acceptable.
Of course.
The company is going to waive its cross on all existing parties.
Oh boy, that'll save us some time. Okay, so have no cross Gabir. So I think we still do have two remaining crosses. And yeah, all right. With that, Mr. Smith. Oh, wait, I have to do the thing, right? Okay. All right. You're gonna have to help me with your name. Gabreskibeer? I was close. Okay. Okay. If you could raise your hand. Do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
Is anyone communicating with you or assisting you in any way?
No,
If that changes, you'll let us know.
I will.
Okay, thank you. Mr. Ross, or Mr. Smith, sorry, you're up.
That's okay. I can be Mr. Ross if that's helpful.
It works both ways, doesn't it?
Thank you, Commissioner. I did have one just matter I wanted to get before introducing Ms. Gibretz-Kabir. I believe my understanding of your request of the company is that they're to confer with CCEF and have the company put in their SOP some information regarding interest rate buy downs and things like that. Am I understanding that correctly?
Yeah, that's correct.
Okay. So I think the concern I would raise with that, I think you've heard the concerns. I think one request that staff would make, if that is the path that we're going to go down, is that parties be granted an opportunity to respond to that discrete portion of the company's SOP once it's filed. It seems like in the absence of being able to actually verify or cross-examine CCEF on any of the information they do provide to the company, that may provide some alleviation of some of the notice concerns that staff has. So I just wanted to raise that. I don't know that we need to make a decision on that, but that was a potential suggestion that I just wanted to raise.
Yeah, that may offer us a good solution for how to go forward on that. And I'll consult with counsel and we'll come up with a determination on that. Thanks.
Okay, and sorry to derail us here, but all right, I'm ready. Good afternoon, Ms. Gibretz-Kabir. I've almost gotten it. I'm getting there. Could you please spell and state your name for the record?
Sure. First name Nardos, Nardos. Last name Gabreziabher, Gebreziabher.
I promised I practiced it. And what is your position with staff?
I am testifying on behalf of trial staff for the commission. I work as a senior economist.
Okay. And did you cause to be filed in this proceeding what's been marked as hearing exhibit 700?
Yes.
And its attachments?
Yes.
And if I asked you the same questions contained in that testimony here today, would your answers remain the same?
Yes.
Okay. And with that, Ms. Gibretz-Kabir stands ready for cross.
All right. Ms. Judkins, clear.
Good afternoon, Ms. Gibretz-Kabir. For the record, my name is Sarah Judkins. I'm representing CLEAR, and I would like to first focus my questions on staff's concern about the lack of a cost-benefit analysis conducted in this application. So staff has concerns that the company did not conduct a cost-benefit analysis for the proposed TOBF program, correct?
That's correct.
And a TOBF program is not a novel offering for utilities across the country, is it?
And not across the country, but it is a new program for PSCo and its customers.
And in fact, in your testimony, you cited a report stating that there are over 110 utilities across the country that offer something akin to this type of financing program, right?
That's correct.
And the prevalence of these programs, similar to the proposed TOBF program, should give some indication that they're cost effective, right?
I don't think we can make that conclusion. I'm sure there are different types of programmatic differences among the different utilities that exist and that have done, similar types of analysis before implementing or launching these types of programs. So I think it's generally considered a good practice to implement some sort of cost benefit analysis And I think to your note about, that reference in my testimony that, says 110 utilities have, similar types of programs. One of the findings is that most of them do have or have done some sort of cost benefit analysis before or during the implementation of these programs.
So as you just mentioned, and you also indicated in your testimony, a cost benefit analysis could occur in the future during the implementation phase, even if the commission approves the TOBF in this proceeding, right?
That's correct. And I think one of the reasons why we're asking for a pilot-like program in this proceeding is to allow for that to take place. If we start small with more targeted and smaller capital and per premise amount, we will have the opportunity to collect enough data to assess, the viability of such program before expanding it into something that may have unintended consequences.
Thank you. And specifically, you suggested that if the commission decides a cost benefit analysis would be helpful, it could order the company to provide this type of analysis in its next DSM application, right?
Yes, that's one option for the commission.
So the lack of a cost benefit analysis in this proceeding should not prevent the commission from approving the TOBF proposal now, right?
So that's correct, but I think the lack of a cost benefit analysis in this proceeding is why we think this program should be much smaller than what the company is proposing it to be in terms of what the maximum per premise amount is. And I think what some of the other parties are suggesting in terms of what the maximum capital should be.
Staff is also concerned that the company has not executed a final contract with CCEF, correct?
That's correct.
And if the company had executed a final contract with CCEF before filing the application or while this proceeding was pending, it's possible that the executed contract could have included terms that conflict with what the commission may approve in this proceeding with respect to program details, right?
That's correct.
And in that situation, the company and CCEF would have to amend the contract to implement any differing terms the commission approved, right?
That would be the expectation.
Objection, Your Honor. That question calls for speculation, also possibly calls for a legal conclusion.
Yeah, I'll allow it. Objection overruled.
Would you like me to repeat the question?
Go ahead, yes.
And so in that situation where a previously executed contract did not match the terms and program elements that the commission approved, the company and CCEF would have to amend the contract to implement any differing terms the commission approved, right?
Yeah, there would be a need for some form of provision. Again, I'm not a lawyer, so I don't know how these contracts are drafted and what room there is in order to amend these types of contracts, but there would be a requirement or some room for those changes.
So doesn't it seem like it's a more streamlined process for a contract to be executed after a commission decision so that it can include, in the first instance, commission-approved terms and details?
So there's a couple of ways to do it. The lack of contract, and as mentioned in my testimony, is a way that, we're saying we don't have enough details or, in-depth insight into what is being proposed in terms of the programmatic details between PSCO and CCEF. That lack of contract, whether it's signed or whether it's provided as a drafted document, is what we had, what we were seeking. If it was provided as a draft document, it would have provided us with more insight and details into what the two parties were agreeing to. If it was provided as a signed document, I think it would have needed some, Form F provision that would have allowed for modifications based on the commission's decision. So I think there was room in terms of how that document would have been provided and at what stage that document would have been provided.
And I know there's been a lot of discussion about this document today, but did you review the public comment that CCEF submitted into the document in which it explained that CCEF is working with the company to get to a final executed contract?
Yes, I have.
And from that public comment, CCEF seems committed to working with the company to ultimately reach a final executed contract, right?
Yeah.
And so given this, shouldn't the commission feel comfortable with CCEF's commitment to the TOBF program, even without having a final executed contract at this point in time?
So I think there is a misrepresentation in how that's being drawn. We're not asking whether CCEF is able to implement, a contract that is signed with PSCO. The question arises from the lack of detail from this side, is we're looking at what this program entails. If we don't have some form of draft document, whether it's signed or during the drafting phase, we simply don't have enough information into what CCEF and PSCO are agreeing to. We understand that CCEF has the experience in implementing similar programs, so the question is not about whether they're able to do such a program.
Thank you for the clarification. And given that we've already discussed that a final executed contract would have to implement or align with a commission final decision, does that give you more comfort?
Can you repeat that question?
Yeah. So I think we discussed a little bit earlier that the final contract between the company and CCEF would have to align with whatever the commission approves in this proceeding, right?
That's correct.
And so does that fact give you more comfort in the situation we found ourselves in, where the contract is still under negotiation and has not been provided to the parties in the proceeding?
Yeah, I think the expectation is, for the commission to have, access to this contract before or after, at some stage during the process of implementing or launching this program.
Thank you. Those are all of my questions for you. I appreciate your time.
Thank you.
Thank you. And next is WRA, Mr. Barroso.
Thank you, Commissioner. Good afternoon, Ms. Gerbrugsa.
Good afternoon.
How are you?
I'm good.
Thank you. And for the record, my name is Parks Barroso, and I'm representing WRA in this proceeding. Just two topics to discuss with you today. First is the length of loan terms, and the second is the maximum loan amount per premises. So first, on length of loan terms, your position, staff's position, is that the loan term or the repayment period should be limited to no more than 5 years. Is that correct?
So that was our preferred recommendation based on, how we want to implement this program as a pilot. If the commission approves this program as a pilot for 3 to 5 years, it would be consistent with that pilot program to have access to data where, applicants or customers are limited to having a loan duration period of 5 years.
Thank you. And so is that still your position, that this should be approved as a pilot and the repayment period should be limited to 5 years at a maximum?
That would be staff's preferred position, yes.
Would you agree with me that one of the goals of this on-bill financing offering is to allow customers to reduce barriers to home energy upgrades that a customer might not otherwise be able to afford due to the high upfront costs?
Yeah, that's one of the goals.
And in your opinion, could high monthly costs also serve as a barrier to investing in home energy upgrades?
They can, and that's why we're recommending reducing the maximum per premise amount to $15,000 versus the company's rebuttal position for $50,000.
Thank you. I appreciate that staff's position, but just sticking on the loan term length, if all else is held equal and the same loan is spread over 10 years versus 5 years, would the monthly payment on the 10-year loan be higher or lower than the 5-year loan?
The 10-year would be lower.
Thank you. And if we could please pull up your testimony. I believe Ms. Kunkel is still driving, if she's still with us. This is hearing exhibit 700. Great, thank you. And scrolling to page 21, please. And so what I see here, Ms. Bregsbier is a table showing different financing programs offered by other utilities. And there's a column titled Max Term. Do you see that?
I do.
And just sticking with that column, it shows that none of those other utility programs limit loans to a maximum length of 5 years. Is that right?
Yeah, and I see that and I understand that. I think these programs and the information here is as they stand today, not necessarily when they were first launched. So I don't think we have insight into what the maximum terms were or what the other types of eligibility or financial amount would be when they started out during the earlier stages of implementation.
Fair enough. Thank you. And if we could scroll up, please, to page 10. I'm looking at lines 3 to 10. And so here, this is a quote or an excerpt from the Commission's decision in the company's most recent DSMBE strategic issues proceeding. And please feel free to take a moment to refresh yourself on this if you need.
Okay.
And if we look specifically at lines 6 through 7, I read this to say that on-bill financing better aligns a participant's costs of participating with the savings that are thereby achieved.
Okay.
In terms of that phrase, savings achieved, do you understand that to mean the energy savings that a customer might achieve from pursuing energy efficiency or electrification measures?
Can you repeat that question?
Sure. So the term savings achieved, do you understand that to refer to energy savings that a customer might receive from pursuing an energy efficiency measure or an electrification measure?
Yes.
And is it your opinion that the useful life of an energy measure or a heat pump or other measure would be 5 years or less?
I think most of them have different life cycles, and if that's to be considered, we understand that it might be longer than 5 years. But if we're focused on the savings that are thereby achieved as a result of these installations with the Tariff on-bill program, I don't think we have insights into what the actual savings are. As customers, at least when they sign up at this stage, there's no saving tool that will be implemented with the launch of this program. Won't have access to information regarding what those savings are. So I think, to your point, there will be savings, but at least the customer won't know what those savings are as these programs are implemented.
If the useful life of a measure is more than 5 years, or the savings from measure endure for more than 5 years, wouldn't a longer loan repayment period result in better aligning customer costs with the savings that would be achieved through that measure?
So if we're trying to, I guess, have customers pay lower amounts in longer periods, it may look, smaller. But I think if we're considering the interest rates that are proposed in this proceeding, and if we're adding some of those costs associated with administrative costs, I think those costs would differ.
Let's switch gears here and turn to the maximum loan amount. So, Ms. Bregsbier, your position and testimony was recommending a maximum amount per premises of $15,000. Is that correct?
That's correct.
Are you aware that in public services testimony, it estimates an average cost of $20,000 to purchase and install a heat pump for space heating?
Yeah, I understand some of the costs associated with heat pumps. Heat pumps are higher than that $15K.
And so, taking public services estimate at face value, if the maximum funding is capped at $15,000, it follows that a customer would not be able to pursue the purchase and installation of a heat pump under staff's proposal.
We have taken into consideration some of the rebates that exist as part of the DSMBE. I don't know how much the rebates will reduce that amount, but that's also available. And I think customers will have access to other forms of financing if that's really an investment they're willing to make at this stage. And just to your point about 15K not being enough, I think we're saying at this stage, we should start small with 15K, see how, the program is launched and implemented and how customers respond to this program. And if there is a need to expand on the maximum amount, that's something that the commission can consider in the next TSM or when, the company is reviewing, updating this tariff on bill program.
One more hypothetical for you. Let's say a customer is not only interested in a heat pump, but interested in pairing a heat pump with complementary measures. Again, a $15,000 cap would likely not allow a customer to install a cold climate heat pump, pursue panel upgrade, and pursue a weatherization upgrade all at once, funded through on-bill financing funding.
And I'm just going to lodge an objection that, I mean, we've done some hypotheticals here. We've talked about there's a lot of variables. So to the extent that this calls for more speculation, staff would object to that.
It's overruled. If you could answer the question or rephrase, Mr. Barroso.
Ms. Cabrera-Spear, do you need me to repeat the question?
Yes, please.
Certainly. So we just discussed a customer who's installing only a heat pump. Now let's say the customer is interested in pursuing a heat pump and complementary measures funded through the OBF program. Again, a $15,000 funding cap would likely not allow the customer to pursue a cold climate heat pump, a panel upgrade, and a weatherization upgrade all at once.
Yeah, I think that's correct. But again, going back to staff's point, I think the goal is not to have the maximum amount for customers.
Thank you, Ms. Cabrera-Spear. I hate to cut you off, but you can finish your response with your counsel and redirect.
All right, thank you.
And those are all of my questions. Thank you so much for your time.
All right, thank you.
Great, thank you, Mr. Barroso. I think there are no other questions from the parties, so I just had a couple of quick questions. And you talked about this a little bit. I was just trying to understand a little bit better. You mentioned cost effectiveness tests a number of times and how there would need to be some sort of cost effectiveness. And I've tried to imagine how you might do a cost effectiveness test with a financing program which can cover a variety of different measures, probably bundled, where your benefits are going to be actually greater. I mean, for example, if you do a heat pump and insulation, you're going to have a greater benefit than if you just did the heat pump. And so, I'm having a hard time understanding how you would take a program like this and apply benefits when you don't know what the measures are that are benefiting. Or were you talking about doing sort of a post hoc evaluation?
So I think we can do both. If we are, if we're collecting enough data during the initial stages of implementation, we have more access or more information into what customers are upgrading to, how much they're paying, and what the savings are in terms of those upgrades. So I think it's easier to do that once we have enough data from customers. But during the initial stages or prior to collecting enough data, there are ways to do these cost benefit analysis. And I think the Minnesota document that we shared this morning provides different ways of doing this. There are ways where we can just take the average of what those costs would be for each customer and what the savings would be on an annual basis, and then compare it if we want to focus on what the cost benefit analysis would be just for the borrower themselves. And there is also a way to do it for non-participant participant customers and add it to the borrowers who are actually causing some of these costs. So going back to your point, the more accurate analysis would be done once we have some data. But if we are trying to make some assumptions about what the overall benefits are, we can assume or use forecasted data based on what we think customers will take on, based on the maximum pair premise amount and what that could cover and how much saving that could bring in a given year.
Okay, so you're saying you just sort of estimate what people might do and what the deemed savings might be from each of those and how they might impact the system, and then measure that against, I guess, you would just, in what the company has proposed, you would just measure that against the administrative costs.
Yeah, not just
That's all anybody's paying, right, is in terms of what they're proposing.
Borrowers are paying more than administrative costs. They're paying for the borrowed amount and the interest rate and the 2% fee. So there is a way to just do that analysis just for the borrowers, where we're taking into consideration all costs that they have to face versus the savings that they could see. And I think this is similar to, a savings test that some of the other utilities are doing, where they focus just on how much savings, would come from these upgrades when customers take on these loans.
Okay, so you're talking about doing a cost effectiveness test for the individual customer that's making their own investment, not whether or not it's a good investment on part of the utility to have this program. You want to make a decision whether or not this person who's decided to spend money on a heat pump, whether it's worth it for them.
No, I think the cost effectiveness test, there are different ways to do it. We can do an analysis where we're measuring what the benefits are for borrowers based on the cost associated with the overall, upgrades. But also there is, I think, a program level cost benefit analysis that could be done that is similar to how the company does program level or portfolio level analysis on the DSM side. So taking the program as a whole, I think the company admits that it hasn't done a program level cost benefit analysis in response to discovery, but it would be similar to how they're assessing different programs or portfolios in that instance.
Like using a TRC.
Yeah, using the modified total resource cost test that they do, yeah.
Right. I think that the commission has expressed some questions around using TRC and some of these things, but I get your point. And so you mentioned in your testimony a 2020 decision in another DSM case where the commission stated their priority was only providing funding for low-income customers, correct?
That's correct.
That wasn't the directive from this commission, correct?
No, it wasn't a directive.
I think this commission talked about it in a much broader way.
That's correct. I think it was mainly just to highlight that over the years, tariff on bill programs and how they would work has revolved around how they would be able to, fill in the gaps for income qualified customers. We know there is more room, and more customers could take advantage of this type of program. But over the years, the focus has been making sure this type of program works for income qualified customers.
And if I understand your position on page 49 of your answer testimony, you suggest that only people who are income qualified need financing, I think is what you said. We should focus this on people who need financing, and that would just be income qualified people. Is that correct?
So if I may look at the electronic version of my testimony.
Yeah, Ms. Kunkel, if you could bring up her answer testimony and go to page 49.
So the point we're trying to make here is that we need to make this program work for customers who actually need, access to low cost financing. And most of them, I think, are, income qualified customers. And this is citing to a prior language that we used where, the socialization of costs associated with tariff on bill programs could be great if we're not too focused on where we are targeting this type of program.
So, I mean, I would expect that a customer who signed up for financing would need it. So I'm wondering how we make a determination on who needs financing when there might be, for example, people that don't have $15,000 for a heat pump.
Yeah, and I think we understand that gap. It's hard to sometimes weed out the customers who actually do need this financing. And one of staff's recommendation in this proceeding is to potentially consider carving out a portion of, the budget for income qualified customers in case some of the rebate amounts run out and they need access to some of these funds, or in case, there are DSM funds that may not be accessible to them for many reasons. I think the point we're trying to make is if we're going to proceed with this type of program, I think we need to make sure that we're either reserving a portion of the capital to income qualified customers, or and increasing outreach to these customers where they know they have access to these funds and they're taking advantage of them.
Okay, thank you. I don't have any further questions. Mr. Smith, if you want to do redirect.
Very, very briefly, Your Honor, that I know that we're cutting short on time here. Ms. Kabir, I just wanted to ask you, I have a couple of questions here related to the cross you've just gone through and from the questions from the commissioner. The first thing I want to talk about is the cost benefit analysis. Is it staff's position generally that a cost benefit analysis is a good practice for new programs?
That's correct. And I think our recommendation for having some form of cost benefit analysis is based on, best practices that we have reviewed in the industry, other utilities, other assessments that have done similar types of programs generally have done this type of assessment. And it goes back to the point where, these are good practices if we're looking at what some of the other utilities in the country have done. And it's also consistent with the Commission's direction from 2023, the last DSM application, where the Commission directed the company to consider or to have a component where customers have transparency and information into what the savings and benefits are associated with a tariff on bill program. So it is good practice, and it also responds to the Commission's direction from 2003 that directed the company to file this application.
And that's a point. Mr. Barroso actually brought this up, and I'd like to, if we could, for just a moment, Ms. Kunkel, could we bring up Ms. Kabir's answer testimony and go to page 10, line 20, please? And so this quote, I believe this was something that Mr. Barroso pointed you to. And I think, if I'm correct, this is what you're referring to with the Commission's prior directive. Is that correct?
Yes, I think he was referring me to the prior quotation, but the one that I was just referring to is the one that's in front of us from lines 20 to 26.
Okay, and this is where the Commission here, and I'll let it speak for itself here, but it appears that what it is directing the parties to do is, well, what do you believe that it's directing the parties to do here?
So in that decision, the Commission suggested the company to have 3 additional components into its program design. And one of them specifically says the program should ensure that customers enrolling in a tariff on bill program have dedicated access to benefits and potential savings over time.
I see. And in staff's position that conducting a cost benefit analysis would aid in that directive.
That's correct.
Okay. So, and Ms. Kunkel, we can actually take this down. I appreciate it. I might bring it back one more time, but for now we can take it down. The next thing I just want to go over for just a moment here is to talk about sort of this affordability and staff's recommendation for a $15,000 per premises cap. Do you recall being asked about that on cross-examination?
I do.
And I believe Mr. Barroso asked in one of his hypotheticals about a 10-year versus a 5-year loan term. Do you recall that question?
I do.
Could you tell me offhand, and I can, if needed, I can take you to it in your testimony, but are you able to tell me what the bill impact would be on a 5-year loan with your preferred cap of $15,000?
Yes.
An approximation.
I think with the 15,000, we're looking at $500 a month. And with the company's proposed $50K, that 5-year loan would be in the range of $800, $900.
So I think, is it fair to say then that the affordability issue, staff's $15,000 cap sort of touches on that affordability issue?
That's exactly correct. I think the point with the $15,000, at least during the initial stages of the program implementation, is for the commission to have enough data and details about how this program would work before having borrowers take on great amount of loans they may not fully understand and they may not afford in the long run. So I think that affordability question needs to be given the consideration that it deserves as we're considering some of the environmental goals and missions that this bill provides.
Thank you. And Ms. Kunkel, I'm going to ask you one more time to bring up Ms. Gebrez-Kabir's testimony and take us to page 50, if you don't mind. So I believe Commissioner Plant asked you just a brief couple of questions about low-income customers and income-qualified customers. Do you recall that?
I do.
And I believe you did at least mention that staff had posed two, or at least one potential resolution to the query that he posited to you. Do you recall that?
I do.
So here on page 50, is this where you give staff's other or both recommendations?
This is correct, yes.
And does in your view, do you feel that these address some of the concerns that staff has regarding income qualified customers as this program has been proposed?
Yes, I think it addresses one of the main reasons why we have such a program in place. And we want to make sure that income qualified customers are benefiting from this program if it's to be implemented. And one way to do that is to ensure that there is enough outreach and coordination to ensure that they have access to these, but also to make some form of the funds available to them if there is a need for it.
Thank you. And we can take this down. And Ms. Gebrez-Kabir, I just have one more question for you. Could you please explain to us that's the balance that staff generally has to weigh when it comes to weighing these types of programs? Could you just give us a sense of that?
Yeah, I think like I mentioned earlier, we understand this program was a result of prior DSM applications and the interest for filling the gaps to ensure Colorado can meet its environmental goals. But I think, like I mentioned earlier, we need to take into consideration what this means for participants who take on the loans and non-participants who may be burdened with some of the costs associated with running this program. So that affordability question, I think at the end of the day, needs to be given the level of consideration that it deserves, especially if such a program is to be implemented at the level that the company is proposing, and it could have the impact that it could have in the long term.
And so ultimately, staff does support an on-bill financing program as a general principle, correct?
Yeah, with the right level of program details and the right level of protection and guardrails for customers and also non-participating customers, staff would support such a program.
Thank you, Ms. Gebrez-Kabir. I have no further questions.
All right, thank you. I appreciate it. I think we're gonna break for the day. We have next up Ms. Elam from Boulder. And I know that there's only about 10 minutes, but I do have some questions for Ms. Elam, so I'm going to put that off until tomorrow. And we'll plan on starting tomorrow morning at 9 a.m. Are there any issues that we want to address before breaking for the day? Yeah, Ms. Crimpton.
Thank you. During my cross-examination, Mr. Murphy, I had the commission take administrative notice of Senate Bill 21-230, and that has been placed into our box as hearing exhibit 302. So I guess I'd move to admit hearing exhibit 302. There weren't any objections to the request for administrative notice previously.
Okay, we'll just double check. Any objections? No. Okay. It's so admitted.
you.
then. Thank you. Anything else before we break?
The company just has one quick comment in regard to Mr. Ross Smith's counsel for staff's position on the statement of position issue of how parties could perhaps file some sort of response to the to request a CCF that you've laid out to Commissioner Plant. The company would not oppose that type of process, just for clarity, if that's more workable for the commission.
That's very helpful. Thank you. Appreciate it, Ms. Judkins.
Hi, Commissioner. Earlier, my colleague had requested that Clear's witnesses be cross-examined after 11 a.m., but with the excusal of Mr. Brissett, Ms. Laird is available in order tomorrow morning.
Okay, yeah, and I think we only have maybe a couple hours tomorrow morning, so we should be done before noon. All right. Okay, with that, we will be adjourned until 9 a.m. tomorrow. See you then. Thanks.